Mr. Shah, what is?
My lord, I was praying for your lordship's indulgence in a matter. My lord, your lordship has fixed an ex parte suit for hearing at 2 p.m. on 27th. My lord, I have been recently briefed in the matter. I'm in some difficulty on the 27th. My lord, actually, my lord, I could not attend to a lot of professional matters in the last few days because there was a bereavement in my family.
Yes, yes.
My lord, I was requesting your lordship if it can be, my lord, fixed, my lord, any time in the month of February. My lord, if it permits, my lord, your lordship's schedule permits. I'm mentioning on notice to the other side.
Who is for the other side? So,
My lord,
okay, okay, I am taking note of it.
My lord,
You are for the plaintiff.
I am for the plaintiff.
Who is for the other side?
My lord,
They are
Mr.
contested,
Mr.
no?
Obhimanyu Shandilu appeared. My lord, that is his name is recorded in the last order.
Contest, give the order.
And I have also mentioned, I'm mentioning upon notice to him.
Argument is going on.
Yes, ma'am. It's for argument. It is an ex parte matter. It should not take very long.
Okay.
That is my personal estimation.
Okay, I am taking note of it. On 27 you mentioned, then I'll fix a date.
I'm very grateful.
Take note of it.
May I mention, Lordship?
Note kar lena.
May I mention, Lordship, this matter has appeared on 16 January and suddenly it has appeared because it was not in the list. This is the new motion one. And after that, Lordship has passed and please passed an order on 6th of February. And without fail, Lordship, the petitioner's advocate will appear. Just to bring Lordship's glare that it was unintentional.
What you want?
Nothing, Lordship, just to bring Lordship's glare that it was my apologetic
It
mistake.
is listed. It is in the list.
Yes, Lordship has passed an order on 6th.
So what you want? Already passed the order. Okay, no problem.
Like Lordship.
Testamentary matter, my lord.
Hmm.
During scrutiny, my lord, only typographical error in the cost title of the PIN number has been wrongly typed out.
Hmm.
I am seeking your lordship brief that this matter will be listed.
What is a listing? It is you can correct in the before the master.
It cannot be. On non-contentious cause, I have paid the entire court fee.
That's correct. Only the it is.
Typographical error in the cost title. PIN number has been wrongly typed out. Otherwise,
So who told you to mention them before this court?
department told me.
So what is the purpose of scrutiny?
Scrutiny, it has been found out that the typographical error in the, but they have no power to correct it in view of the fact that since all.
Where is the application? It is in the department. Take them to be mentioned.
My lord, I have a similar case like my learned friend, my lord. I have filed a commercial suit. Now, during scrutiny, they have found some typographical errors. Now, a formal leave is required of my lord to get those.
No, that is correct. Commercial and all these things, that is correct.
Yes.
Because after the affidavit.
Yes, affidavit part, they told that there is a specific direction of my lord to get all this.
In the affidavit portion, once the affidavit is up,
you have to.
They cannot.
Formal defects in the petition body
That's
of the
correct.
petition master. And if there is a in the affidavit portion, which is before my, I have given it my letter.
That's I instructed.
Yes, yes.
I find that
They told us.
the
They told me.
affidavit portion, once it has been affirmed by the oath
Court.
commissioner, so it cannot
You
be
cannot
carried.
touch it. You cannot touch it. My lord, let it appear as to be mentioned.
To be mentioned.
All the
Commercial.
Commercial matter.
Monday to be
Let it appear on Tuesday because they told that they will give us a formal report. We will prepare it and give it. They are really overburdened, Baba. Wait.
My lord, may I have your lordship's kind leave, my lord, to move, my lord, 8 writ applications, my lord, as unlisted motion on the ground that these petitioners, my lord, are very aged and they are going to die. Their days are counted. What happened in this matter? They participated in the selection process.
What is the matter?
Matter, my lord, is the pension.
Is the writ petition?
Writ petition, my lord. I am praying leave, my lord.
What is the urgency for an unlisted motion?
Urgency, my lord.
What is the urgency of an unlisted motion?
My lord, because of the fact that, my lord, some of them are in the deathbed.
When they retired?
Retired, my lord, some in the year 2013, some.
So after
2014.
12 years,
No, my lord, no. My lord, they filed the writ application. The Honorable Justice Shampar Sarkar was pleased to direct the Panchayat Secretary to consider the case of the petitioners. There were 68 petitioners. And the Panchayat Secretary, my lord, after hearing in the year 2024, was pleased to reject the case of the petitioners.
Correct.
Challenging that order, my lord. This petitioners, my lord, has come before you, lordship.
So what is the urgency? You file it.
But, my lord, one thing, my lord. Actually, their condition is very precarious and
That's
they are
correct,
suffering
sir.
from, my lord.
You are challenging the order of the authority. Correct.
No. That has been finalized
Huh.
by this honorable court. Honorable Justice Amrita Sinha already set aside that order
Correct.
of the department.
Correct.
In spite of that, my lord, I have filed representation that this order has been rejected. Please grant us pension.
No, after the rejection, there is no direction.
That-
If the impugn order
but
passed by
these
the
petitioners-
authorities,
My lord, these petitioners could not approach the honorable court, my lord. One Chandra Raishwar, my lord, approached the court.
Go before the regular. Yes. No. Yes.
My lord,
Sorry, sir. This is not.
my
an
lord,
urgent
I
matter.
shall file, my lord, only.
You can file. Who?
They are, my lord, only short of, my lord, below 6 months, my lord, deficiency. Only
file
the
it.
point is, my lord, to condemn the deficiency. So kindly grant me liberty.
No, sorry.
My lord,
Yes.
my lord, to list the matter on Monday at least, my lord.
No. Yes.
My lord, these matters, my lord, these people, my lord, are suffering very much.
What is the urgency?
Unauthorized construction running in the agricultural land.
When you file the writ application?
Writ application filed new motion under the heading.
When you filed, sir?
Filed, my lord, December.
So now,
My lord, running in the
so court was there. Why you not
unauthorized
mentioned?
construction without plan sanction.
Okay,
without
well,
permission.
within only 1 week.
And-
Next week the court will come. Yes.
My lord, I served
Yeah,
the
my
notice
lord,
other
please-
side.
My lord, I am
Nothing.
praying, my lord.
Nothing.
My lord, I am
nothing.
praying for reconsideration
I am
of my
praying
prayer,
for
my lord. I am praying, my lord.
Sorry.
Some of my 4-5 cases are there in the monthly list which
Hmm.
are unlikely to be called.
Hmm.
So I am praying for to be listed in the daily supplementary list on tomorrow, day after tomorrow, so that it can be heard.
What is your prayer?
Prayer is for inserting those cases, 4-5 cases. in
It
the
will
daily-
come. It will come. Automatically, it will come. It's a
No,
commercial
it
matter.
is in the monthly list.
It is a commercial matter.
No, non-commercial.
So what is the stage of the suit?
It says the affidavits are complete.
What is the stage? What affidavit? What application?
Application is for injunction and attachment, and in one of the cases, degree has been passed in my favor, and it has to be listed as suit hearing of the suit, in which the interest portion is pending. So that is already there in the monthly list. But it is
What is the number in the monthly list? Give the list. Come with the list. Then we'll see.
Yeah, my lord, leave to
Yes.
mention one matter.
The list to
Where is the under? Where is our list?
list. I will hand over to the office.
We'll hand over. Yes.
May I, my lord's leave to mention one matter. My lord, in this PLA matter, my lord, grant was directed to be issued on 30th August 2024. My lord, till today, my lord, I have not received the.
Have you approached the department?
Lordship, everything is ready.
Ah,
My lord, I am being told that 24th of December the grant was written,
ah.
and my lord, thereafter it is lying with a certain person. My lord, he says that another 1 month we have to wait. I do not know what is the reason.
Problem is that there is shortage of staff.
Absolutely.
Correct. And after we are passing an order, 2-3 courts are taking the testamentary matter. We are passing orders. Now they are, we have directed to maintain the seniority of the day as per the orders. So they are maintaining.
Nothing is
the
being
list.
maintained.
No, it has come to me. It has same allegation.
My lord,
has
it
been
is
made
in
just-
August. The grant was
Okay.
directed to be issued
Okay,
on
I will see to that.
lordship. Even it is made ready, even writing is ready. Only, my lord, the register has not.
Okay, I will see.
I'm great.
I have my lord's kind leave to mention, my lord. I know, my lord, this is not the time for mentioning of an extension of interim order. The only difficulty is, my lord, I mean, led by Mr. Bhattacharya, senior advocate, my lord. He has some difficulty in the second half. That's the only issue I am mentioning upon
For
notice.
the defendant.
For
Which
extension
matter?
of this is, my lord, that
New
matter,
life, my
new life, your lordship is hearing. Your
Ah.
lordship has kept it on the 30th again.
Ah.
The interim order is expiring today.
Ah.
My lord, I am praying for extension. I know, my lord, this is not the time, my lord. I humbly apologize for the same, my lord.
What is the number?
My lord, I have copy of the last order, my lord, where the interim order was extended till 24th.
When the matter is fixed?
My lord, on
My lord,
30th of January, 30th.
30th of January.
Though the matter is not listed, the counsel for the plaintiff has mentioned the matter upon service of upon notice to the counsel for the defendant, and the counsel appearing for the defendant is also present. It is submitted that the interim order granted earlier is going to be expired today and prayed for extension of interim order. It is further submitted that the matter is fixed for hearing on 30 January
30th January.
30 January
11:30
2025.
in the morning.
In view of the submission made by the counsel for the plaintiff, the interim order which is going to be expired today is extended till 7th of February 2025 or until further order, whichever is.
I'm grateful. I'm very grateful.
My lord, I beseech you, lordship, my lord, that I shall file these petitions will not today, my lord.
Sir,
My lord,
for
we will-
filing the writ petition, I don't think any leave is required.
No, my lord, grant me
As
leave,
far as my knowledge.
grant me leave, my lord, to mention on
For
Monday.
what leave?
Leave, my lord, as to move as urgent
You
motion.
file it, then come and we'll see
For a
to that.
limited period, my lord, determination. I want to do the matter before you, lordship.
I know. Yes.
My lord, I have got 4 probate matter. It has been corrected by the insolvency department. I am only praying for listing of those.
For what?
For listing of the probate matter, uncontested probate matter.
List it.
Deeply obliged.
Item number 1.
Well, lastly, I am appearing on behalf of the plaintiff.
Yeah.
I take to leave to appear online, Your Lordship. I am not in the court right now. But in this matter, item number 1, compromise order has been made on 3rd May 2024.
That's correct. It has been made, and this decree has been passed in terms of the settlement arrived between the parties, and the deed of settlement was made as a partner, as a
Yes,
part.
Your Lordship.
Now the department is facing difficulties with regard to the settlement, deed of settlement having some annexes. Correct. So that and some of the annexes, so they wanted that an order, it is not possible for the department to retype and made the part. So I am
Your
passing.
Lordship,
So I am
yes.
passing an order what the document along with the memorandum of consent has been filed, that may be attested or certified by the concerned officer and made the part of the same.
Much
You have
obliged.
difficulty and you have any difficulty for that?
No,
Instead
Your
of
Lordship.
I'm appearing on behalf of the defendant number 3.
you have any difficulty? No. So and so appearing for the plaintiff, so and so appearing for the defendant number 3A. Defendant.
Yes, Lordship. Defendant number 3.
3A, capital A.
3.
Full stop. The matter is listed as to be mentioned on receipt of the report of the master and official referee of this court dated 21st of January 2025. Full stop. By an order dated 3rd May 2024, this court has disposed of CS Com 289 of 2012 and 2024 within bracket old CS number 147 of 2021 along with all connected applications on the basis of the terms of the concerned terms entered between the defendant number 1 and defendant number 2. At the time of passing of the order, this court has directed that the concerned terms and settlement entered between the plaintiff and the defendant number 1 and 2, as well as the defendant number 3, be made as part of the decree. Full stop. Now the department has submitted the report stating that the two terms of settlement on the basis of which this court has passed the decree and directed to make the said terms of settlement as part of the decree are voluminous with their annexes and schedule, and few of the annexes, which are also the part of decree, are eligible and eligible, and he prays for direction upon the advocate on record of the parties that the terms of settlement filed by the parties on the basis of which this court has disposed of, be filed another certified copy so that the same can be made as part of the decree. Will you able to file the certified copy of the terms of settlement? You are not. Where is the plaintiff? Please.
Yes, Your Lordship, I can file it, Your Lordship.
About the defendant number 3?
Yes, Your Lordship, I can file it.
What about the defendant number 3? Full stop. Considering the report of the department, the counsel for the defendant number 3 and counsel for the defendant number counsel for the plaintiff defendant number 1, 2 and defendant number 3 are directed to file the certified copy of the terms of settlement dated along with legible copies of the annexures dated money bola na dated है भी terms of settlement date मत कर date कर दे terms of settlement filed by the annexes in the department so as to enable the department to make the same as part of the decree within a period of how much time? 2 weeks?
Lordship, 2 weeks, Your Lordship, 2 weeks.
Weeks from date. Yes.
In this matter, arguments are concluded. Lordship, in this matter, Lordship has sought for some clarification in this matter. Mr. Kanish Kejriwal is appearing in this matter. Lordship, I am only praying for short passover of 5 minutes. He will appear any moment. Lordship, 5
minutes? No,
Lordship, any moment he was stuck in a jam.
And for the defendant, last to last date on Friday, the list collapsed at 3 o'clock. Matter was still, court was till 3:30. That time, they had come because it's not a long matter. It had concluded. By the time my junior advocate on record had come, matter was over. I was also seeking some discretionary relief.
This matter was heard at length.
Yes, Mr. Kejriwal.
I have already intimated to your advocate what is the difficulty. If you want to that proceed with that, the court will proceed with that. Only wanted to give ask for the clarification. If you are not able to give the clarification,
amount which was mentioned in the purchase order and the amount which was mentioned in the invoice, only to that extent. Lordship, he is appearing. I am only praying for
okay, not today. Come not today.
My lord, I'll get 1 minute, by the clock.
Come.
Today,
yes, next.
My suit. Suit for money due on account of goods sold and delivered. This is after the mediation process has failed.
Mediation process
has failed. Non-starter report given. Now, I will find the non-starter report at volume 2, page 277. Last page. The defendant had not come forward.
Yes.
Now, the defendant is within, plaintiff is outside. Now, my lord, goods sold, my lord, on account of purchase order issued, my lord will find the purchase orders. My lord, the first purchase order, my lord will find at page 21. And the second purchase order, my lord will find at page 157. 157, volume 2. First is page 21, second is 157. Now, my lord, I have pleaded, my lord, the paragraphs which are within and outside, my lord will finally find at page 60, paragraph 69.
23.
Yes.
When the last payment was made?
My lord, no payment made, my lord.
The client is very good, yeah. Without payment, you're supplying the goods. For
No,
for
actually,
3
my lord,
years?
the relationship, my lord, is pretty old.
Okay.
My lord, for the first time, my lord, this has happened. Now, my lord, kindly see the defendant, my lord. Defendant are well-known, my lord, company, my lord. It's not that. So, my lord, there was no occasion, my lord, for my client to, my lord, have some doubts. Now, my lord, I have prayed for, my lord, leave, my lord.
Why order to rule 2?
My lord, for getting the future claims, my lord,
What
which can.
future claims?
My lord,
A simple claim. It is a purchase.
My lord, to be on the safer side, my lord, if you need to file the amendment, my lord, then my lord, this issue, though my lord, Supreme Court has now, my lord, day before yesterday passed a
That's why.
judgment that my lord, fresh suit, but my lord, let us be, my lord, on a safer side, my lord, Supreme Court, another bench will pass another judgment. So, my lord, I have prayed for order
That's
to
why I'm
rule
asking. Now the Supreme Court stated that now you
my lord,
can file a
tomorrow
separate
another
suit.
bench will pass
There is-
another
there-
judgment.
there
Let us be,
cannot
my lord, cautious on this. So, my lord, order to rule 2 and clause 12, I have prayed, my lord.
Son suffering for the plaintiff. The plaintiff has filed the present suit for praying for a decree for a sum of rupees 81, 18, 164, along with interest at the rate of 18% per annum, and allied prayers. Full stop. Counsel for the plaintiff submitted the plaintiff has already initiated pre-mediation process, but the defendant failed to come forward, and accordingly non-starter report has been filed. Now the plaintiff has been filed. Now the plaintiff submits that the plaintiff is outside jurisdiction and the defendant is within the jurisdiction of this court, and some cause of action arose outside and some cause of action arose within the jurisdiction of this court, and prayed for leave under clause 12 of the latest patent. Full stop. Counsel for the plaintiff the plaintiff has also prayed for leave under order 2 rule 2 of the Code of Civil Procedure, and submit that though the plaintiff has filed a suit for recovery of the amount with respect of the purchase orders and with respect of the material supplied to the defendant, but there is every chance that further claim may arise during the pendency of the suit, and as such order 2 rule 2 of the Code of Civil Procedure, a leave under order 2 rule 2 is required. Consider submission made by the counsel for the plaintiff, peruse the pleading, leave under clause 12 of the latest patent as well as order 2 rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by the. Yes.
Oblige, my lord, my advocate on record is appearing online, my lord. He is enjoying 24. He has not come to.
I'm grateful.
My lord, my suit under order 37, my lord, wherein they have made an application praying for leave to defend. In this, my lord, we have filed opposition in due time. In December, my lord directed them to file their reply for the completion of the affidavits. Till date, my lord, no.
I'm out of time. I'm seeking an extension.
My lord,
for
this is the
7
second
days.
extension. They might, may I beseech your lordship, my lord, considering the fact.
Mr. Chaudhary supposed it, and you are not filed, and you have to.
No, my lord, the same situation can happen also in my time, and I have to face. But this is the second extension I'm saying, my lord. I'm leaving it to lordship with a last chance, maybe recorded.
Lordship, last chance, 7 days I'll file it. It's already ready. I'll just affirm. I had
Affidavit in reply.
Reply, your lordship, my application.
Son suffering for the plaintiff, son suffering for the defendant. Full stop. Counsel for the defendant prays for extension of time to file affidavit in reply. Full stop. Counsel for the plaintiff raised objection and submitted that this is a
second extension.
This is a second extension. Full stop. Second extension. He submitted that By an order dated 23rd of December 2024, this court has granted time to the defendant to file affidavit and reply within 1 week after winter vacation, but the defendant failed to file the reply, and as such is praised for rejection of the request made by the counsel for the defendant for extension of time to file affidavit in reply. Consider the submission made by the counsel for the parties. This court is of the view one further opportunity should be given to the defendant to file affidavit in reply, but it is made clear that this opportunity is a preemptory, and as a matter of last chance, it is further made clear that within a period of 1 week, comma, the defendant failed to file the reply, comma, to file affidavit in reply, chance to file affidavit in reply will be closed and the matter will be heard without the reply. Accordingly, the defendant is directed to file affidavit in reply within a week from date, list the matter on 11th of February 2025 for hearing.
Only one inadvertent mistake on my part. It should not be second, it is a fast extension. I have pointed out to Mr. Kothari even. Yes.
So I'll file it within 7 days, not an issue. Grateful, Lordship.
6, my lord, I am for the plaintiff.
My lord, I seek to appear online, my lord. With my lord. My lord had asked me to take instruction on this, my lord. The client, my lord, has sought for some time, my lord, to gather the funds, my lord, if he can pay off and
so what
contest.
time? Tell him I am fixing according to you.
My lord, next week, my lord, any day, my lord.
So and so appearing for the plaintiff. So and so appearing for the defendant. As per the prayer made by the counsel for the plaintiff. As per
the defendant.
For the defendant. The case is adjourned. Let the matter appear on the commercial matter.
Yes, my lord.
Yes, ma'am.
Let the matter appear on 7th of February.
In the meantime, let them pay something, my lord, to show.
That's coming on that day. Let's come on that.
My lord, one thing more, my lord, I want to record, my lord. We have taken a certificate from the department that they have already entered appearance on 19th day of July 2024.
That's why it is the undefended.
They have come.
Undefended suit. Yes, next.
Grateful, man.
Please, your lordship.
For the respondent number 2, my lord, at the very outset, I should indicate that the copy of the plaint has not yet been
sorry. I'm just giving to you right away. My lord, I'm just handing up, my lord, a hard copy. You need a soft copy, I'll email it. I'll email the soft copy of the plaint also.
And it has become difficult for the clerks. So we were not briefed in this matter. I have not received a hard copy.
But I'll email the soft copy.
Yes.
But your lordships will remember, under some peculiar circumstances, I had presented the plaint. Now, my lord, this is a suit. The plaintiff, rather the petitioner, had, my lord, installed an ASU plant, my lords, in the factory premises of the respondent. This is respondent number 2. My lord, the principal contract was for, my lords, around 48 crore 50 lakhs. And let me be, my lords, very honest to your lordships, this entire money has been paid. Except, my lord, they were delayed in making payments. Number 1, the letter of credit was not opened. And, my lords, there were certain price escalation, my lords, in terms of, my lords, the US dollar, my lords, there is this thing. Now, my lord, what has happened is thereafter, subsequently, 2 bank guarantees were, my lord, given to your lord. But I'm sorry, my lord,
Lord, lapsed bank guarantees. If your lordship sees the language of the bank guarantees, they've not been invoked in accordance with their terms.
Why you could not satisfy
his lordship said something very interesting. His lordship said, bank guarantee is a tripartite agreement.
Not content, yes.
Yes, it's not it's a separate agreement from the main contract. It's a tripartite agreement. And yours earlier, my lord, when we used to, this issue came up when we had just joined. In fact, Justice Indira Banerjee had delivered a single bench judgment which said that for a bank guarantee, a cause of action is bank paying. Ancillary is invocation, but real cause of action is bank paying. So therefore, an order in personam, in the absence, in personam upon the beneficiary, in the absence of the bank, should not be passed. That judgment, my lord,
So unreported judgment was really ignored by the bar when we would move section 9s and get, my lord, orders of bank guarantee injunction, because there are numerous orders which have been passed subsequently. Then, my lord, the law was relaxed, and for the purpose of making an order to be passed on a section 9 effective, third parties started getting added in a section 9, which is which is, my lord,
to have some water.
Which is, my lord, the present regime. Now we are moving forward again, though not relevant here. Now we have Cox and Kings, which is saying a veritable party can also be added in arbitration. That's a separate matter. So, my lord, when we obtained the order and when we went for, my lord, arbitration, Justice Gupta said that you have made the bank a party in your section 9 and you have obtained this order. It's a tripartite contract. I know I can pass an order in personam. However, when you made the bank a party in 9, now here bank cannot be made a party. So how can I decide it? It is better you go file a suit. We took an adjournment, then we thought that the better thing to do is to, my lord, get this done in the presence of the bank, which is why we filed this suit with leave of the learned arbitrator, restricted to the issue, my lord, of the bank guarantee. Now, my lord, I'm not going into the principal contract apart from, my lord, two issues. Number one is that contract was for, my lord, setting up some sort of a supply and setting up some sort of a plant. My case is that the plant is fully functional. Their case also is that the plant is functional. However, that doesn't mean that bank guarantee can never be invoked. The bank, so that's number one. Some equity in my favor. I am not, my lord, a runaway person. And I invoked arbitration because they haven't paid me on time and there are outstanding payments, which is, my lord, the backdrop of the invocation. Now, the bank guarantee, my lord, is very interesting. My lord, please come to page 69. Kindly come to page 69. The bank guarantee, my lord, starts at page 70. There are two such bank guarantees, identical terms. Very interesting bank guarantee. Normally, one doesn't come across these. My lord, fourth paragraph. Now, therefore, we, the bank, unconditionally and irrevocably undertake and guarantee to pay to the beneficiary under this performance guarantee any amount up to an aggregate value of such and such against, now this is important, any loss, damage, costs, charges and expenses caused to or suffered by the beneficiary for reason of non-performance by the supplier of the terms and conditions of the said contract without any contestation, demur or protest and without questioning the legal relations subsisting between beneficiary and supplier. So, my lord, usual up to here. Now, my lord, see this. Upon receipt of a simple written demand from the beneficiary received by the bank on or before 26th of June 2024, within bracket expiry date.
That is the last date.
That is last date. Indicating the amount to be received by the beneficiary, mentioning therein that the supplier had failed to perform its obligations before expiry date of the guarantee under the contract and contract is still valid and binding. So number one, so you have to make that statement. True or false, my lord, is irrelevant. You have to make that statement. And number two, demand should be accompanied by a copy of the beneficiary's letter to the supplier giving 30 days notice during the guarantee validity period to make good the deficiency and a certificate from the beneficiary certifying that a period of 30 days has lapsed. This is the important sentence. So
that's why on that day he has argued the matter, the notice.
So what happened was the claims arose late. So therefore, the counterblast also came late. They issued I'll show your lordship the documents. they issued the first invocation. We wrote to the bank saying that where is the 30-day notice and where is his certificate that I haven't done it within 30 days. Bank told them that you can't do this. So they withdrew. Now, when they withdrew, we invoked arbitration because we have our claims. After that, they gave a notice. Now, from the date of the notice, 30 days itself takes them to beyond 26 June 2024. So, my lord,
date already expired.
So now they can't fulfill the second part. They cannot, within the validity of the bank, within the
guarantee validity period to make good the deficiency.
they can't invoke now. Because to invoke, they need that 30-day notice.
So when you completed the work?
Earlier, long back. Now, I'll show your lordship those two letters by which they invoked and they withdrew. Then they again, my lord, they gave this notice. And we, my lord, went to court. Section 9 court. My lord, there's another catch to it. There's another catch to it.
There is a notice.
My lord, before that, my lord, let me now show what they are going to argue, which the learned judge, my lord, decided. My lord, please see page 71. Huh? Of course. আগের বার করেছিলিস অদ্ভুত argument.
There might be a CCTV. 70.
Milord 71. Next page, Milord.
Yes.
Milord, third line. Notwithstanding anything contained herein before, our liability shall not exceed such and such. Second, these bank guarantee shall be valid only up to 26 June 2024 expiry date. And we are liable to pay the guaranteed amount or any part thereof under this bank guarantee only and only if we receive a written claim or demand on or before 26 June 25. That's been 1 year after that. Claim period, claim date.
Correct.
Now what happens is, having regard to the bank guarantee language, you can only, my lord, invoke it within 26 June 24, which is the expiry date. However, if you want to file a suit on the bank guarantee, you can do so within 26 June 25. That, my lord, is the interpretation of Delhi courts and also our honorable court, my lord, on this sort of a bank guarantee. Now, my lord, kindly see the notices. My lord, first notice, first is, my lord, let me show your lordship the notice of 1st May 2024, which, no. 1st May 2024, which is, my lord, at page 80. To answer your lordship's query, my lord. 1st May 24, this is to, at the bottom of the page, this is to summarize 110 TPD oxygen plant. Lordship has seen it?
Yes.
Oxygen plant against contract number such and such dated such. Plant has been in operation since quite a long time. Hence, here we would summarize commissioning milestones. Number 1, supply of gaseous oxygen to BF 31st January, that's a third party, 31st January 24. To BF 2nd February. Nitrogen is 2nd February. Liquid oxygen charged into storage tank 4th February. Liquid argon charged storage tank 15th February. First sold out 26th February. First liquid argon tanker sold out 12th April. So, my lord, before this plant was set up, these are, my lord, the dates, commercial operation dates. So this is what we placed on record. Then we say recently we had deputed Mr. Such and Such, having 35 years of experience for continuous production stability review. They've done a 30 hours for liquid oxygen, etc., 36 hours, 46 hours. And results are available in attached table. All productions are well in limit as per the contract. We must highlight following achievements, etc. Plant has, the next paragraph here, we would like to highlight that plant has been deemed accepted long back on the very day you had first used for production for commercial use. So we have supported you. So we are withdrawing our operations from 4th of May, etc.
They respond to this.
And so, Lordship has seen, my lord, by last year, 23, it was more or less done. different kinds of commercial operations achieved from January.
They respond to this with this comment.
And
they respond to this with this comment.
There is a response
77.
At 77.
Right there. Manoj Verma, Bigwell Energy, 77 middle of the page.
And
no, a BL comments there. 77. I have gone through. Manoj Verma.
That second notice. Lordship will kindly see, Milord. Dear Mr. Boshak, second email.
Page 77.
Yes.
And then, Milord,
their email.
Their comments, Milord. BEL comments.
Yes.
When the liquid nitrogen was taken in, that this is not reflecting in your mail, we have deputed such and such. Then why has production not been considered in front of your expert? There are various issues
But
which come up.
For
your information, operation manual not available. That's small issues. So, Lordship will see, BEL comments are the way, but your Lordship will not see that they are disputing the setting up of the plant or the commissioning. Small issues will not raised here and there. And the date of this email is, Milord, 2nd May 2024.
Correct.
From December, it's all ready. From January, Milord, in different phases, commercial operations are happening. Now, Milord, kindly see page 99. Now, auto first day.
67. Invocation.
So this first is the 1st May 2024, second is the 2nd May 2024.
And this is no Shoracho.
I
Milord, kindly come to Milord, the notice of invocation. Milord, 18th of June 2024 at page 99. This is not, this is in June. Plant operating from January. Suddenly in June, they want to invoke. Milord, it's malafide. Though, Milord, I am with a little bit of hesitation, I must say, if the rest of my submissions were not there, just on this, maybe I would not have been able to persuade your Lordship. Because it's a dispute arising out of the contract, which your Lordships really don't want to see at the time of invocation. But, Milord, please see this. Because of the statement contained in this notice, 18 June 24, with reference to PBG, kindly note PBG was issued by HDFC Bank on behalf of Ellenbury Industries. Supplier fails to perform obligation as per the contract, hence PBG is to be encashed. Now, Milord, please compare page 99 with, Milord, the bank guarantee at page 69. Barco 69. At page 70.
Yes.
Demand, they're indicating the amount to be received. That supplier has failed to perform its obligations before expiry date. That's, Milord, subject to correction. Before expiry date, not mentioned. Next, that statement, Milord, please, Milord, compare this with page 70. I'm sorry, 71.
This bank guarantee shall be valid only up to 26 June 2024.
Correct, Milord. 26 June 2024. This is 18 June. So suddenly, Milord, they get excited. They now know the bank guarantee is going to get, Milord, expired. After 6 months of commercial operations, they, Milord, invoke, importantly, Milord, number one, this invocation notice does not say that the amount to be received by the beneficiary, saying that supplier has to perform its obligations before expiry date of guarantee, not mentioned. Number two, they have not mentioned the demand should be accompanied by a copy of the beneficiary's letter to the supplier giving 30 days notice during guarantee validity period to make good the deficiency. Not there. Notice not given. Number three, certificate from the beneficiary certifying that period of 30 days has lapsed. Obviously not there.
Yes.
So, my lord, we write to them saying that this is not, my lord, a valid invocation.
Yes.
We write to the bank.
Yes.
Now, bank accepts that.
123.
Please now, my lord, look at page 123.
First bank was saying I will release it.
123.
Yes.
In fact, I am, Millard, not correct in my submission. On 9th, this is 18th of June is the notice of invocation. I should have showed your lordship page 110, Millard, which is 19th June in the sequence of events.
110.
Yes, Millard.
19 June.
19th June, right at the top, Millard.
Yeah.
Millard, this is from HDFC Bank to Millard us, indicating invocation has been taken up with your good office.
After the 18 June letter.
After the 18th June letter. Taken up with the beneficiary about non-compliance of the clause and seek further clarification. Accordingly, beneficiary confirmed about withdrawal about invocation claim and informed that will be presented if needed post compliance of the clause.
Yes.
So, this bank records that they had accepted the position. Accordingly, beneficiary confirmed about invocation claimed and informed that will be presented if needed post compliance of the clause. So bank on the next day itself informs us that this is not in terms and it will be done post compliance. Now, my lord, please look at page 136. 136 से देखिए तारपर देखा. Milord, 19th of June 2024, Milord, an admission by the defendant that they don't want to invoke. Milord, it's actually 135. Milord, just the page before. Please see, Milord, 19th June. Again, the bank.
Yes, kindly
Recording.
hand over the original PBG and our representative.
That's Milord, the second one, the one after that.
Okay.
19th June at 12:12.
Achha, second one.
Yes. This is from Rana Mukherjee, HDFC, to Kaushik Mondol, Bengal Energy. That's my learned friends' clients. Both the unconditional invocation claims stand withdrawn as per appended mail from your end. Please arrange to collect 2 numbers of bank guarantees from our bank along with receiving given yesterday. So, my lord, they have issued to the bank, and my lord, the bank is, my lord, returning the guarantees. That is evident from the email on top. Kindly hand over the original PBG to our representative. That's, my lord, Bengal Energy now asking back.
Taking back, yes.
This is the admission on the defendant. This is a trailing on the basis of which bank replies.
Then, my lord, page 136. Next page. We are issuing 30 days notice to the applicant as per PBG. In the notice period, till the notice period, kindly hold invocation process. So that's an admission that this notice has to be given. Now, after this, my lord, let me skip over. I give a notice on 20th June at page 145. Kindly come to, my lord, 144, which is this is, my lord, a letter attached to an email. So 144, my lord, is the email at 8 minutes past 12. I give my dispute resolution notice because of their, my lord, unholy act of attempting to invoke the bank guarantee. And the letter, my lord, is at 145, which is sent by the email at 144 at 6 minutes past 12.
Yes.
Now, my lord, kindly come to page 150. Within 2 hours, at, my lord, 239, page 150.
Yes.
Is, my lord, their notice now that make good defect. 30 days notice in terms of the bank guarantee.
Be 20th June, you have sent the notice.
They have sent 20th June. I have sent
You
the
have sent the
notice.
notice at 12:08 p.m.
Yes.
12:08 p.m.
And after they get my invocation notice, 2 hours later, this is not invocation of the arbitration agreement because there are disputes. 2 hours later, at 2:39, comes Millard, their notice asking me to make good the deficiency, which is Millard that 30 days notice under the bank guarantee. Millard, please see Millard, page 150.
Yes.
From Naveen Agarwal at Bengal Energy.
Yes.
20th June 24, 2:39. And Millard, the instant notice is being issued for the purpose of calling upon you to make good deficiency and defect left behind by you in execution of the contract. Now, Millard, kindly see page 152, paragraph 11. For the purpose of mitigating its loss, undersigned calls upon you to carry out at your own expense all work, including replacing goods and deploying manpower to achieve the guaranteed value and make good all your deficiencies as pointed out to you within 30 days from the date of receipt of the instant notice, failing which the undersigned will be constrained to take action, including invocation of bank guarantee.
Yes.
So, Millard, we'll have to calculate 30 days from 20th June.
So these are 20th June.
Yes. So if we now go to Millard.
So what has happened to this?
Now, after that, Millard, we came to court. Millard, because our argument, principal argument is 26 June 24, it all comes to an end.
Okay.
So if you want to invoke, you have to do it by 26th of May 24.
26th of June 2025.
Please, post na 2 minutes. No, 25th of May, I have to, Millard.
That was the last date.
Yeah, because I need 30 days cure period.
Correct.
So, Millard, this notice comes, Millard, in June. That Millard takes the 30-day period back to July. So, how can you invoke? Millard, please see the notice again, Millard.
No, 26 June is 2024 was the expiry date.
Expiry date.
And on the same date, they have issued the notice.
Yes, Millard, but 26 June 2024, as per terms of bank guarantee, I need to also, but the invoker needs to say, I have given you a 30 days notice.
30 days notice.
Correct. So that notice has to be given by
before by 24th of May. So that's why on 26 June, when they have issued the notice, the time was over. So they cannot invoke further 30 days.
Yes. And so they also can't give a certificate within 30 days that I have failed to make good. And they can't invoke the bank guarantee because the terms of the bank guarantee say that the demand from the beneficiary has to be on or before 26 June 24.
Okay.
So, my lord, with this case, my lord, I go to court in a Section 9 application making the bank a party. At the ad interim stage, my lord, please see page 212 now. Moved in, my lord, their presence.
Yes.
My lord, learned, I'll just place, my lord. According second paragraph, petitioner commission plan cure defects. In the meantime, 2 bank guarantees furnished. Learned senior counsel agreement period contains that petitioner already invoked arbitration clause by issuance of a notice under section 21. Learned senior counsel placed stress on the 4th clause of the bank guarantee. Terms and conditions are exactly the same to highlight that the bank guarantees were not unconditional but were subject to precondition. As per the terms of the bank guarantees, the bank unconditionally and irrevocably undertook to pay the amounts covered by those against any loss, damage, costs, charges, and expenses caused to or suffered by the beneficiary by reason of non-performance
Yes,
Yes, by reason of non-performance by the supplier of the terms and conditions of the contract without any confiscation, demur, protest. However, same was subject to receipt of a simple written demand from the beneficiary by the bank on or before 26 June 24, which was described as the expiry date, indicating the amount to be received by the beneficiary. Over and above, the beneficiary had to mention in the said
Okay,
written
now
demand.
the court has passed an order.
Yes, now, Millard, important part, Millard, I'll omit submissions. Please see the findings of the court.
Yes.
Millard, please come to page 216, last two paragraphs. Upon hearing learned counsel,
Yes.
it transpires that judgment cited by the respondents is not apt in the present context. In the said case, what was laid down was that if an injunction was granted in respect of invocation of a bank guarantee, said bank guarantee should be directed to be renewed from time to time, keep the same alive. Judgment of the Delhi High Court is more appropriate in the context, since the factual scenario therein has some bearing on the present factual matrix. In the present case, as in the said case, there are two contradictory clauses, one of which requires the written demand to be made in a particular fashion and before a particular expiry date, whereas the last portion of the bank guarantee provide that claim as mentioned therein can be made before such expiry date, that is till June 26, 2025. The proposition laid down in Hindustan construction is well settled. In fact, the respondents accepted such proposition that a bank guarantee to be invoked, the clauses stipulated therein, and the modality as provided therein are to be complied with. In doing so, the respondents in fact withdrew their first invocation and gave a further notice on 20th June 2024, apparently to comply with the clauses of the bank guarantee. The question which remains is whether, even if the notice dated 30th June
It should be 20.
is taken into logical conclusion, it would satisfy the mandatory requirement of the bank guarantees. There are threefold prerequisites for invocation of the bank guarantee as per the fourth clause. The first is that there has to be loss, damage, cost, charges and expenses accrued to the beneficiary by reason of non-performance by the supplier. That apart, the beneficiary has to tender a simple written demand to the bank before expiry date of 26 June 24, indicating the amount to be received by the beneficiary. Not possible in my case. In the said written demand, the beneficiary has to mention that the supplier has failed to perform its obligations also before the expiry date of the guarantee under the contract, and the contract was still valid and binding. Not possible. Also, the demand should be accompanied by a copy of the beneficiary's letter to the supplier, giving 30 days notice during the guarantee validity period to make good the deficiency, and a certificate from the beneficiary certifying that such period had lapsed. Hence, even on a plain reading of the said clause, it is evident that the lapse in performance as well as the simple written demand have to be prior to the expiry date, that is 26 June 24. More importantly, the written demand has to be accompanied by a prior 30 days notice, giving an opportunity to the supplier to make good the lapses alleged by the beneficiary and a certificate that such 30 days have lapsed. Hence, it is mandatory as per the said clause that the 30-day period has to elapse prior to the expiry date, that is 26 June 24, and the simple written demand has to be subsequent to such expiry of 30 days, but also before the expiry date, that is 26 June 24. In the present case, even if the 20th June 24 notice has been given by the beneficiary, 30 days thereafter takes us well into the month of July 24. As such, even if such notice and the certificate of such period having elapsed is now annexed to a simple written demand to be made by the beneficiary, such demand has to go beyond the expiry date of 26 June 24. Thus, the mandatory requirement of making a simple written demand preceded by a prior notice of 30 days, attaching a certificate of expiry of 30 days, cannot now be fulfilled in any manner by the beneficiary before the expiry. So, my lord, this is the first part of the finding. It can never be done. Now, my lord, to deal with the second clause, the 25 clause. Coming to the interplay of the said clause with the non-obstante clauses at the end of the bank guarantee, it is well settled, as rightly contended by learned counsel for the petitioner, that in cases of construction of contracts, a settled rule is the doctrine of the earlier clause prevailing over the latter clauses. Hence, in the event the latter non-obstante clauses cannot be reconciled with the prior clause requiring written demand to be made before the expiry date, the earlier clause prevails over the non-obstante clauses, even at the cost of the non-obstante clauses being rendered nugatory and meaningless. However, in line with the judgment of the Delhi High Court in Explore Computers, a harmonious interpretation may be lent to the two sets of clauses in the manner that whereas the invocation by a written demand has to be preceded by a 30 days notice made before 26 June 24, which is the expiry date, the legal claim or demand on the premise of the alleged non-performance by the supplier on the strength of the parent contract can be made even thereafter. Any other meaning would defeat the purpose of the earlier clause of the bank guarantee and thus cannot be accepted by the court. Insofar as question of strict rule in case of grant of restraint orders regarding invocation of bank guarantees is concerned, it is well settled that if a bank guarantee is unconditional, the court would be loath in granting injunction, since the same comprises of an independent contract between the bank and the beneficiary. However, in the instant case, the root of the dispute lies not in the parent contract, but in the terms and conditions of the bank guarantee itself. Since the bank guarantees here are not unconditional, but the expression unconditionally and irrevocably used therein is circumscribed by the subsequent clauses which mandate certain prior requisites to be fulfilled, the clause has to be read as a whole, and it cannot but be interpreted that the bank guarantee, if at all to be invoked, has to be in terms of the clauses thereof. Seen in such context, in the present case, it is no longer possible for the beneficiary to invoke the bank guarantee before the expiry date, that is 26 June 2024. And injunction granted from restraining invocation of the bank guarantee, affidavits directed. Now, my lord, while I am at this, I just want to show your lordship two judgments. The Delhi High Court judgment, which, my lord, we had showed Justice Bhattacharya. Hey, Rudroman, get a copy though. He's making a collection of this judgment. Huh?
How much time you will take?
Milord, I can be very quick. Milord.
Because 11:30 other matter is fixed.
Milord, may I, should I?
He has stated that of 15 minutes. That's
Milord,
why
okay. Milord, I'll be quick, Milord. Something can, which
then
can.
he has to give an opportunity.
He has nothing to say.
He has been bullying me since 1996, since the time we started sharing a room, and he's been continuing to do that till.
Also, you share today with regard to the status quo.
Milord, actually, Milord, this is ad interim stage.
It's only on the interpretation of the.
Already may I make a suggestion?
Already interpreted by the court. So what
No,
you
I will show that interpretation is not correct. The Delhi High Court.
Whether this court can now.
Yes, my lord, and whether this suit is meant, whether this suit is, my lord, that was at an ad interim stage. After that, there were directions for affidavits. Those affidavits were filed. They have not disclosed those affidavits with their petition. My lord, and the matter went into arbitration where Mr. Chaudhary, my lord, will kindly come to that minutes. Mr. Chaudhary said that I have already filed a suit. So that's why the learned arbitrator did not want to delve into it. did not want to delve into it and said that you are at liberty. You are at
When
liberty.
I move, learned arbitrator observed, you go and file a suit. Bank is not
That's
here.
why you have not taken the decision from the arbitrator. You will not going
Learned
to enter.
learned
You could
arbitrator.
have been taken the decision
No,
from
no,
the
kind-
arbitrator.
kindly
Then their remedy is elsewhere.
Milord, kindly see, Milord.
Paragraph 2 and 3
No,
of this
let me show the minutes.
Arbitrator verbally stated to you, and you filed a suit.
He has
and
given me
arbitration
leave.
is pending.
He has given me leave.
My lord
Yes.
will read
So
paragraph
it can't.
before that. Has been
Okay, let it complete.
Milord, he added, Milord, my submission that client has been advised to file a suit restricted to the relief of preventive injunction. He added that such suit has already been filed, does not press the application, application dismissed. Insofar as this tribunal is concerned, claimant is granted liberty to apply for preventive injunction before such forum as he may be advised. That he's given me express leave and they didn't object. My learned friend's junior was in the arbitration. On the first day, when the learned arbitrator expressed that in the absence of the bank, I cannot pass this order. On the second day, when I prayed for and was granted leave. So you take advantage of the observation of the arbitrator, learned arbitrator, my lord, in the arbitration, and you come now and say otherwise.
But you cannot take the word from the other side. You have to take your own steps.
Correct.
In
So this
accordance
is
with the
was
law.
their section 17 application.
So now I am on a
Section 17. If you found that the arbitrator is
so
not,
now, Milord,
you could have
no,
been
it's
taken
a
the
it's
decision
a
from
it's
the
a
arbitrator.
Milord, it's a tripartite contract.
Correct.
In the absence of the Milord, the injunction.
No, then the second order, when the Justice Sarkar has passed the order taking into
Kindly see that.
consideration.
So that's why the leave was necessary, which the learned arbitrator gave me. Milord, kindly see, it's the matter was referred, Milord, 222 interim order, which has been passed by a
The petition will approach the learned arbitrator by filing an application under Section 17
with
of the
interim press.
with the interim
Requested to describe the scope of the interim press made and dispose of the application within 3 months.
Correct.
So the learned arbitrator observed that you go file a suit.
Okay. Because the learned arbitrator has not.
But I can't be remediless.
Not come to the finding. You could have been taken the finding from the learned arbitrator. Why the Section 17 is not maintained?
May I humbly submit this?
Then the court can, but now simply you stated that arbitrator stated and you have withdrawn the application and filed the suit.
With leave.
Yes, with leave. But the coordinate bench has passed an order. You approach before the arbitrator under Section 17.
Now, Milord, may I submit this? First question which I ask myself is, say if I hadn't gone to Section 9 court or Section 17 court, would my suit be maintainable? Answer is yes. Because this is a suit which arises out of a tripartite agreement, which is the bank guarantee, which is separate from the agreement between the parties. The tripartite agreement, bank guarantee, Milord, all judgments, Milord, last 30 years, Milord, say that bank guarantee is a separate contract, distinct, and its terms are distinct from the term.
So why you have filed the APCOM before the learned court?
Because
on 7th November, if it is that is
yes,
the law,
but I made
then
a
why you have filed the Section 9 application, Section 9 application, and you got the order from the court to filing Section 17 application before the arbitrator. You got the leave from the court, filing Section 17 application before the arbitrator, and now you are turning around.
So is it, Milord, I ask myself, is it turning around or is it accepting the position that the bank is not before the arbitrator?
So you could have been considered that when you have taken the order from the coordinate bench of this court.
But then the coordinate bench sends me for decision to the arbitrator. The arbitrator gives me leave to
Gives leave, but he has not come to the finding. You could have been moved the application before the arbitrator could get the finding from the arbitrator. Yes, I am not in the tripartite agreement. The arbitrator cannot decide the Section 17 application in the present proceeding. Then the court, your remedy is elsewhere. Then
Milord, that would no remedy is not elsewhere. Matter is, Milord, this suit is even independently maintainable. Because if I today file a suit would be independently maintainable. But I would not be able to pray for an interim injunction because I had already for the same relief asked the Section 9 court. Now, my lord, Section 9 court, I go, I don't complete, I get an ad interim order, I don't complete the proceeding. What I do is, I take it before the learned arbitrator and then I obtain leave from the learned arbitrator to pray for the same relief before your lordship. So that is not barred.
Okay.
May
कौन सा
take-
matter
may
है?
I just
Because
take 30
otherwise-
10 seconds.
Otherwise, your lordship sees
kindly takes
on
the
a-
minute.
No, no,
Kindly takes the minute. Well, 10 seconds. I have not
That's why
interrupted.
after going
My
to
lord,
the minutes, I am asking the
Mr.
question to
Chaudhary, my lord, may I just read? Mr. Chaudhary, learned senior advocate, submitted that his client has been advised to file a suit restricted to the relief of a preventive injunction restraining the respondent, which is my client, Bengal Energy, from invoking the PG. He added that such a suit has already been filed. He, as such, does not press the application under Section 17. He could have requested the learned arbitrator dispose of.
That's why I'm
No,
putting
no,
the
see the next paragraph.
That's why I'm putting the question to
The
Mr.
next
Chaudhary.
paragraph.
No,
He
the
has put the impression before the arbitrator that he has filed the suit, so that's why he's not
No,
going.
no,
to
this is
Section 17.
this is not the
And
first
that
day.
is the reason
This
that
is not
it
the
was
first day.
dismissed as not
I
pressed.
think your junior should tell you what happened. This is not
I'm
the first
I'm
day.
reading from the. Oh, I'm reading.
No, no,
from the
I
minutes.
get in a minute, sir. Now.
I'm reading.
Milord,
from
this
the
is,
minutes.
Milord, I must say this. This is most unfortunate. First day when I moved the petition, I moved the Section 9, made my open just the way I've opened before your lordship today. Observation of the learned arbitrator was that Mr. Chaudhary, please consider the matter. Bank is not a party before me. You should go file a suit. I said, please give me a day's time to take instructions and think about the matter. Keep it after 15 days. Lordship keeps it after 15 days. On the night before, I go file the suit and go and withdraw it.
Okay.
And
okay. Come tomorrow. Come tomorrow. Come tomorrow.
And Milord, there is no objection.
Why should
There
I
is
object? He's
not a
withdrawing his own
statement.
Section 11-17 application.
No, there's
He
not
could
a
have
question
requested
and you
the
come
learned
to court.
arbitrator.
Why they will raise objection if you are committing something wrong? Why the other party will raise objection? No, this is not correct. Other party will take the benefit of the appropriate stage. If you are
Question
committing
is,
wrong,
am I-
why they will object?
Very
on
well,
that?
Milord, very well. Let us now see, as per bank guarantee law, whether I have done something wrong or not.
That is different thing. That is different
There are
thing.
two
Now,
issues.
because now if you directly file a suit,
Yes.
taking into the bank guarantee, tri-party agreement, that is different thing.
Yes.
Now, here the fact is that you have first invoked Section 9
Yes.
of the same document of the same party. Section 9, you got the order. Subsequently, you again went to the Section 9 before the same court.
No, no.
What?
Same section.
Same Section 9.
section.
And in that you have got the order from the court. Yes, you filed a 17 application. That till that period, 3 weeks time has been granted. Now Section 17 application you have filed. Now you are coming to this court. Now suit will be
Now,
filed. It is
question
not the
is-
finding. It is not the finding of the arbitrator. No, I am not going.
But the
to that
leave.
Section
But the
17.
leave, my
Leave
lord.
might be. Leave might be. See, if you file a suit. And tomorrow you are coming to this court. My lord, I am taking appropriate steps. Please give me a leave to withdraw. The court will give the withdraw, but the court
No, no.
will not give
Yes,
any
yes. I
finding.
agree. Leave to withdraw.
Correct.
But have I taken leave to withdraw? No, I have taken leave to withdraw with leave to move the appropriate
That's why the
proceeding.
tribunal is concerned. The claimant is granted liberty to apply the preventive injunction before the such forum as they may be advised. First, you have made a submission. Let us see. Let us see. Come tomorrow.
Very well, Milord, what can I do? Milord, I go to arbitration, Section 9 court. Learned judge says that I don't have jurisdiction to entertain you for go file suit. I file a suit.
That's
Now
what I'm
this
telling you. You
objection.
could have been
Milord,
taken.
I will.
You could
Milord,
have
may
been
I
taken
humbly
the-
pray,
you
Milord?
could have, the first day I have indirectly I informed your learned friend.
Milord,
Why
in
you have
my-
not pressed the Section 17 application before
Milord,
the
in my humble
arbitrator?
submission, if I had pressed the Section 17 application and the learned judge had held on any ground that injunction is not obtainable, in that case, I would be stuck there. But
so you have
I have withdrawn with liberty to, I have withdrawn after filing a suit with liberty to move in that proceeding for the same relief. Nothing, my lord, prevents me from getting this relief. I only request your lordship, my lord, because if your lordship, otherwise, remediless, absolutely.
Come tomorrow, see on that this point. Come tomorrow.
My lord, only difficulty, my lord, I'll be very candid with your lordship, my lord. If by any chance your lordship, my lord, dismisses, in that case, I, my lord, won't either have time to file an appeal or go back before, because I'm running here and there. Merits are in my favor. Learned judges held that you can't do this. But bank guarantee is 1 second. You know, this is preposterous. You know, I will convince your lordship on the law of withdrawal of suit, withdrawal of proceeding. What is the effect of liberty to file afresh?
Period of 3 months. No.
Let him come back on Monday.
No,
I will not. Wait a second, Mr. Chaudhary.
I will not.
No. I will take instruction because he is saying that he might not have the time. I have asked my advocate on record to take instruction that for a week my client will not take any action.
I don't want. I don't want your.
He can prefer an appeal.
No. I don't want your charity.
Then let's do it on the.
I don't want it. I'll come back tomorrow and I'll argue.
Come on.
I don't mind coming back tomorrow.
Please extend the order.
No. Why not? I oppose that. It is still 6th of February. It is still 6th of February.
6th of February. Yes, I am taking on 27.
If it can have some preference, my lord, and retain its position in the list, my lord.
Let it come on 27. Come 27. I will take the first matter.
28th, I'm not there, my lord.
27, I will take. 27. Monday.
Is it not possible to do it today, my lord?
All the fixed matters there. Fixed matters are here.
But I must say, my lord, 27th I'll come, my lord.
Come
Morning
on,
10:30.
10:30.
But a humble submission is, my lord. I know, my lord, our submissions, your lord, just the way we think about merits of the matter, our submissions also are on your lordship's mind.
You are correct. You are correct. I am
with
not
leave,
that.
I am here before your lordship.
This court is having a view. Once you have taken a leave from the court and the court has granted the leave to file the section 17 application and 3 months time has been given and you file this section 17, why you have not obtained the order from the arbitrator?
May I just inject something into this? What is the effect? I ask myself the question. What is the effect of the second leave?
Why you not thought this submission which you are making at the time of making submission?
But I have taken leave from the arbitrator. Will that be meaningless?
Why you have not made this submission before the section 9 court? No, it cannot be. I cannot move the section 17.
Section 9 court, after constitution of arbitral tribunal, doesn't decide and sends me to the arbitrator. Arbitrator gives me leave to come.
Okay.
Can that be washed away from the minutes?
Okay, come on Monday.
Can it be washed away?
Monday 2 p.m. Come at 2 p.m. at Monday?
Yes, well. Grateful.
Leave granted by arbitrator.
Files the suit, decides to withdraw.
What is so funny about it?
Counsel for the plaintiff has argued at length with regard to interim order, but due to paucity of time, hearing could not be completed. Let the matter appear on 27th of January at 2 p.m.
Grateful.
Sir, kindly consider that, the leave granted by the arbitrator. Will it meaningless?
Come on that day. Answer?
I will not take too much time.
Yes.
So this is that. What you can see my this is the on the application. Let me take my original note and this. I will not trouble my lord with any documents today. The claim is made on the premise that the status quo order in terms of prayer B, GA 845 of GA 85 continued as it is till withdrawal of the suit.
Correct.
Because this is factually incorrect. After 23rd of March 2015, the parties out of court on 2nd April by way of an amendment to the MOU agreed to continuation extension of the MOU till 31st of March.
So that's why you have submitted. Once the amendment has come, so that on order.
Everything goes. This extension has the impact of waiving its earlier refusal. And then, Lordship, there's no amendment of the plaint. And then best is subparagraph C. By order of 6th May, GA 845 is disposed of. The status quo order was expressly modified by allowing the parties to discharge their reciprocal obligation. So expressly modified. Lordship sees the order. After this, how can he say? And this order does not record any opposition from the side of the defendant.
Yes.
And now, in the said circumstance, the basis of the defendant's claim, as if the status quo order in terms of praise we passed on 23rd March is continue as it is. That's the whole point. And Lordship, I want to finish with Lordship 13th May order. This is in April, on 6th May, both sides more or less agreed, they extend the MOU that they will continue. And after this, the Lordship, after Lordship is a court of equity, Lordship sees page 163. Then he turns around. 13th May, he disputes this MOU is invalid. You can't look into this MOU. This is an unstamped document. He extends it. Then on that basis, the GA is disposed of in another GA where the bonus shares are in issue. This whole thing is illegal. See, I was humbly praying, my lord, this is an application, Lordship, in a court of equity. Can you not entertain this? This is flip-flop at every stage.
Okay.
My lord, I appear for the defendant petitioner, my lord. I'm praying for a short date for a rejoinder, my lord. Short rejoinder, we'll come back and let them stand up, my lord.
When this will be completed? So many dates.
Just a short date. We'll come back with a short rejoinder.
So and so appearing for the plaintiff.
Lordship would ask for a note. Have you given your note? So Lordship would ask for notes at the end. I don't think they will come back note as yet.
Lord, we'll come back with the note as well on the next.
Suffering for the defendant, counsel for the plaintiff has filed a supplementary note. Let the same be kept with the record. Counsel for the plaintiff has concluded his argument. Counsel for the defendant prays for time to give reply. Accordingly, case is adjourned. Let the matter appear on non-commercial है क्या? कोई डेट है, कोई टाइम है?
Except next Tuesday, any day.
Let the matter appear on. Let the matter appear on 6th of February under the heading Adjournment at the top as parted.
Grateful.
My lord, I am for
the defendant number 1 to
plaintiff, my lord. A short backdrop before Lordship further proceed, my lord. Chance to file WS was closed, upheld by the appeal court. My lord's order. I am for the plaintiff, my lord.
What is the GS6?
My lord, GS6 is at my instance. I am the defendant number 4 in the suit.
My lord, now
this is my
ploy to delay.
Expunging my name
Yes.
from the array of defendants. My lord.
No, I am opposing this application.
Which application?
No, his application for expunging.
You are appearing for?
The defendant number 1 to 3.
As all are, it can be understood that if Lordship can.
For the plaintiff.
Yes, my lord.
So return statement, you will not file the return statement.
No, my lord, no one, everyone. And my lord, kindly see, my lord, there is a clear averment against the defendant number 4. My lord, even, my lord, though we were not, my lord, kindly, I would like to show one instance, Lordship will understand. But though after the closure of chance to file written statement, my lord, there is no question of discovery and inspection. My being over candid, my advocate on record offered them if they would like to get inspection. They said the ploy to delay. They said no, there is no formal order, not now. So this is one after another application.
Where is the order?
But see, the order of
closing the written statement.
my lord, the order of the appeal court, I am saying that it is
That is an admitted position, my learned friend is trying to impress upon.
No, not.
But I have a right
Arey,
after the law to prefer an appeal,
Yes.
but I preferred.
Okay, no
I knew my lord, I had no chances.
No problem there.
It's not a question of delaying the proceedings.
My lord has only worked on the statutory part.
Lord,
Number 4 did not go.
without a
October 4,
without
my
a
lord,
written
order.
statement, I am very limited.
October
Okay,
4.
okay, leave it. Okay, you want to file affidavit to
No, my
I
lord,
want to file, my lord. I want to file an affidavit because, my lord,
you are the defendant.
No,
How
my lord,
you
I-
can? You are
well,
not
if
the
he is
judge.
expunged,
You
my
are
lord,
not-
if he is expunged, then my lord, I will be in trouble. The
you
entire
that?
decree will fall on me if there is a decree.
Okay.
So like, he should not be expunged. That's my
My lord,
contention.
even if
Plaint is there. Plaint नहीं है. क्यों नहीं आ रहा है? Where is the plaint? You are not enclosed the plaint and you find an application for RA of the party.
My lord, I have only
coming for the first time.
What is the document?
Then they have. My lord, if you, my lord, the actual thing is, my lord, on the last occasion when this matter appeared, my lordship came to the last order. My application GA6 was already filed before that, but it did not appear on that day. It is appearing.
Correct. Now it is appearing. What?
The plaint is not has not come today, my lord. And they want to, and if they want
I wanted to hear the application here without the plaint. Yeah, show me.
without the plaint, perhaps it would be a little.
So you are not enclosed. It is your duty.
Delay and now is
You know the practice of the original side. The GA application will not come with the plaint of the suit.
Now the WS chapter is closed. Now a new track of delay.
My lord, if the application can come again with the plaint, my lord.
No, I am. Yes. What is why you wanted to array?
My lord, this is the case of the plaintiff in this matter is, my lord.
Ah.
Simple. Goods sold and delivered.
You are also not disclosed the what is the prayer in the plaint.
It is
You filed an application only disclosing the 7 paragraphs. That too, all paragraph have 2 lines.
Well, I really have that only one document to release.
Yes, show me.
My lord, in my GA6, my lord, the lordship
In cross-examination, they will get.
in my GA6, my lord, the only document that I've relied, my lord, is the MCA portal document, my lord.
Correct.
Which clearly shows, my lord, that I am not, I'm neither a shareholder nor a director of the company. I'm no one in the company. And all transactions, even in the plain, the document that carries in the plain, my lord, all transactions are with the defendant number 1. 1 is the company, defendant number 1, 2 and 3 are the directors of the defendant number 1 company. And defendant number 4 have no nexus, no privity of contract in this matter, my lord.
Okay, it is upon between them, between you and the defendant.
See the paragraph in the plaint.
You and the defendant.
My lord, nothing from the plaint, my lord. If the plaint appears before, my lord, I can show from the plaint, my lord. Nothing, no specific allegation against me, my lord. All the documents. For example, there is a paragraph, my lord. He's saying that the plaintiff is saying that all the defendants. Now the corresponding annexure, when I'm looking into, my lord, I am nowhere to be found in the annexure, my lord.
That
There
is.
is not a specific pleading against the defendant number 4, my lord.
अरे she तो जज साहब जाने it is a matter of trial.
Quickly, my lord.
जज साहब को शिकाबू ना. My lord knows that it is a matter of
My
trial.
lord knows, my lord. Order 1, Rule 10, my lord, at any stage, my lord. I have missed the window of 120 days. I admit, my lord.
What is the concept?
Order 1, Rule 10, my lord, at any stage, my lord.
I am not telling that it is barred by limitation. The court is not taking that the application filed by you, the barred by limitation. Only you have to show that there is no cause of action against you and there is no prayer made against you. You are not a necessary party or not a proper party. This 4 thing is to be satisfy this court. You are not the necessary party. You are not the proper party. No claim has been made. No claim has been made. These are the things is to be. Yes, show me.
I really apologize for the plaintiff should have been a part of this application. My lord.
So and so appearing for the plaintiff, so and so appearing for the defendant number 1, and so and so appearing for the
I
defendant.
appear for 1, 2, 3.
I am for the plaintiff.
He appears for
appearing
4.
For the plaintiff, so and so appearing for the defendant 1, 2, and 3, and so and so appearing for the defendant number 4. Defendant number 4 has filed an application being GA Form 6 of 2025, praying for deletion of the name of the defendant number 6 from the cost title of the plaint. Full stop. As full stop. It is fine from the application filed by the defendant number 4 that he has not enclosed the copy of the plaint, and the department has also not sent the record of the suit, and as such it is not possible for this court to take the application filed by the defendant number 6 for hearing. Full stop. Due to this reason, the case hearing of GA6 is adjourned. Let the matter appear on.
On the next week. Darao bhai. No, this is the ploy, my lord.
Let the matter
When it can come from the record, this is the ploy.
Let the matter appear on.
Again, an extension for supplementary
January 2025. So the department is also directed to place the record of CS Form 4494 of 2024 along with GS6 of 2025 on 31st of January 2025. Come on 31st.
My lord, any day next week, lordship?
31st. Next.
Next week is the 31st.
আরো খেলবি? দশটায় কিন্তু সব বোঝে।
কি বোঝে? আমি
Item number?
To the petitioner, my lord. On 10th January, your lordship was pleased to take up this matter. And the defendant did not
None
appear.
appears on behalf of the defendant according to the interest of justice. Same heading. Today also nobody is appearing.
Nobody is appearing. This was a peremptory direction, my lord.
What is application?
My lord, this is that matter. Your lordship remembers your lordship had heard this matter over a period of time. I am the landlord. The suit for eviction. Earlier, it was filed in the regular division. Defendant took a point that it should be filed in the commercial division. Then I came to the commercial division. About 18 lakh rupees outstanding on account of rent. That is IAGA 1 for payment of the outstanding dues on account of rent. Then the second application is for summary judgment, your lordship, under 13A for eviction. The matter was heard at length. The 13A was resisted on the ground that there's a suit pending in the city civil court, and a section 10 application was reserved for judgment by a coordinate bench. I said that very well the eviction may not proceed, but the monies which are outstanding, admittedly due and payable 18 lakhs odd, ought to be directed to be paid. That argument was being heard. Then they came up with an application for rejection of plaint under Order 7 Rule 11, saying that now that the commercial court does not have jurisdiction, it should be an original suit. They keep doing this flip-flop, my lord. I am only humbly praying, my lord, that
the order passed by this court.
Beg your pardon, my lord?
That order, T. Thompson.
T. Thompson, my lord, is still pending. 7th of March has been fixed. Learned senior counsel has been appointed as amicus by the larger bench.
So that is the ground they have taken in this also.
Yes, my lord. They say that this should be a... But in this case, my lord, given the stand earlier that this cannot proceed in the original side, they cannot take this point again, my lord. And similar point had been taken by the husband. This is against the husband. Similar point had been taken by the wife. There were two suits, my lord. Two premises. One let out to the husband, one let out to the wife. The wife had taken a similar stand earlier. And so from the original side, the suit was transferred to the commercial side. Then, my lord, Deepak Polymer came in. So then they took a stand that it should be before the commercial side, which was overruled by the coordinate bench, my lord, and a decree for eviction was made, which was confirmed in appeal, not interfered with. Kindly see the appellate court order in this also. This is the order of the learned single judge. Kindly see, my lord, paragraph 11 of my Lord Justice Kapoor's order, recording this constant flip-flop and attempt to, my lord, defeat my rights. Justice Kapoor's order on a single page. Yes. Kindly see paragraph 11, maintainability of the suit. Suit is not maintainable in the commercial division, should have been filed. Having contended that the suit was not maintainable in the ordinary original civil jurisdiction, the defendant number 1 is now stopped from contending that the suit is now not maintainable before the commercial division. Same ploy over here, my lord. Accordingly, I find that the contention of maintainability is one made in sheer desperation and is outrightly mischievous. If taken to its logical conclusion, this argument would mean that no suit can be filed by the plaintiff against the defendant number 1, whether in the commercial division or in the ordinary original civil jurisdiction of this court. Obviously, the only intent of the defendant number 1 is to drive the plaintiff from pillar to post. Thus, I find no merit in this contention and the same is rejected. And, my lord, the decree for eviction was made. Against this, an appeal was preferred, my lord. Your lordship will see, kindly see the order of the appellate court, my lord, 2023 SCC online Calcutta 766. And I'm not troubling your lordship from the arguments. Kindly see paragraph 20. From whatever angle this court looks, that we do not find any illegality and or infirmity in the impugned judgment, the appeal is thus dismissed. So, my lord, I am only pressing GA1, my lord, eviction can stand for the time being, but if your lordship kindly sees GA1, please, my lord. Monthly rent of 1,09,250 per month.
Yes.
And from 2019 November, this has not been paid. And apropos this, your lordship will kindly
What
see
is the last paid rent?
1,09,250 admittedly, my
Per
lord.
month?
Per month. 1,09,250 per month is the last paid rent.
Where is the document?
Your lordship will kindly find it is an admitted position, my lord. May I just show it to your lordship from the affidavit in opposition? Kindly take the opposition of the defendant, number 1.
Yes.
Kindly see paragraph BB at page 12 of
12
the
paragraph BB.
paragraph BB.
Yeah.
It is also pertinent to mention that the said monthly rent of the suit premises was enhanced to rupees 1 lakh so and so only by the petitioners, and which they received till November 2019 and thereafter refused to accept online payment of rent from the respondents. Well, they say November, I say September, but without going into this dispute of September or November, because they've not given any proof of payment up till November. They've annexed the rent receipts at Annexure H, but that doesn't have any rent for October or November. In fact, it stops at September. So, my lord, from November onwards, at least on the admission of the respondents, my lord, kindly consider prayer A of my application.
Yes.
And this money is admittedly due and payable. So, although it says that it should be deposited before this honorable court, I pray, my lord, that it should be handed over to me and I be permitted to treat this as occupation charges without prejudice to my rights and contentions in the suit, my lord. This amount will work out to, I'll tell you, lordship, my lord, from November, 67,73,500 for the total period of 62 months.
Yes.
Your lordship will see the order sheets in this matter. Matter was argued at length, and then they suddenly come up with an application for rejection of plaint.
What has happened to that?
That is also pending in your lordship's list, my lord. That is GA6. They seek an adjournment. If your lordship sees how mischievously they've done this, they seek an adjournment on 9th of December. I had completed my arguments on 18th of November. If your lordship sees the order of 18th November, I had completed my arguments.
Depositing, yes.
Yes. And after my argument is completed, they seek time on 9th of December. And then they come up with this application under Order 7, Rule 11 for rejection of plaint. Very sharp practice, to say the least, my lord. The trend is, my lord, to somehow evade adjudication. Earlier, this matter was heard on 10 September. If your lordship sees the order of 10 September, they took the ground that section 10 should be heard.
So appearing for the plaintiff. None appears on behalf of the defendant. The plaintiff has filed an application being GA1 of 2021 in CS 115 of 2021, praying for a direction upon the respondent to pay a monthly sum of rupees 1,09,250 to the petitioner or to deposit the same before this court on and from September 2019 till such time the respondents hand over the physical, vacant and khas possession of the said premises to the petitioner as occupational charges with respect of the said property. The defendants have filed their affidavit in opposition. The GA1 and the said application was taken up for hearing, and on 18th of November 2024, the learned counsel for the petitioner has concluded his argument in respect of GA1 of 2020. The matter was fixed on 9th of December 2024, and on the said date, the learned counsel for the defendant prays for time. Accordingly, the case was adjourned till 9th of January 2025. On 10th of January, the matter was taken up for hearing, but none appears on behalf of the defendant. And accordingly, for the interest of justice, the case was adjourned till today. And in the order dated till 21st of January 2025. In the order dated 10th of January 2025, it was made clear that on the date fixed, if the defendant fails to appear, appropriate order will be passed. Today, when the matter is taken up for hearing, none appears on behalf of the defendant, no accommodation is sought. Full stop. As none appears on behalf of the defendant, accordingly, the application being GA1 of 2021 was taken up for passing. Full stop. Admittedly, the defendant was the tenant in respect of the premises in question. Full stop. The defendant in paragraph.
Your Lordship, I appear for the
defendant in paragraph.
I appear for the defendant in this matter.
Yes.
Your Lordship, I appear for the defendant in this matter.
Yes.
I'm audible. Your Lordship, the fact is that if due to some family emergency, I have to go out from court in the first half. Your Lordship kindly takes up the matter any day. I had a family emergency. That's why I had to push up from the court immediately in the first half. I came to court.
Mr. Banerjee, this is not the way. When the court has already started, then you are watching what the court is doing. Then
No, I was not watching, Your Lordship. I was not watching. My clerk told me that the matter has been taken up.
You are not the alone advocate appearing for the defendant.
Junior, I didn't find him in court.
From the record, four persons are appearing in the matter.
Correct.
And you are make the court as a fool. On the last occasion, when the matter was completed, you filed an application for dismissal of the suit. You have taken the time. Again, the time was given. On the last occasion, none appears. This court has, for the interest of justice, adjourned the matter, made it clear that if none appears, and today none appears. For 15 minutes, Mr. Thakkar has already argued the matter. Now, court has started a dictation. Now, Mr. come from the through the video conferencing and telling that you are appearing for the response.
Your Lordship, I thought my junior is there. Your Lordship, I apologize for that.
It is not you are all singly appearing. For the last, I find from the Testator, 4 persons are appearing for the defendant.
Yes. Arijit Roy is the junior. I don't find him in court.
So sorry, I am. Yes.
Your Lordship, due to some family emergency, I had to go out from court. Your Lordship will grant me. Your Lordship will fix the matter on Monday. I will come and argue.
In question and
Your Lordship will fix the matter on Monday. I will come and argue.
In affidavit in opposition.
Your Lordship will kindly give us one opportunity. I will come and argue on Monday, Your Lordship.
Paragraph 5 within bracket BB have admitted with regard to the enhanced rent. Full stop. Paragraph BB, paragraph 5 BB reads as follows. Record this. Full stop. Okay? Set out कर. Full stop. Now the only disputed question here, whether the defendant is required to pay the occupational charges, that is rupees 1,09,250 from the month of September 2019 or from the month of November 2019. The plaintiff is claiming the occupational charges from the month of September 2019. But the defendants in their affidavit in opposition stated that the plaintiff has received that.
Starting now, kindly hears me out, my lord. Kindly hears me out, my lord. I just not starting. I'm being led by Mr. Banerjee. Also starting now.
Received the monthly rent and received the rent till the November 2019. Considering the above, as the defendant, considering the above, this court find that the defendant has admitted with regard to the monthly rent, enhanced monthly rent of rupees 1,09,250 in the affidavit in opposition. Thus, the defendant or defendants? Defendant is directed to deposit the monthly rent and the occupational charges of rupees 1,09,250 per month from the month of December 2019 till today, and also to continue to deposit the said monthly occupational charges with the registrar of this court within 2 weeks from the date of this order. Full stop. If the defendant paid the said amount and deposited the said amount with the registrar of this court and registrar ordinance side of this court, comma, the registrar ordinance side shall invest the said amount in the interest bearing fixed deposit having the facilities of auto renewal and to file the report before this court. File the report before this. In view of the above, GA number 1 of 2021 is disposed. Next. No. Record one. At the time of dictating the order, the learned counsel for the defendant prays for time, but this court considering the record find that time and again the defendants are taking the time, and the defendants have already admitted the occupational charges. Thus no adjournment has been given and the order is passed. Next.
I am appearing on behalf of the plaintiff petitioner, Your Lordship. Your Lordship, on the last occasion had directed us to obtain as to whether any written statement has been filed with the department. Your Lordship, we have obtained the certificate.
Filed? Written statement filed?
Oh, no written statement has been filed, Your Lordship.
When they entered appearance,
Your Lordship,
writ of summons was
page
served on
before.
1810. Original writ of summons, copy of so-and-so. Forwarded on Sunday, copy of the original writ of summons along with the copy of the print inquiry letter was dispatched to the address. 18th October they are received.
Yes, Your Lordship.
Defendants have entered appearance on
3rd January
2023. They are not filed.
No
Sole
written statement.
defendant. Sole defendant.
Yes, Your Lordship.
So what is the GS6?
Your Lordship, for the judgment on admission. Your Lordship, we had made over an amount of 1.5 crores for supply of raw cotton bales.
For supply of
raw cotton bales, Your Lordship.
Where is the amount paid to you? Paid by you to the defendant?
Your Lordship kindly takes the bank statement being annexed A. Photo tariff. 31st December 2000.
Annexure A?
Annexed A to the application, Your Lordship.
Yes. Where is the amount paid by you?
Yes, Your Lordship.
1 crore 50 lakhs.
1 crore 50 lakhs, Your Lordship. Your Lordship,
At
kindly
one
comes
time?
to
One
yes, Your
payment?
Lordship. Kindly comes to page 19.
Page 19, yes, find it.
31st December 2019.
Correct.
Now, Your Lordship, there is an email whereby the defendant had acknowledged. Page 28.
Page 28.
Page 28, Your Lordship. The email from the defendant. I so-and-so, proprietor of Mahavir Gaining Pressing Factory, Relegaon, took advance of 150 lakhs rupees against cotton bales, but because of some problem, our gaining is not working. So we request you that we will return your money on 15th February 2020.
Correct.
Now, Your Lordship, part of the supplies had been made, but the rest have not been made. Your Lordship kindly comes to the particulars provided in page 4.
Page 4 of?
My application, Your Lordship.
Yes.
Total advance is 1 crore 50 lakhs. Less supplies made 76 lakhs 65,422. Add interest debit note sent by the petitioner to the
supply. Where is the supply made? Where is the document?
Your Lordship, there is no document, but we are acknowledging that this supply has been made. Although they have acknowledged that they have received 1 crore 50 lakhs, which they have to pay back. But thereafter, we have received some supplies, which we are acknowledging, that is of
They
76
have supplied
lakhs.
the amount, the materials to the amount of rupees 76 lakhs.
Yes, Your Lordship, that we are acknowledging. So that's not we are claiming, Your
So
Lordship.
what remains after deducting the 76 lakh 65,000?
And also, Your Lordship kindly then turns over the page. Less miscellaneous ledger account. There has been some adjustment. So this has been given the benefit of also 3 lakhs 9,000. And then adding the interest, the total comes to 1 crore 16 lakh 65,000.
1 crore 16 lakhs
65,000.
That is the interest.
Yes, including
So,
interest.
When they have supplied the materials to you?
Your Lordship, no document has been given, but Your Lordship, the fact that it was given has also been pleaded in paragraph 9. After
Correct, you have pleaded. So how the court can say, yes, this is the date you received the materials, the amount you deduct, then the amount, the interest is to be calculated.
Your Lordship kindly considers this thing. 1 crore 50 lakhs we have given. We have shown it from the bank statement.
Correct.
Now the defendant has acknowledged that 1 crore 50 lakhs which we have received, we
Correct.
could not give it. We could not supply the raw cotton bales
Correct.
to the plaintiff. Hence, we will return the entire money. The entire money.
Correct.
Now, Your Lordship, thereafter we have received some cotton.
That's why I'm telling, sir, received. You have received.
Yes.
You are admitted. I have no problem on that.
Yes.
So, and you are calculating the interest of 31st of December 2019. When you have received the materials of 76 lakhs.
Your Lordship, the interest would in any event be calculated from the date of payment, because for that amount, Your Lordship, we have not received the supplies. So, Your Lordship, from the date when we had made over the sums, we are calculating the interest on that sum from that date, Your Lordship, minus what we have received. So, Your Lordship, possibly when we have received the materials is not concerned with the interest. I humbly submit, Your Lordship, because I am only charging the interest on the amount which is still lying outstanding, Your Lordship.
Correct.
Not on the amount, not the.
Sorry. Kindly come to the page 4, subclause C.
Yes, Your Lordship.
And kindly come to the page 19. 31st December 2019, you pay 1 crore 50 lakhs.
Yes, Your Lordship.
Now kindly come to the page 4, subclause 6. Particulars, interest debit note, so and so, 31st December 2019. Then
Your Lordship kindly sees it is after B, which is after the negation of the 76 lakhs. Interest 1 crore 50 lakhs.
Where it is mentioned. That's why I'm asking. So you have not given a particular figure. This amount was paid. Okay, 31st of December 2019, you have paid 1 crore 50. Correct. You have not mentioned the amount and the materials have been received with regard to 76 lakh, which date. So that is to be segregated.
Yes, Your
then
Lordship.
the interest part come. If it is not from that day to that date, the amount on which date the materials of 76 lakhs was received, you are not mentioned in any
Yes, Your
of the
Lordship.
paragraph. In the plaint also you are not mentioned.
No, Your Lordship, that is not. Your Lordship kindly grants me a moment. Interest only on the balance sum calculated for us.
And you are asking for the order 12 rule 6.
Yes, Your Lordship. I'll come back with instructions.
So suffering for the plaintiff, so suffering for the defendant. None appears on behalf of the defendant. The plaintiff has handed over the report issued by the Deputy Registrar Legal, wherein it reveals that defendants have not filed return statement till 9th of January 2025. Full statement. The petition 9th of January 2020. The plaintiff has filed an application being GA-Com 6 of 2024, praying for judgment and upon admission. Heard the learned counsel for the plaintiff, but counsel for the plaintiff prays for time for taking appropriate steps. Accordingly, case is adjourned. Let the matter appear on
Your Lordship kindly.
18th February.
Your Lordship kindly keeps it any day next week.
What you will do?
Because it's a short matter, we'll just finish it up because the defendants are anyway not appearing.
31st January. Yes, next.
Grateful, Your Lordship.
My lord, I appear for the applicant in this matter, my lord, for the defendant. My lord, my instructions are that there has been a talks of settlement which has commenced. On 11th of January, my lord, there was a meeting.
But I'll tell you, Lordship, my lord, this is a matter where, my lord, the my lord, defendant was, my lord, not allowed to file their written statement because it was out of time, my lord, after 120
No,
days.
we have taken out, my
And
lord, an
thereafter they have
application
taken
for
out
extension of time, my lord, because that's also pending.
Okay, let me come.
That is also pending.
Thereafter, my lord, they have, my lord, taken out an application for dismissal of the plaint on the ground that, my lord, the writ of summons had not been lodged within, my lord, the extended period, and the master does not have, my lord, the power to extend, my lord, the
My
writ
judgment.
of
That is there.
summons.
That is there, my
My
lord.
judgment is there. On that.
In fact, my lord, if your lordship recalls, Mr. Rai was addressing your lordship on this, but it is on the ground of settlement that Mr. Rai has also been preempted from appearing today. So
But only
that's the
difficulty is
only
that, my
thing.
lord, we have instructions that, my lord, we have clear instructions that there is no talks of settlement which is going on. I'll leave it to your lordship, my lord. My lord, we have instructions to oppose. I really cannot oppose my learned friend, my
To
lord.
whom you have
But
settled?
That is my clear. I just received an instruction right now, my lord. It's on my WhatsApp from my advocate on record indicating, my lord, that on 11th of January, there was a meeting held. If it could be settled, otherwise, my lord, the matter will take its own course.
Well, I'll not come in the way, my lord, as of today, my lord. But on the next day, my lord, if your lordship kindly
As per the
preemptively
prayer.
fixes it, so that, my lord, if it's not settled within that time, my lord, it can, my lord, go on, my lord.
So appearing for
And
the
kindly give a
plaintiff,
short date, my lord, till
so
that.
appearing for the defendant.
2 weeks for settlement.
Full stop. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on
Short date, my lord, if your lordship so pleases.
10th February.
I'm so grateful. So great.
In fact, my lord, my instruction was if 2 weeks could be granted,
2
in the
weeks.
meantime, we've settled. Yes,
2 weeks.
Yes. I completely bow down to your lordship
I'm
on that. Very good. Great.
Lord, item number 12 is my application. There are two applications, 12 and 13. The first application is, my lord, for condemnation of delay.
For?
Condemnation of delay for, my lord, filing an application under Order 9, Rule 13. I've suffered an ex parte decree, and, my lord, I've tried and explained the delay.
Where is the order of the
Yes, my lord.
decree?
Yes, my lord. I'll just place that.
Of this court?
It's passed by your lordship. Lord, it's at page 169 of GA 4.
Okay. $169.
Yes, my lord. Volume 2.
Yes.
স্যার আপনি বলুন না স্যার ডিগ্রিটা রিকল করে দিচ্ছি কি হচ্ছে বাংলাদেশ ব্যাংক থেকে
This Bangladeshi?
Yes, my lord. Enemy state.
How you got the instruction nowadays?
Lordship
From
sees that's the
Bangladesh?
explanation. That is the explanation for the delay.
Appeal is preferred against this?
We had preferred an appeal. The Honorable Division Bench advised us, to be very honest, that don't prefer an appeal. You should exhaust your remedy before the single judge. So based on that, we came back before your lordship, my lord.
What is the ground? Because you have not appeared.
Yes, my lord. We had not appeared, my lord. The ground in the main application is this. They show service of the writ of summons at the address of the bank according to them, it's been served. But we have shown, my lord, the pin code on which they have alleged to have served, there is no such pin code. From the Postal Department of Bangladesh, I have taken a printout. I have indicated that that particular pin code does not exist. That's one. The other point is this, my lord, that in the report filed by the sheriff, there is no conclusive proof that it's been served. In such circumstances, they should have approached this Honorable Court under Order 5 and sought for newspaper publication in Bangladesh. Maybe, my lord, because I'll just indicate the language when it came as in the draft, it was not very happily drafted. So, my lord, what had transpired is this, my lord, it seemed as if the submission before this court is this, that as newspaper publication had been made. Instead, it should have been, there should have been a newspaper publication, which is not there.
That was a deliberate statement on oath. I don't know how you are going to come out of it.
I can't come out of it. Now, my lord, I have tried and explained the delay, my lord, on 2 counts. Firstly, my lord, with regards to the documents which we have tried to rely upon in this application and along with the application for recalling, these were all, my lord, in the vernacular language, which is the national language of Bangladesh. We had applied and we took time to have it converted into English, my lord. Thereafter, we filed it. My lord, we have certificates to that effect.
Who are you?
I am, my lord, the defendant number 2 in the suit.
Defendant number 1 doesn't come.
So what is your role?
Well, I am letters of credit. Letter of credit claim on account of a revolving credit as against Axis Bank. Axis Bank opened a back-to-back LC with my bank. So they have a claim for the goods allegedly, which they have supplied. I do not know defendant number 1. Now, my lord, that money claim for honor of the LC has gone against me because Islami Bank, that is the bank which I am representing, had a back-to-back LC with Axis Bank.
You are appealing for?
Defendant number 2.
Islami Bank. So
Yes,
how you have been affected?
Well, because the money will have to be removed from my accounts. So, my lord,
not
there's an
your
honor.
money. Who has given the bank guarantee?
The bank guarantee, it's a letter of credit.
Who has given the letter of credit?
Axis Bank has given.
Axis Bank is given, not the bank. It
No,
is the party.
on behalf of, my lord, the defendant number 1.
Correct. So defendant number 1 is not
No,
here.
defendant number 1 is not here. On behalf of the defendant number 1, they have given a letter of credit.
Correct.
That letter of credit, my lord, would affect my position. Because, my lord, letter of credit is not just the credit which is being, it's my, in a way, my lord, it's the credit which is not just of the customer, it's also of the bank. It's my reputation which is also in stake. So, my lord, I have just tried and explained as to what is the cause for delay. Most of it is, my lord, because of these documentation and the bureaucratic held up. The bureaucracy held it up. Apart from that, my lord, there's not much of an explanation. And I've also indicated that I had preferred an appeal, my lord, which was pending, and pursuant to the appeal being disposed of and the leave being granted, we have approached this honorable court. That is in terms of, my lord, the section 5. On the meat of the matter, my lord, service was not made according to us on the bank. What was served was not at the correct address because there is no such PIN code. The documents also which we have annexed, my lord, these documents have been, firstly, it had to be certified in Bangladesh. Then it was translated, and only then we could have filed it.
Correct. Affidavit already?
Yes.
How much time will take?
Affidavit, I'll take some time, my lord.
It takes. So I am fixing a date and time.
Lordship.
That in matter can be ended. So-and-so appearing for the plaintiff. So-and-so appearing for the defendant number 2. Defendant number 2 has filed the present application being GA Conf 4 of 2024 for setting aside the ex parte judgment and decree dated 22/11/2022. Full stop. 22nd, yeah, full stop. Due to paucity of time, hearing could not be completed. According, case is adjourned. Let the matter appear on. Give the date and time. नहीं मार्च में दे दो, 2 डेट दे दो, खत्म करते हैं. 2 dates दे दो. 17th and 18th March at
17th and 18th March. Well, can it be earlier? Can it be? Well, I shall tell you, Lordship, my lord. On merit, first of all, my submission will be that it's a letter of credit. So, my lord, so far the defendant is almost like an unconditional bank guarantee. Therefore, the person who has taken that goods and consumed it, he is not coming forward to defend the suit.
That's why I put the question.
My lord, that is a very pertinent question.
Yes.
And secondly, my lord, I shall show to your lordship that there had been, I should say, there had been prevarication on the part of my learned friends, clients throughout. And my lord, the plaint which has been, copy of the plaint which has been annexed to their application is the original plaint. If they, with the correction even, I don't know how they will come out of all this.
उससे पहले कोई डेट है? 345 है.
If it can be earlier, then my lord, I shall be very grateful to your lordship.
कब है देखो. 6 February. 6 February 3:45 p.
Very good. Very good. Very good. Your lordship.
Yes, call the list.
So before your lordship takes it, 14 is also mine. My lord, can I come back next week, my lord?
14?
Yes, my lord.
For the defendant number 1 and item 14, my lord.
Live is here, my lord. He's on my other side. I'm just waiting material instructions. If it comes, my lord, I'll come back in a week's time.
What is the matter?
No, this is that judgment upon admission application.
14 record
Covered
by
my lord's judgment.
So appearing for the plaintiff. 14, huh? So appearing for the plaintiff. So appearing for the defendant. As per the prayer made by the counsel for the plaintiff. You are for the defendant. Defendant, the case is adjourned. Let the matter appear on 11th February.
Lordship. I'm also filing a.
Then it will go March.
There is a reply to the supplementary affidavit.
Just replies may be taken on record.
The affidavit in
reply to the supplementary. Opposition.
Affidavit in opposition and affidavit.
To the supplementary affidavit.
Affidavit in opposition to the supplementary affidavit.
And the affidavit.
That is?
Reply.
Affidavit and the reply filed by the parties be kept with the record.
My lord's kind indulgence, my lord. The next matter, I don't know, 15. No. Mr. Gupta is having personal difficulty, my lord.
Okay, I will take the matter. When you call him, I will.
My lord, this is my matter, my lord. My lord, the will is of dated 1st December 2020. May I place, my lord?
Yes.
My lord, the will is dated 1st December 2020. It's at page 10 of the application, my lord, Annexure B, my lord. The executor, page 11, my lord, of the application, Mr. Tarun Kumar Banka, my lord.
No. Banwari Lal is the executor.
Yes, my lord.
Banwari Lal Banka.
No, my lord. Banwari Lal Banka is not the executor, my lord. My lord, page 11 of the application, if my lord kindly takes the application.
Who is the testator? Banwari Lal Banka is
yes,
the
my lord. My lord, Banwari Lal Banka is the testator, my lord.
Where is the executor?
My lord, executor, page 11, my lord, will kindly sees that at the top, paragraph 6, I hereby appoint Mr. my son, Sri Tarun Kumar Banka, residing at
Tarun Kumar Banka.
Yes, my lord.
He is the petitioner herein.
Yes, my lord.
Correct.
My lord, there are 2 witnesses, my lord, attesting witness, Shravan Kumar Banka and Nondita Banka. My lord, they have, my lord, attesting witnesses have that. Affidavits are there, my lord.
When he died?
My lord, he's died on, my lord, the date of death is on 4th of April, 2021, page 9, my lord, the death certificate, my lord.
Page 9.
My lord.
4/4/2021.
My lord.
And what is the date of the will?
My lord, the date of the will is 1st December 2020, my lord.
2020 and 2020.
Page 10, my lord, Annexure B of the application, my lord.
Yes.
There are 2 legal heirs, my lord, 2 sons, Shravan Banka and Tarun Banka, my lord. One is the executor and other is attesting witness, my lord. The legal heirs described at paragraph 4, my lord, page 2 of the application, my lord. If my lord kindly takes the page 2 of the paragraph 4, my lord, there are the names of the legal heirs, my lord. Monju Devi Banka, Yogesh Banka, Dinesh, Nirja, Shravan, Tarun, Nondita and Bandita. They are 2 daughters, my lord.
All like given consent.
Yes, my lord. My lord, the no objection certificates are also there. That the affidavits are there, my lord. That everybody has given consent, my lord, to this particular grant of probate on behalf of the executor. Yes, my lord. If my lord kindly takes, my lord, the.
Just a minute.
Yes, my lord.
Bandita Jajo. Nirjarani. Yes, Nirjarani. Dinesh Banka. Where is the attesting
My
witness?
lord, the attesting witness is Shravan Kumar Banka. Affidavit, if my lord kindly takes. Affidavit of attesting witness affirmed by Shravan Kumar Banka. If my lord has my lord, affidavit of attesting witness of Shravan Kumar Banka. My lord, page 2, my lord, the paragraph 2 at the top, my lord. The said will was executed by said Banwari Lal Banka by affixing his signature the foot in my presence and in the presence of other witness. The testator at the time of execution was in sound state of body, mind, and memory and had full testamentary capacity. Deeply obliged, my lord.
Sense opening for the petitioner. Petitioner has filed the present application for grant of probate of the last will and testament dated 1st December 2020 of the testator Banwari Lal Banka. Banwari Lal Banka. Counsel for the petition submitted. The testator has executed his last will and testament in presence of two witnesses while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will and testament. He submitted the testator died on 4th April 2021, leaving behind 8 legal heirs. 8 legal heirs, and all the legal heirs have filed their affidavit of consent stating that they have no objection for grant of probate to the petitioner of the last will and testament dated 1st December 2020. He submitted that Shravan Kumar Banka and Nandita Agrawal, who are the son and daughter, Shravan Kumar who are the son and daughter of the testator, are also the attesting witness of the said will. And out of the two witnesses, Shravan Kumar Banka in his affidavit has also categorically stated that the testator has executed his last will and testament in his presence, in presence of the another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor. Had the learned counsel for the petitioner peruse the original will, death certificate of the testator, all the affidavit of consent of the legal heirs. Please do. Shravan Kumar Banka, who is one of the legal heir, being the son and also one of the attesting witness of the will, has stated that the testator has executed his last will and testament in his presence while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. In view of the above, the department is directed to issue probate to the petitioner of the last will and testament dated 1st December 2020 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number so disposed of. Part of the will. Yes, next.
19, my lord, I am for the petitioner. This GA application has been filed by the petitioner for incorporating the another address of the testator, which is mentioned in the death certificate.
What is the GA number, madam?
GA number 2 of 2025, my lord.
What application?
For
You be granted to the petition at the another address and amend the cost and
my lord.
another address of whom?
Testator, my lord.
Testator. He
Yes,
is
my
having
lord.
two address.
Yes, my lord.
And
One address is mentioned in the will and another address is mentioned in the death certificate, my lord.
so you mention the address in the will,
Yes.
not the death certificate.
No.
Now you wanted to add the address.
Yes, my lord. Yes, my lord. My lord.
That is only.
My lord.
Nothing else.
Nothing else, my lord.
Where is the 21 by C?
21 by C.
Rasen Street, Lilua.
Agrasan Street, Lilua, Bali, Post Office, Lilua, Police Station, Belur, District, Howrah.
So appearing for the petitioner. The petitioner has filed the present application being GA2 of 2025, praying for amendment in the cost title of the PLA application by incorporate
Along with affidavit of assets and no objection
along with affidavit of assets and the no objection filed by the
petitioner as well as the attesting witnesses.
filed by the
and
no
another
objection of the petition is filed
by the other legal heir.
filed by the other legal heirs. Full stop. It consists of the petition submit that at the time of filing of the application, the petitioner has mentioned the address of the testator, which is available in the will. But after going through the death certificate, it find that in the death certificate some other address is mentioned. Accordingly, the petitioner intend to incorporate the second address of the testator in the probate application and other connected documents. Consider the submission made by the counsel for the petitioner for use the proposed amendment. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Accordingly, prayer A to C of the master summon is allowed. GA2 is disposed of.
Grateful, my lord.
My lord, I appear on behalf of the petitioner in this matter. Lordship, on the last occasion, the attending witness has adduced his evidence. Now today is fixed for arguments, Your Lordship. Now, my lord, if I may indicate,
why they are attending witness?
My lord, if my lord attesting witness was not available, Your Lordship, if my lord looks at the chronology once, the issuance of citation occurred, my lord, by an order of 17th November 2022. Thereafter, Your Lordship, we preferred an application for making paper publication because the citation, the reports mentioned that the addressee has left. The legal heir
means
the attesting witness as well as the legal heir. Both the addressee, the endorsement which was there, my lord, service report, it shows that the addressee left. Now thereafter, my lord, we make an paper publication. My lord, even after paper publication, none appeared before this honorable court. Subsequently, lordship, we sought the leave to prove the will by the attending witness. Now, my lord, attending witness was, my lord, produced before your lordship on the last occasion. My lord, thereafter, my lord, this matter has appeared. Now, if I may indicate first, your lordship, this is the will of 2003.
Where is the will? 18,
my lord, the annexure A, page number 12, my lord. Bengali will.
Name of the testator?
My lord,
Krishnakanta Bhattacharya.
Yes, my lord. Krishnakanta Bhattacharya, my lord, will find.
Where is the name of the executor?
My lord, in the will. Your lordship will kindly take the English translation, your lordship. Internal page 3 of the English translation. I am appointing my daughter Shutapa, my lord. If my lord kindly takes paragraph 3. I am appointing my daughter Shutapa as the executrix, your lordship.
Sutapa?
Yes.
As executrix?
Yes,
and who is the petitioner?
The petitioner is Shutapa, my lord. Shutapa Banerjee, your lordship, is the petitioner.
Sutapa is the petitioner.
If my lord kindly takes paragraph number 4, internal page 3 of my application.
When he died?
Yes, my lord.
When he died?
My lord, Krishna Testator died on my lord 19th November 2015. My lord will find the death certificate at annexure.
What is the date of the death? Date of the will?
Date of the will, your lordship, 18 July 2023. 2003.
18 July?
2003, my lord.
Where from you got? 18 July 2003.
Yes, my lord.
And he died on 2015.
2015.
Yes.
My lord,
What about the where is
wife?
the legal heirs?
Yes, my lord. My lord, we'll find the details from paragraph number 4, page 3.
Paragraph 4.
Protima Bhattacharya is the wife, my lord. She passed away on 1st December 2018. And the son, Shukanto Bhattacharya and Shutapa Banerjee, your lordship. Shutapa Banerjee is the daughter, my lord. She is the executrix. And Shukanto Bhattacharya is, my lord, is the son. My lord, even after issuance of citation and paper publication, my lord, he never appeared before your lordship.
These are the two only.
Yes, my lord.
Yeah, polio ka hai?
My lord, will my lord require the details of the order?
है ही नहीं है
वकील भाई तो पीछे ना घुसा है
कहाँ रखते थे Who is the witness?
My lord, witness is the attending witness is the husband of my lord the petitioner, executrix.
Executrix.
Yes, my lord. Utpal Banerjee, fellowship.
Executrix.
Yes, my lord. Sutapa Banerjee, my lord, is the petitioner. She is the executrix.
Husband of Sutapa.
Yes, my lord.
Yes, that's all.
Yes, my lord.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 18th July 2003 of the testator Sri SRI, Sri Krishna Kanto Bhattacharya. Counsel for the petitioner submit that the testator has executed his last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executrix of his last will and testament. The petitioner submit that the testator has executed his last will and testament in presence of two attesting witnesses. The testator died on 19th November 2015, leaving behind his wife, his son, and one daughter. The wife of the testator died on 1st of December 2018, leaving behind one son and one daughter. Petitioner submit that after filing of this application, notices were issued and citations were issued, but the son has not come forward either to give consent or to file caveat or affidavit in support of caveat. The petitioner further submit that the aware of about the two attesting witnesses were also not known, though the petitioner has taken appropriate steps, even publication of the notice, but the attesting witness have not come forward. Accordingly, the petitioner has examined one witness, namely Utpal Bandopadhyay, being the attending witness of the will. He submitted that the attending witness in his affidavit, in his evidence, has categorically stated that the testator has executed his last will and testament in presence of two attesting witnesses while possessing good health and fit state of mind by appointing the petitioner as sole executrix of his last will. The testator has, the attending witness has identified the will as well as the signature of the attesting signature of the testator as well as the attesting witnesses. At the learned counsel for the petitioner peruse the original will, death certificate of the testator and his wife, It is also found that the department has submitted no caveat certificate on 5th of August 2024 stating that no caveat has been lodged for grant of probate of the last will and testament. Full stop. This court also considered the evidence of the attending witness, wherein he has categorically stated that the testator has executed his last will and testament in his presence and in presence of two attesting witnesses, and the testator as well as the attesting witnesses have signed in the will in presence of the attending witness who has been examined before this court as PW1. Full stop. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Full stop. The department is directed to grant probate, to issue probate to the petitioner of the last will and testament dated 18th July 2003 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number so disposed of.
Deeply obliged, my lord.
Next.
21, I have a petitioner, my lord. Here, my lord, the will of the testatrix, my lord, dated, my lord, 26th day of June 1982. It is registered will, my lord. There is a two attesting witness, my lord. Kindly come.
Where is the will?
Will is, my lord, page 10, my lord.
Page 10.
Page 10, my lord.
What is the name of the testator?
Testator, my lord, first name, my lord, Srimati Rasana Baladasi, my lord.
Rasana Baladasi.
Yes, my lord.
Rasana Baladasi.
Yes, my lord. Same page, my lord. Paragraph 1, name of the executor, my lord, appointed Kanu Patra.
Appoint Kanu Patra.
Yes, my lord.
Son of Kalipada Patra.
She is the issueless, my lord.
Sole executor.
Yes, my lord.
Yes, when she died.
Died, my lord, 1993, my lord. Death certificate.
What is the date of the will?
Yes, my lord. Date of the will 1982, my lord. Kindly see, my lord, page 11, my lord. 26th day of June 1982. It is registered will, my lord.
Yes.
She is
and she died on?
Died on, my lord.
93.
Yes, ma'am. 31st August 1993.
What about the husband?
Husband died long ago, my lord. Death certificate is, my lord. Kindly come to the page, my lord. 13, my lord.
What is the name of the husband?
Husband is, my lord.
Atul Chandra
yes, my lord.
Bandari.
Yes, my lord.
Where is that? Page?
Page, my lord. 13, my lord.
Page 13. Atul Chand Bandari, when he died?
Died, my lord, before, my lord,
27. What is the date?
Date is, my lord, date of death. Yes, my lord, date of death, my lord, is died. My 7/7/1982, my lord.
That is 82?
Yes, my lord.
Good. Yes, then?
Then, my lord, there is two attesting, my lord. Kindly come to the original will, my lord.
Two attesting witnesses.
Both are advocate, my lord, but both are died, my lord. Both are died. Yes, my lord. Both are died.
Naturally.
Yes, my lord.
82.
No, 2020, my lord.
93 testator died. You filed the suit when? 2022. After 40 years.
Page 10 and, my lord, 11, my lord.
Where is the explanation?
Yes, my lord. Page paragraph 13, my lord. Paragraph 13.
The original copy of the will of the deceased
because
was misplaced. The petitioner very recently got the said. Who is the petitioner? He is the executor.
Yes, she is the issueless, my lord.
Huh?
No one there, my lord. He is the brother's son, my lord.
The petitioner who filed, he is the executor.
Yes, my
lord. Old scrap paper lying in the storeroom and premises number 20, for which some delay has been occurred in filing the application. Kanu Patra.
Yes, ma'am.
Who is he?
He is, my lord, the brother's sons of the testatrix, my lord. There are three. His brother also died, my lord. Three son of this brother.
So
who are
notice issued.
Yes, my lord.
Notice issued.
Yes, my lord. Notice publication also done, my lord.
So how you approved the will?
By attending witness. He is.
They appeared.
Your lordship fixed a date, my lord. Last occasion appeared, my lord.
For this you are making so much submission.
Last occasion, my lord, record was not traced, my lord. No, today is not matter. Because last occasion record was not traced, so you will direct to place the matter today, my lord.
Since offering for the petitioner, counsel for the petitioner submit that the two attesting witnesses are no more, and as such, the petitioner intend to prove the will in solemn form by examining the attending witness. Accordingly, he prays for fixing the date for examination of the witness. In view of the submission made by the counsel for the petitioner, let Kamala, in view of the made by the counsel for the petitioner, the case is adjourned. Let the matter appear on when you will have
Calcutta, my lord.
March.
Any day. No.
There is no time to examine the witness. How much time will take?
Only, my lord.
Let the matter appear on 20 February 2025 for witness action. Next.
When I appear for the petitioner, this is an amendment the amendment application. Now I must indicate, there was an page 14. There's an earlier order allowing my amendment was passed by this honorable court. This is Mukherjee's order, page 14.
Yes.
Now page 14, the order, which is GA2, it is for injunction filed by the caveators. Now in
page 14.
1-4.
GA5.
GA5, but if Malalas reads the order, it's because GA5 is an application for amendment and GA2 is for restraint.
Yes.
So GA2 was not allowed.
GA2 is dismissed as withdrawn.
Yes. GA5 was allowed.
Correct.
GA5 was mine.
Correct.
Now the problem we faced during the carrying out the amendment, the similar of the other one, it was not done properly. The underlying portion was not done. I'll show you what happened. Now, if Lordship's pleasure to come to page 31, the asset, the address of the asset is 1 by A Mahendra Chandra Garden Road. So it has gone down as 11 Mahendra Chandra Garden Road.
Where?
Page 31. Now it was initially the struck off portion. Lordship will see 11 Mahendra Chandra Garden.
11 Mahendra Chandra.
It should be now what I want to add.
1 by A.
Yes.
Correct.
So this is the wrong that we made. So the department said that we did a mistake. What mistake we did? Change brief for us. The supply copy given to us by the illustrated advocate, it was wrong. So we proposed amendments was based on the wrong cost papers in our hand. So we now pray before your lordship that the earlier amendment be not carried out and the amendment shown now be carried out, which I am showing at from page 17 onwards. So it's the superseding the earlier amendments. Now, so far this application is concerned, there's an opposition filed by the caveators. They have filed opposition. We are not using a reply. Well, they have said that once amendment has been allowed, you cannot do it for the second time in the opposition. But there is no denial of the such that there is a mistake. And
where is the earlier amendment? You are not enclosed.
No, but the earlier amendment, that is, I have just now was saying the earlier amendment. I can show you. But the earlier amendment which was there is.
Who is for the defendant? Nobody is appearing.
No, they appear. They have filed opposition file. Opposition.
Biswarup Mukherjee.
GA6, sir. Yes. There's one opposition file by GA6.
No, GA6 opposition is there. Affidavit opposition. Yes, GA6.
GA6. So this is the.
So nobody. What we want?
Give them because the same thing happened. Because
so and so appearing for the plaintiff. None appears on behalf of the defendant. The plaintiff has filed an application being GA6 of 2024, praying for amendment in the PLA application.
It is now a TS.
In the plaint. the print. Though the defendant have filed the affidavit in opposition in connection with GS6 of 2024, but none appears on behalf of the defendant. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 12th of February 2025. The plaintiff is directed to inform the next date of hearing to the defendant.
I'll also bring that earlier amendment also. 12th February. Oblige.
My application, my lord. My application, my lord, for letters of administration, my lord. On last occasion, my lord, the executor was in witness box, my lord, for proving the Xerox death certificate of my lord, the testator. My lord, now
Where is the will?
my lord, will is at page translation, my lord, is at page 16. My lord, the executor was appointed.
You're not given the translated copy. Translated copy of the will?
Yes, my lord.
Where is that?
Page 16, my lord.
Page 16.
Yes.
Yes.
My lord, the executor was, my lord, the son of the testator who has.
What is the name of the testator?
Bandhu
Gopal Roy.
Yes.
Bandhu Gopal Roy. Yes. Where is the name of the testator in the will?
At the front page, my lord, page 16. Sri Bandhu Gopal Roy, my lord, son of late Upendrolal Roy, page 16.
Bandhu Gopal Roy is the testator.
And my
Where is
lord,
the executor name?
executor name is at page 18, my lord.
I am appointing the elder son of Sriman Vikas Roy, the executor of this will. Yes.
My lord, he has died in 2018.
Who died?
This executor.
Executor died
My
on?
lord, died on, my lord, 10th September 2018.
Where is that?
My lord, I have annexed the death certificate, my lord.
10th September?
10th September 2018, my lord. And I have annexed the death
What is the name of the testator? Executor?
Executor, my lord, Vikas Kumar Roy. Page 20, Annex C.
Vikas Kumar Roy.
My lord.
10th September or 19th September? What is the date?
Yes, my lord, 19th September. My lord, I'm sorry, my lord.
2018.
19th
Yes.
September.
And when the testator died?
My lord, testator died 12th December 2004. 12th December 2004.
Where is that?
My lord, I have annexed the death certificate, my lord. My lord, page 21, my lord. Page 21, annexed.
The December 2004.
Yes, my lord.
Died. Yes. Then?
My lord, since my lord, it was not issued by the municipality, my lord.
Legal heirs.
My lord, all legal heirs have consented, my lord. I have annexed the consent
How
affidavit,
many
my lord.
legal heirs?
My lord, 6. My lord, I have mentioned page 6, my lord. Para 6, my lord.
All have given
3
consent.
daughters.
All have given consent.
All have given consent, my lord.
Who is the petitioner here?
Petitioner is the, my lord, wife of the executor.
Wife of the executor. Where is the consent?
My lord, I have
Affidavit
annexed, my
to
lord.
Smita
Yes.
Roy.
Six consent affidavits, my lord.
Just a minute. Susmita Roy. Gautam Roy. Nilima Basu. Savita Datto. Smita Talukdar. Biswajit Roy. Where is the affidavit of Ruby Roy?
Ruby Roy is the petitioner, my lord.
Ruby Roy is the
Ruby Roy is the wife of the executor.
And Susmita Roy?
Well, I have filed, my lord. She is granddaughter.
Susmita Roy, there is nothing.
Yes, my lord. She has also filed.
No, there is no affidavit.
Yes, my lord. She has filed. I have my copy, my lord.
Yes, Susmita Roy. And Vikas Roy, son died.
Died.
Where is the attesting witness?
My lord, I have filed, my lord, attesting witnesses.
Who are the attesting?
Bhattacharya, my lord.
Dulal Bhattacharya.
Yes.
Dulal Bhattacharya along with Anil Sarkar.
Yes.
Who was the another attesting
Yes, my
witness?
lord.
Anil Sarkar.
Sarkar, my lord.
Who was examined before this court? Attending witness.
Attesting witness, my lord, Dulal
Now, who
Bhattacharya.
is examined before this court?
My lord, she is the, my lord, the petitioner and wife of the executor. Since executor has died.
Okay. Well, what is the affidavit about what is the total value of the
I paid, my lord, ad valorem duty. I paid.
paid? What is the total value?
Yes, sir.
4 crore. 40 lakhs. Sense suffering for the petitioner. The petitioner has filed the present application for grant of letters of administration of the last will and testament of the deceased Bandhu Gopal Roy, BA and DHU. Bandhu Gopal Roy, dated 10th November 2004. What is the date of the will?
Will 10th November 2004.
Counsel for the petitioner submit that the testator has executed his last will and testament in presence of 2 attesting witnesses by appointing his elder son Vikas Kumar Roy as Vikas BIKASH Vikas Kumar Roy as sole executor of his last will. Of this last will. She submits that the testator died on 12/12/2004. 12/12/2004. And the क्या बोला 12/12/2004 and the executor died on 19 September 2018. And now the wife of the executor has filed the present application for grant of letters of administration. The counsel for the petition submitted that the wife of the testator was the predeceased to the testator who died on 30 August 1998. She submitted that all the legal heirs of the testator have filed their affidavit of consent stating that they have no objection for grant of letters of administration. She further submitted that out of the 2 attesting witnesses, one of the attesting witness, namely Dulal Bhattacharya, has filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind. Counsel for the petitioner submit that the petitioner could not get the original death certificate of the testator and is relying upon the death certificate issued by the hospital authorities. And to prove the same, the petitioner has examined herself before this court and she has produced the medical certificate wherein it is proved that the testator died on 12/12/2004. Counsel for the petitioner submitted that the petitioner has proved the will and is entitled to get the letters of administration of the estate of the deceased left behind. Estate of the deceased. Had the learned counsel for the petitioner produce the original will, comma, death certificate of the testator, comma, death certificate of the executor, death certificate of the wife of the testator, comma, affidavit of consent all the legal heirs, comma, affidavit of the attesting witness, and the evidence of the petitioner wherein and the death certificate issued by the hospital authorities, which has been proved by the petitioner by examining herself before this court, and stated that She could not get the death certificate from the municipal authority, but she obtained the death certificate from the hospital authority, wherein the testator died. Full stop. Considering the above, this court finds that the petitioner has proved the will, and is entitled to get the letters of administration. Accordingly, department is directed to issue letters of administration of the last will and testament dated in 10th November 2004 on furnishing bond of rupees 4 lakhs with 2 sureties, 4 lakhs with 2 sureties on compliance of all formalities. PLS disposed.
Since my lord, at the time of deposition, my lord, I have submitted the all original certificate of cremation, my lord, and my lord, after completion of all proceeding, my lord, may I get back
certified copy, file an application, it will be returned to you.
my lord, originals are there, my lord.
Correct. Because it has been exhibited.
My lord.
The court cannot return. After that, you have to obtain certified copy,
Then,
bring the certified copy on record, and the court will pass an order for return of original.
My lord, great. Okay. Grateful.
My lord, this is my application of probate. In the will, my lord, the name of the attesting witness appearing as Gopal Verma. But at the time, in the will, the one of the attesting witness, his name is appearing as Gopal Verma, and at the time yes, my lord, at the time of filing the affidavit of attesting witness, my lord, he used his name as a Sandeep Verma. So, my lord, there was a direction to bring the attesting witness. We examined, and the deposition dated 17 January 2025.
Yes. So opening for the petitioner. The petitioner has filed an application for grant of probate of the last will and testament dated 6th April 2007 of the testator Sushil Chandra Bhattacharya. Full stop. Counsel for the petitioner submit that the testator has executed his last will and testament while possessing good health and fit state of mind by appointing the petitioner is the testator executor.
Yes, my lord. Rajesh Kumar Shah.
By appointing the petitioner as sole executor of his last will and testament. Full stop. Counsel for the petitioner submit that the testator died on 27th of March 2018, leaving behind 4 legal heirs.
Yes, my lord. The wife of the deceased, son of the 2 sons of the deceased, and married daughter of the
4
deceased.
legal heirs, but none has come forward. Nobody has given consent.
No.
But none has come forward either to give consent or to file affidavit or to file caveat and affidavit in support of caveat. Counsel for the petitioner submitted. The citations were issued. In spite of receipt of the citation, none has come forward to raise objection for grant of probate, and according the department has submitted no caveat certificate, wherein it reveals that no caveat has been entered against the grant of probate of the last will and testament. Counsel for the petitioner submitted the testator has executed his last will and testament in presence of 2 witnesses. One witness, namely Gopal Verma, has filed his affidavit of consent, stating that the Verma, VERMA, has filed his affidavit stating that the testator has executed his last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executor. In the affidavit, the attesting witness stated that he is also known as Sandeep Verma, and accordingly, the attesting witness has examined before this court on
17 January 2025.
On 17th of January 2025, and during his evidence on oath, he has stated that he has put the signature as Gopal Verma, but his name is Sandeep Verma. He has explained that the Guruji of the witness has asked him to put his name as Gopal Verma, as it was good for the luck of the business of the attesting witness, and accordingly he has signed all the document as Gopal Verma, but in all documents his name is appearing at Sandeep Verma. Full stop. This court has the full stop. Considering the evidence of the attesting witness, this court find that the Gopal Verma is also known as Sandeep Verma, and in the evidence he has categorically stated that his name is Sandeep Verma, but he is putting his signature as Gopal Verma as per the advice of his Guruji for the purpose of his business. Considering the above, this court full stop. Consider the submission made by the counsel for the petitioner, produce the original will, death certificate of the testator, no caveat certificate, and the affidavit of the attesting witness and the evidence of the attesting witness. This court find that the petitioner has proved the will and is entitled to get the probate of the last will and testament. Accordingly, the department is directed to issue probate of the last will and testament dated
6th of April 2007.
6th of April
2007.
On compliance of all formalities. At the time of grant of probate, copy of the will be made as part of the probate.
My lord, order not to be drawn up. Order not to be.
Why?
My lord, that will take.
Nothing will happen. Next.
My lord, I beg to appear, my lord. Kindly allow me to appear virtually.
Yes.
25. My lord.
Yes.
It is grant of probate of last will dated, my lord, 25th March 2015 of the deceased testator. My lord, my lord will find the will from page 12 to 15, and date will find at page 15. Executor's name is appearing page 13, para 1, bottom.
Para 1?
Bottom, page 13.
Priya Basu.
Yes.
Yes. Attesting witness.
My lord, page 15.
Yes. What is the date? March 2015.
Yes, Lord.
The date of the death of the testator
was, my lord, page 11, 4th February 2022.
Where is the legal heirs?
My lord, para 5.
Why?
Citations were issued, my lord. My lord, no caveat certificate has been issued by the department.
Okay. Attesting witness.
My lord, filed affidavit, my lord. And also declaration. Second name, Milan Kumaraj.
Where is the attest? Have you enclosed?
Yes, that affidavit is there, and declaration is there at the foot of the petition. Milan Kumaraj.
Affidavit.
Attesting witness, yes. Milan Kumaraj. Affidavit or attesting witness.
Affidavit attesting witness is not available here.
It must be in file because I have my office copy. Milan Kumaraj, it was affirmed on, my lord, on 12th July 2023.
Yes. Yes. So and so appearing for the petitioner. Petitioner, fully of the petitioner has filed the present application for grant of probate of the last will and testament dated 25th March 2015 of the testator Raja Basu Roy alias R.A. ROI alias R.A.Y. Full stop. Counsel for the petitioner submit that the testator has executed his last will and testament by appointing the petitioner as sole executrix of his last will and testament while possessing good health and fit state of mind in presence of two attesting witnesses. The Testator died on 4th of February 2022, leaving behind his wife, daughter, and son. Full stop. The petitioner submit that as the legal heirs have neither come forward to give affidavit of consent nor have filed their caveat or affidavit in support of caveat, accordingly citations were issued. He submitted that in spite of the issuance of citations, none has come forward to raise any objection for grant of probate, and accordingly the department has submitted no caveat certificate dated 20 January 2025, stating that no caveat has been entered for grant of probate. Full stop. The petitioner submitted out of the two attesting witness, one attesting witness, Mr. Milan Kumar H. Kumar H. alias Milan Kumar H. AICH. देख लेना यार. Has filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executors of his last will and testament. Heard the learned counsel for the petitioner produced the original will, affidavit of no caveat certificate submitted by the department, affidavit of the attesting witness. This court finds that the petitioner has proved the will and entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament dated 25th March 2015 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate.
My lord, since my lord, it is a order of probate, my lord, it not required to be drawn up because my lord, because chapter, my lord, has on earlier occasion I say I have deferred.
Order है ना दोनों में दे दो. The order cannot be. The office is directed. Orders, no order can be drawn up.
Need not to be drawn up. Yes, my lord. Grateful, my lord.
26.
I am appearing for the petition. This is when application was executed for issuance of citation and general citation as well as special citation. That is the pair A and B of the master.
Issuance of citation?
Yes.
None has come forward?
No, none of these.
How many legal heirs?
There are my lord, sons, daughters, PDC's son's wife, granddaughter. So that is at page 3, paragraph 4.
That's all?
Yes.
Sense offering for the petitioner. Counsel for the petition submitted.
Where A and B of the
none of the legal heirs have either come forward to give affidavit of consent or to file caveat and affidavit in support of caveat. Accordingly, he prays for issues of general citation and special citation in terms of prayer A and B of the present application. Accordingly, prayer A and B is allowed.
But there are certain properties which are outside West Bengal. Let there be also.
But you have not filed an application. 283.
Prayer is also there, madam.
But 283, you have to come with an application under 283. 283 subclause 3. Though it is not applicable. Let they come. If they have not come, then we'll pass an order. Because this court is of the opinion, if the legal heirs have coming forward for giving no objection, then the citation is not required on the publication. Correct. And as per the 283, some of the lawyer has brought to the notice that it is not applicable. So if it is so, then I will pass an order for publication of that outside of the jurisdiction. Let this be completed first.
We'll come back there.
Yes, next.
This is my application. My lord kindly takes up the original will, annexure A, page number 11.
हो गया ऑर्डर किया उसमें issuance of citation.
My lord kindly takes up the original will, annexure A, page number 11. Column number 7, my lord.
Sudipto Chandra Roy is the testator. Correct. Where is the name of the executor?
Page number 12, clause 7. I hereby appoint Sri Shomir Kumar Aditya, son of such and such, following
Spelling
him,
Dipanko.
Dipankar.
Who has filed the Dipankar file?
Yes, my lord.
What about the Samir?
My lord, he died. I have annexed the death certificate.
Okay. When the testator died?
1st of January 2019.
1st January 2019. So
And after next page, Shomir Kumar Aditya, 3rd of December 2020.
3rd December 2020
Yes,
he
ma'am.
died.
Yes, ma'am.
Then he filed.
Yes,
How
ma'am.
many legal years? 3.
My lord, page number 4. The wife of the deceased, daughter of the deceased, and two daughters of the deceased.
They have not come forward.
No, my lord.
No caveat certificate.
Yes, my lord, that has been issued in the month of November. And my lord, the affidavit of attesting witness, which has been affirmed on
What is the name of the attesting witness?
Somorde, Mr. Somorde. First attesting witness.
Summer day.
Yes, my lord.
19 October. Yes. That's all.
Yes, ma'am.
So suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 19th October 2012, executed by the testator Sudipto Chandra Ray. Counsel for the petition submitted. The testator has appointed Sri Samir Aditya as executor, failing which SAMIR Samir Aditya, failing which Sri Dipankar Datto, DATT. Counsel for the petition submitted. The testator died on 1st January 2019 and the first executor, namely Samir Kumar Aditya, died on 3rd December 2020, and thus the petitioner has filed the present application for grant of probate. Counsel for the petitioner submitted. The testator died leaving behind his wife and 2 daughters, but none has come forward either to give consent or to file caveat or affidavit in support of caveat. Accordingly, citations were issued. In spite of issuance of citation, none has come forward to raise any objection. And accordingly, the department has submitted no caveat certificate dated 11th of December 2024, stating that no caveat has been entered against the grant of title. Full stop. Counsel for the petition submitted. One of the attesting witness, namely Summer Day, Summer Day, has filed his affidavit stating that the testator has executed his last will and testament on 19th October 2012 in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as executor of his last will and testament. Consider the submission made by the counsel for the petitioner, peruse the original will, death certificate of the testator, death certificate of the first executor, no caveat certificate of the department, and the affidavit of the attesting witness. This court find that in spite of issuance of special citations, none has come forward to raise any objection, and accordingly, the department has submitted no caveat certificate. In the affidavit, the attesting witness categorically stated that the testator has executed his last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executor as the executor of the will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Subpara. The department is directed to issue probate to the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number 27 is disposed of.
I'm grateful.
Before rising, my lord, I have mentioned this matter, my lord, with the probate petition. If I have told by my lord's officer, the matter has, in the website report, it has been shown as disposed of, but it is awaiting for final order. My lord.
This is the order of coordinate bench where the citation, issuance of citation were issued. And the report is also on the next page where it is shown as disposed of. Let this matter. Yes, ma'am. Let this matter appear.
Let me have your
File is lying before you.
item number 17 of the commercial list. The interim order is expiring today.
Come and send the junior. I will
My lord.
after at
My
the
lord,
time rising.
he will be there.
Yes, no problem.
And affidavit of service, he will be.
Yes, call the matter.
Lordship, in a compelling situation, I'm seeking leave to file an urgent matter, Lordship. In a compelling situation, Lordship, I'm seeking leave to file an
What is
urgent
the
matter.
compelling
Lordship.
circumstances?
Situation is that, Lordship, the petitioner is the elected member of a Gram Panchayat, Lordship.
Ah.
Lordship, the meeting was held on 9th, Lordship. The Lordship, a budget was proposed by
Meeting
the
was
Pradhan,
held?
Lordship. One meeting, a general meeting was held, Lordship, on 9th. Last in this month, Lordship. There, Lordship, the Pradhan of that particular Panchayat, Lordship, proposed a planning, Lordship, next year planning, Lordship. Thereafter, Lordship, on that planning, on that meetings, the Pradhan failed to obtain the majority, Lordship. However, Lordship, subsequently, the others member, Lordship, they also proposed the same planning, Lordship. That was accepted, but that was not duly uploaded to the Lordship website, and that was not endorsed by the authority concerned, Lordship. Thereafter, Lordship, Pradhan, Lordship,
So
now
what is the
their
urgency?
urgency is that, Lordship. Now, Lordship, they have decided, the Pradhan decided to conduct further meeting on 29th, Lordship. There, Lordship, on that meeting, there are some situations, Lordship, where that some members will not be able to present there for their personal difficulties. Now, Lordship, since one bill has one plan has already been passed, Lordship. Now the Pradhans wanted to, Lordship, to revise the entire things by, Lordship, superseding the previous meeting, Lordship. And that plan, Lordship, where the Pradhan wanted to, Lordship, they make a plan, Lordship, in favor of, Lordship, they decided to give some work, Lordship, to in favor of their favorable person, Lordship. That is the situation. Kindly, Lordship, the meeting is, Lordship, on the 29th. Panchayat determination, Lordship, it is urgent determination is given to your Lordship.
So fine.
Since, Lordship, meeting is on the 29th, Lordship. Since, Lordship, if I file the matter, Lordship, the matter will be, Lordship, come after 29th, Lordship. So since, Lordship, the matter will become infractuous.
27, 28 कोई खाली है? कुछ 11:30 देखो. हैं? Fix. 3:45 भी नहीं है. If I allow also, it is not possible for me to this court to take the matter.
Kindly, Lordship, since, Lordship, the matter will become infractuous. So therefore, Lordship, that will not take much time, Lordship. Kindly, Lordship, since consider, Lordship.
Okay, allow leave is granted to file and the list on 28.
Grateful, Lordship.
As motion, as new motion.
Matter fixed at 2 p.m. at the number 2 of the non-commercial list.
May it please, my lord. I appear for the.
Yes.
I appear for the executor in this matter, my lord. Lord, on the last occasion, if my lord remembers, my lord had asked me to prove this will in
Yes,
solemn
witness
form.
present.
Yes, witness present. The only issue, my lord, here is, my lord, that the will has been filed on the with the certified copy, not the original.
আপনি কি ভাষায় কথা বলছেন? আজকে প্রথমবার সাক্ষ্য দিতে আসছেন নাই, কে বলবেন? বলুন। আমি শপথপূর্বক বলছি।
আমি শপথপূর্বক বলছি।
এই মামলায় সাক্ষ্য দিতে এসে আমি যা বলবো সত্য বলবো।
যা বলবো সত্য বলিব।
সত্য বই মিথ্যে বলবো না।
সত্য বলি মিথ্যে বলিব না।
কোনো কথা গোপন করব না।
কোনো কথা গোপন করব না।
আপনার নাম?
অশোক সরকার।
অশোক সরকার। ASHOK অশোক সরকার। বাবার নাম?
ফণীভূষণ সরকার।
ফণীভূষণ সরকার। ফণীভূষণ বানানটা ইংরেজিতে বলুন।
PHI
SAN ভূষণ সরকার। আপনার বয়স?
আমার এখন বয়স হচ্ছে 64।
64 ইয়ার্স। কি করেন আপনি?
আমি কিছু না, বেকার। বেকার।
আনএমপ্লয়েড। আর কোথায় থাকেন? বাড়ির ঠিকানা আস্তে আস্তে বলুন।
আমি নেতাজি নগরে থাকি, টালিগঞ্জ।
নেতাজি নগর, টলিগঞ্জ।
4/1 বাড়ির ঠিকানা।
4/1 নেতাজি নগর, টলিগঞ্জ। কলকাতা কত?
40।
ইয়েস স্যার। ইয়েস। আস্তে আস্তে বলবেন। ছোট ছোট করে।
Mr. Sarkar, who was Pushpa Guha?
পুষ্পা গুহ কে ছিলেন?
উনি আমার পাশের বাড়ি দিদি একজন।
She was an elderly sister who used to stay beside my house.
Are you aware whether Pushpa Guho is alive or dead?
আপনি কি জানেন পুষ্পা গুহ এখন জীবিত আছেন না মারা গেছেন?
মারা গেছেন।
He has died.
Are you aware of the date of death of late Pushpa Guha?
আপনি কি জানেন পুষ্পা গুহ কত তারিখে মারা গেছেন বা প্রয়াত হয়েছিলেন?
উনি মারা গেছেন হচ্ছে 29শে জানুয়ারি
সাল
22।
She died on 29th January 2022.
Shown an original document to the witness. Mr. Sarkar, what is this document?
এই ডকুমেন্টটা কি দেখুন এবং মাই লর্ডকে বলুন।
ডেথ সার্টিফিকেট।
This is a death certificate. কার?
এটা পুষ্প গুহ।
Of Pushpa Guho.
Will you be able to tell the date as provided in the date of death as provided in the death certificate?
এই সার্টিফিকেটে মৃত্যুর তারিখ যেটা লেখা আছে আপনি দেখে বলতে পারবেন?
মৃত্যু তো মারা গেছেন।
I have not brought my spectacles with me.
Acha. Should I tell? It's written already, has confirmed already.
Whose death certificate?
The testatrix.
Ask.
Please tell my lord. Please tell my lord whose death certificate is this?
কার মৃত্যুর প্রমাণপত্র বা ডেথ সার্টিফিকেট এটা?
বলেছে? ঠিক আছে আবার
বলনি।
who has obtained হ্যাঁ কেটে দিন। Who has obtained this original death certificate?
এটা কে নিয়েছেন এবং কে নিয়েছেন?
এটা নিয়েছেন ওনার রিলেটিভ রাজেন্দ্র প্রসাদ।
This death certificate was obtained by one of her relative, namely Rajendra Prasad. Sir. প্রসাদ। উনি যেটা বলেছেন ওটাই যাবে।
Yes, then.
ওদেরকে বাইরে যেতে বলুন তো। আচ্ছা, from where was this original death certificate obtained?
এই অরিজিনাল ডেথ সার্টিফিকেটটা কোথা থেকে তোলা হয়েছে?
এটা মিউনিসিপাল কর্পোরেশন থেকে।
কোন মিউনিসিপাল কর্পোরেশন বলুন?
এটা হচ্ছে এই যে আপনার ধর্মতলায় যেটা।
From the municipal corporation.
Original death certificate was obtained from the municipal corporation situated at Dharmatala. Dharmatala.
Lord, may this document be marked as Exhibit A.
Exhibit A.
Exhibit A. Mr. Acha.
Yes.
Mr. Sarkar, are you aware as to whether Pushpa Guho was married or not?
আচ্ছা, আপনি কি জানেন যে পুষ্পা গুহ, যিনি প্রয়াত পুষ্পা গুহ, উনি বিবাহিতা ছিলেন না আপনি জানেন?
বিবাহিত ছিলেন।
She was married.
What is the name of her husband?
তার স্বামীর নাম কি ছিল?
স্বামীর নাম হচ্ছে বিশ্বনাথ গুহ।
The name of her husband was Vishwanath Guho.
Are you aware whether he is alive or dead?
উনি বেঁচে আছেন? ওনার স্বামী বেঁচে আছেন?
না, স্বামী
No, he is not alive.
Will you be able to provide the date of death of Mr. Vishwanath Guha?
বিশ্বনাথ গুহ কত তারিখে মারা গেছেন আপনি বলতে পারবেন?
25শে ডিসেম্বর
25th December সাল
2022।
2022.
না 22 না 10।
2010.
হ্যাঁ।
25th December 2010.
Shown an original document to the witness. What is this document?
এই ডকুমেন্টটা কি মাই লর্ডকে বলুন। This is the death certificate. Card death certificate.
এটা বিশ্বনাথ
Of Vishwanath Guho.
Can you tell my lord from whom? Can you tell my lord who has obtained the original of this death certificate?
এই অরিজিনাল ডেথ সার্টিফিকেটটা কে তুলেছেন বলতে পারবেন?
উনি ওই রাজেন্দ্র বাবু তুলেছেন।
This original death certificate was obtained by Mr. Rajendra Prasad.
From where was it obtained?
কোথা থেকে এটা তোলা হয়েছে?
ওই আমাদের প্ল্যানেটের যেটা কর্পোরেশন হেড অফিস।
From the corporation head office situated at Esplanade. Situated at Esplanade.
Lord, may this document be marked as Exhibit B.
Exhibit B.
Exhibit B.
আপনার কাছে দাদা?
কার কাছে?
আপনাদের কাছে উইলের সার্টিফাইড কপিটা দিন।
He is the petitioner.
He is the attesting witness. Shown a certified copy of to the witness. What is this document?
এই ডকুমেন্টটা কি মাই লর্ডকে বলুন। এটা কি ডকুমেন্ট বলুন?
এটা এটা হচ্ছে কপি, হচ্ছে দলিলের কপি।
This is the copy of a deed.
Shown page 5. No, page 5, no, page 6 of this certified copy.
এটা কি?
Ha. Mr. Sarkar, are you in a position to identify the signatures appearing at page 6 of this document?
আচ্ছা 6 নম্বর পাতায় যে সমস্ত সইগুলো আছে আপনি কি বলতে পারবেন কার কার সই? Yes, I can identify. বলুন কার কার সই।
এটা হচ্ছে পুষ্পগড়।
At the right side there is a signature of Mrs. Pushpa Guho.
এটা হচ্ছে আমার অশোক সরকার।
At the left hand side the first signature is of mine. The first signature is of mine, that is Ashok Sarkar.
আমার ওয়াইফ রুমা সরকার।
The next signature is of my wife, namely Mrs. Ruma Sarkar. Ruma.
যে উকিল এটা করেছে চন্দন।
And there is also a signature of the advocate, namely নাম কি বলুন? Namely Mr. Chandan Kumar Saha.
Can you identify the date provided in this document?
এই ডকুমেন্টে যে তারিখটা দেওয়া আছে সেটা কি আপনি বলতে পারবেন কত তারিখ?
বাইশ 2014।
22/2014. 22nd January 2014.
Mr. Sarkar, please tell my lord, how were you able to identify the signature of Pushpa Guha?
পুষ্পা গুহর সিগনেচার সই আপনি কিভাবে চেনেন?
এর আগে ওনাকে এই সইটা করতে দেখি।
I have seen her signing in front of me on various occasions previously.
Did Pushpa Guha signed in your presence at page 6 of this document?
এই যে 6 নম্বর পাতায় পুষ্প গুহ সিগনেচার করেছেন, সই করেছেন, এটা কি আপনার সামনে আপনার উপস্থিতিতে করেছেন? Yes.
Will you be able are you in a position to tell my lord where was this document signed?
আপনি কি বলতে পারবেন যে এই ডকুমেন্টে যে সই করা হয়েছিল কোথায় করা হয়েছিল?
এই চন্দন সাহার বাড়িতে।
At the house of the advocate, namely Mr. Chandan Kumar Saha.
Are you in a position to tell my lord as to whether this will was registered or not?
এই উইলটা কি নিবন্ধীকরণ বা রেজিস্টার করা হয়েছিল না করা হয়নি জানেন আপনি বলতে পারবেন?
এটা
এই উইলটা কি রেজিস্ট্রি করা হয়েছিল? রেজিস্ট্রি করা উইল এটা? Yes.
Where is the original of this registered will?
এই রেজিস্টার্ড উইলের অরিজিনালটা কোথায়? আসল
অরিজিনালটা হারিয়ে গেছে।
The original has been misplaced.
Was any step taken after the original will was lost.
Mr. Alim,
Yes, my lord.
how the attesting witness will say with regard to the original will?
My lord, because in his affidavit, because my lord, this PLA was signed, was filed, my lord, with his affidavit. That is why.
Maybe. That's why I have gone through that. That's why you are not allowed the order. How he can only concern with the signing execution.
Very well,
of
my
the
lord. In
deed.
that case. No. Last question ta শুধু কেটে দিন যে was any step taken? My lord, in that case, my lord, let the certified copy be marked as Exhibit C, my lord, because he has identified the signatures of the persons who have signed. My lord, let that document be marked as Exhibit. My lord, in that case, my lord, may I call the the executor?
Correct. He is the main person.
Yes.
He has to explain.
Very well, my lord. Puro document.
Will is marked as Exhibit C.
C.
Exhibit C, comma, signature of the testatrix is marked Exhibit C by 1. Only one signature of the testatrix are there.
Yes.
And the signature of this witness is marked as Exhibit C by 2. And the signature of the another attesting witness is marked as Exhibit C by 3.
আপনার আর আপনার ওয়াইফের সিগনেচার গুলোকে গোল করুন। Testatrix by 1.
If you all persons will be in the district judiciary, nobody will be able to prove the will.
Yes.
Very tough.
By 3.
You are get the benefit in the original side. If in the district court,
yes, Lord, I have faced.
Each and everything has to be proved.
I have faced, Lord.
Even not the leading question. That the questions which you or persons are putting, that is not the way to put the question to the witness on dock.
Yes, Lord. Lord, in that case, Lord, may he be discharged. May I call the testator?
That's all?
Yes, Lord. The executor is also there.
He was remain in the courtroom.
No, Lord, he can leave.
He was remain in the courtroom.
He was there. Lord, he was there at that point of time, Lord. I didn't realize, Lord. I thought I should have let him go, but
this cannot.
Lord, there's only one test executor. I'm very sorry.
But not. It is not a good practice.
I thought that he will not give evidence, but then later on I realized that is why. If my Lord wants, then I can do it.
বলুন। আমি শপথপূর্বক বলছি এই মামলায় সাক্ষ্য দিতে এসে আমি যা বলবো সত্য বলবো সত্য বই মিথ্যে বলবো না কোনো কথা গোপন করবো না। আপনার নাম?
আমার নাম ডক্টর রাজেন্দ্র মিত্র।
ডক্টর রাজেন্দ্র মিত্র। বাবার নাম?
লেট দিলীপ কুমার মিত্র।
দিলীপ কুমার মিত্র। আপনার রাজেন্দ্র মিত্র, দিলীপ কুমার মিত্র। আপনার বয়স?
বয়স 52।
52। কি করেন আপনি?
বাই প্রফেশন ডাক্তার।
আমি ডক্টর বাই প্রফেশন ডক্টর। আর আপনার বাড়ির ঠিকানা বলুন ধীরে।
B/12/1
B/12/1
কাটজুনগর। KATJU
কাটজুনগর বলুন।
যাদবপুর, কলকাতা 32।
যাদবপুর, কলকাতা 32। Yes, sir.
Mr. Mitra, how are you related to late Pushpa Guho?
প্রয়াত পুষ্পা গুহর সঙ্গে আপনি কিভাবে সম্পর্কিত?
উনি আমার বড় শালী।
She is my elder sister in law. ব্র্যাকেটে লিখে দাও, wife's elder sister.
Probate petition টা দিন।
বোঝা যাবে না, বৌদিও তো সিস্টার in law না।
Probate petition. Probate petition.
Wife's elder sister, বউয়ের বড় বোন।
Mr. Mitra, who has filed the instant probate application for grant of probate before this honorable court?
প্রবেটের জন্য আবেদন কে করেছেন?
আমি করেছিলাম।
I have filed.
Will you be in a position to tell my lord?
এক্সিকিউটিভ
Will you be in a position to tell my lord? Was the probate application filed with the original will?
প্রবেটের জন্য যে আবেদন করেছিলেন এটা কি অরিজিনাল উইলের সঙ্গে করেছিলেন? অরিজিনাল উইল দিয়ে?
অরিজিনাল উইল তো মিসিং হয়ে গেছে।
No, the original will was misplaced.
What steps did you take after the loss, after the misplace of the original will?
অরিজিনাল উইলটা হারিয়ে যাওয়ার পর আপনি কি পদক্ষেপ নিয়েছিলেন?
আমি একটা যাদবপুর থানায় একটা জিডি করেছিলাম, করে তার সার্টিফাইড কপি বার করেছিলাম।
I filed a GD, general diary, at Jadavpur police station, and after that I obtained a certified copy of that will.
Shown a document to the witness. Please tell my lord what is this document?
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন যে এটা কি কি ব্যাপার এই ডকুমেন্টটা।
এটাই আমি ওই যে জিডিটা করেছিলাম, এটা সেটার সংক্রান্তই যাদবপুর থানাকে করা হয়েছে।
This is the copy of the GD that was filed by me at Jadavpur police station. Yes.
When was this GD made? Made.
কখন করা হয়েছিল এই জিডিটা?
13/7/2023।
The GD was made on 13th July 2023.
20?
Was this GD received by the Jadavpur police station?
যাদবপুর পুলিশ স্টেশনে কি এই জিডিটা নিয়েছিল?
নিয়ে একটা কপি আমায় দিয়েছে।
Yes, they took the GD and they given me a copy of that. They gave me a copy of it.
Where is the copy of that GD?
ওই কপিটা কোথায় জিডির?
ফাইলে আছে।
কোথায় আছে বলুন?
মনে হয় এর ফাইলেতেই রাখা আছে মনে হয়।
I guess the copy of the GD is in the file.
After submitting this GD, did you personally obtain the certified copy from the registrar?
আপনি জিডিটা করার পর আপনি কি নিজের থেকেই ওই রেজিস্ট্রারের কাছ থেকে সার্টিফাইড কপিটা তুলেছিলেন উইলের? Yes.
My lord, may this letter be marked as an exhibit, my lord. The original is with the records of the court, my lord, I am told. But I have to. Petition is it's along with the petition.
That copy, you give that copy.
Petition नहीं. It's not there in the records. I'll put another question. About ওই যে চিঠিটা Xerox আছে Xerox. Is this the photocopy of the copy which was given to you by the Jadavpur police station after acknowledgement?
এটা কি সেই যাদবপুর থানা থেকে আপনাকে যেটা জিডি পেয়ে ওরা যেটা দিয়েছিল তার জেরক্স কপি বা ফটোকপি এটা? Yes.
My lord, now may this be marked as exhibit, my lord, subject to objection. Or my lord, may this be marked as an exhibit, my lord.
Where is the original?
The original, my lord, I am being told.
Original will you misplaced, original complaint you misplaced.
Lord, I am being told, my lord, that without that
And
copy
second thing you give that.
একটা copy দিন তো.
Give the probate application. When you file the probate application.
The probate application was filed on 14th day of November 2022.
Then, and this is 2023 after
Yes.
the filing of the. What question you have put?
No, I haven't asked that before. Very
You
well.
put the
Lord,
question.
may I ask him another question? If my lord
No,
permits.
no,
Very well, I
because
shall ask.
You put the question at the time of filing of the application. The original will was not there. I made a complaint. But the complaint is 23, file the case in 22.
22.
Please mind, this is a probate matter, sir.
Yes, Lord. Lord, I believe this will be a issuance of my lord addressing the court, my lord, because I don't want to address this in front of the witness. If my lord permits, my lord, then may this document be marked, my lord.
Where is the original? You have to prove the
The original is, my lord, I am being told is with the record because they have to file it with the court. If
It's
the
not in your-
same is filed with the certified copy. No, original টা কোথায়? Police station letter টা? Original? Where is the receipt copy? That original receipt copy. But I don't know whether it's there in the records. I'm being told, my lord, it's in the records.
Then the record the.
एक बार
Give the record. It cannot be because you filed 2022. This
subsequently
is
it
23.
was
So
subsequently
how
it was
you
given.
can file here?
Original টা? But subject to correction, but there will be a letter which will be addressed to the registrar insolvency.
Huh? Citation. Not there.
Not there. But I'll ask one more question, it will cover
Yes,
that part.
yes.
Probate petition টা দিন তো ওনাকে। Shown certified copy, shown exhibit A. No, sorry, acha, exhibit
There is
C,
the death
exhibit C,
certificate.
exhibit C.
Yes.
Mr. Mitra, is this the certified copy which of the will which you had deposed earlier?
এটাই কি সেই উইলের সার্টিফাইড কপি যেটার ব্যাপারে আপনি বললেন? Yes.
Will you be in a position to tell my lord when was this certified copy issued?
এই সার্টিফাইড কপিটা কখন বা কবে ইস্যু করা হয়েছে আপনি কি বলতে পারবেন?
6/4/2022
The certified copy was issued on 6th April 2022. 22
Did you file this instant application for grant of probate with this certified copy? It is there. With this certified copy?
এই সার্টিফাইড কপিটা নিয়ে কি আপনি উইলের প্রবেটের জন্য অ্যাপ্লিকেশন করেছিলেন?
হ্যাঁ।
Yes.
Yes. ঠিক আছে, এবার ওটা সরিয়ে দিন, এটা দেখিয়ে দিন। Please encircle the endorsement by the Jadavpur police station.
Please, to court. This is the original document which you have filed before the police authority.
এটাই কি সেই অরিজিনাল ডকুমেন্ট যেটা আপনি পুলিশ অথরিটিকে দিয়ে দিয়েছেন?
হ্যাঁ হ্যাঁ হ্যাঁ।
Yes.
Is the document contain the seal and signature of the concerned police office, police station?
পুলিশ স্টেশনের কারোর রিপ্রেজেন্টেটিভের মানে সই বা সিল কিছু আছে এখানটাতে ডকুমেন্ট? ইয়েস।
Is the document contains your signature?
আপনার সই আছে ডকুমেন্টে? ইয়েস।
Then encircle the signature.
Kindly encircle the same.
ওনার সইটা?
ওনার সই and
আচ্ছা,
his signature.
আপনার সইটা এনসার্কেল করুন লাল দিয়ে স্যার। The witness encircled his signature appearing on the said document.
Yes. Now, my lord, may this document be marked as exhibit. It will be exhibit D.
This is the way to put
Yes,
the question.
I didn't had the original, that is.
Exhibit D. Signature exhibit D by 1.
Now, my lord, if my lord, yes, my lord wants, my lord, I can address.
Yes.
Yes, my lord. Yes. My lord, may the witness be discharged.
You will argue that today?
Yes, yes.
Better accept dictation. Yes, give the file. Yes.
Yes, my lord. My lord, application for grant of probate of the last will dated 22nd of January 2014.
What is the name of the testator?
Pushpa Guho. Testatrix.
Testatrix.
Testatrix Pushpa Guho. Application, my lord, for grant of probate of the last
Pushpa
PUS
Guha.
Yes, my lord. PUSPA GUHA Guha.
GUHA Guha.
Yes, my lord.
Yes. Where is the name of the executor?
Lord, executor, your lordship will find. I have there's a Bengali version and Lord English version. I'll be relying upon
English.
Yes,
Come to the English version.
Lord, at page 6, your lordship will find in the brackets in bracket it's written page -6. I do appoint Dr. Rajendra Mitra, husband of my younger sister, the executor to this will.
Page 6.
Page 6. Your lordship will be like this, my lord. Page 6 will be written here.
What is the paragraph?
This is not numbered.
I appoint Dr.
Rajendra Mitra, husband of my younger sister, the executor of this will. After death, the executor will obtain.
What is the date of that will?
22nd of January 2014. That your lordship will find at it's written in Bengali vernacular at page 6 of the Bengali vernacular.
22nd January
2014.
2014.
Yes, Lord.
Okay. What is the date of the death of?
The date of death of Mrs. Pushpa Guha was on 29th of January 2022.
Where is that?
But that's annexure A to this petition.
Pushpa Guha 29 January.
Yes, Lord, this is exhibit A. Yes, Lord, this is exhibit A. Lord, husband of the Pushpa Guha had predeceased her. That was on 25th of December 2010.
Predeceased.
Yes, my lord. That's the last.
How many legal heirs?
My lord, there is no legal heir. We have pleaded in paragraph
5. 2 legal heirs.
Your lordship may kindly sees.
2 legal heirs. Kindly come to the page 3, paragraph 5.
Yes, my lord. Kindly sees paragraph 5.
Yes.
Yes, my lord. No one has given consent.
Correct.
My lord, citations were issued. No affidavits were forthcoming in support of caveat, my lord. No one has filed any caveat and no affidavit in support of caveat was made.
No caveat.
Citation and order.
Yes. Then.
Yes, my lord. Now, my lord, I have in paragraph number.
Where is the attesting witness?
Yes, my lord. Attesting witness is there separately. Mr. Ashok Sarkar has given. He came and deposed also before my lord.
Ashok Sarkar.
Yes, my lord. The attesting witness, he came and deposed before my lord.
Today appeared, no?
Yes, my lord.
Okay.
The first witness, PW1.
That's all.
Yes, my lord. And my lord, only one thing I'd like to point, my lord, that in paragraph 3, I have pointed that the original will was lost and this certified copy and this was filed on the basis of certified copy. Only, my lord, one thing. Your lordship's query was, my lord, that in 2022 you had filed in 2023. The certified copy was issued prior to filing. Only this was the fact, my lord, I wanted to mention.
Since appearing for the petitioner. Petitioner, 2 witnesses are present. No, petitioner has examined 2 witnesses. Witness number 1, namely
Ashok Sarkar.
Ashok Sarkar is the attesting witness of the will. During his evidence, he has identified the certified copy of the original will, as well as signature of the testator, as well as his signature and signature of the other attesting witness. The will is marked as Exhibit A, signature of Exhibit C. Exhibit C, signature of the testator. Testatrix.
The
signature of the testatrix is marked Exhibit C by 1. Witness of this witness C by 2, and the attesting witness C by 2, and signature of the another attesting witness is marked as Exhibit C by 3. Full stop. Full stop. He has also produced the death certificate of the testator and testatrix and her husband. Both were marked as Exhibit A and Exhibit B. Full stop. Another witness is the PW2, namely Dr. Rajendra Mitra,
who is the executor.
Rajendra Mitra, who is the executor of the will, last will and testament, dated 22nd January 2014.
2014.
14. Full stop. During his evidence, he has identified the original will, and he has stated that the original will is misplaced, and he has applied for the certified copy of the said will, which is enclosed with the present application. He also submitted that he has made complaint to the police authority, that is the police of
Jadavpur.
Where is that?
Let the original just now handed.
Fine. He has made a complaint to the police authority, that is the officer in charge, Jadavpur Police Station, and accordingly a GDE number 887 dated 13th July 2023 was recorded. Full stop. Both the witnesses have been examined and discharged. The petitioner says that he will not examine any further witness. Accordingly, evidence on the side of the evidence of the petition is closed. Full stop. Counsel for the petitioner submit that the testatrix has executed her last will and testament on 22nd of January 2014 in presence of two witnesses, by appointing the petitioner as sole executor of her last will, her last will and testament. Full stop. He submit that the husband of the testatrix was the predeceased to the testatrix, who died on 25th of December 2014, and testatrix died on.
Her husband died in 2010.
Testatrix died on
29th January
2022, leaving behind two legal heirs, but none of the legal heirs either come forward to give consent or to file caveat and affidavit in support of caveat. Accordingly, citations were issued. In spite of issuance of citations, none has come forward to raise any objection for grant of probate. The department has submitted no caveat certificate dated 2nd December 2024, certifying that no caveat has been entered against the grant of probate of the last will and testament. Full stop. Counsel for the petition submitted the petition has proved the will and is entitled to get the probate of the last will and testament of the testatrix Puspa Gu. Heard the learned counsel for the petitioner. Original will is misplaced, and the petitioner is relying upon the certified copy of the will. To prove the will, the petitioner has examined the attesting witness, one of the attesting witness, and the attesting witness has categorically stated that the testator has executed his last will and testament in his presence, testatrix, in his presence and in presence of another attesting witness. The attesting witness has identified the will as well as the signature of the testatrix and the signature, his signature, as well as the signature of the another attesting witness. The executor in his evidence has stated that the original will was misplaced and he has obtained certified copy of the will as the will of the testator, as the last will and testament of the testatrix was the registered will. Full stop. He has identified the certified copy of the said will, and he has also stated he has also identified the complaint made to the police authority with regard to the loss of the original will. The said complaint is also been marked as Exhibit D. Exhibit D. Full stop. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament to the petitioner. Last will and testament dated 22nd January 2014 on compliance of all formalities. At the time of grant of probate, the certified copy of the will be made part of the copy of part of the probate. PLA number so disposed of.
So just one fact, my lord. My lord, apart from this legal as mentioned, my lord, one Gautam Das had filed a caveat which was discharged.
Discharge.
So I just wanted.
Counsel for the petitioner, during his argument, has brought to the notice that one person, namely
Gautam Das, not there as provided in the
Gautam Das had appeared and filed caveat. Subsequently, by an order dated 12th of April 2024, the caveat and the Mr. Gautam Das has been discharged as caveat.
Yes, sir. Extremely grateful, Lord.
Yes, next.
In this matter, Mr. I'm approving for the respondent, my lord. My lord, I'm humbly praying that the matter kindly takes it up on Monday, my lord, because Mr. Gupta, my lord, because of personal difficulty, is unable to attend.
Today.
Deeply obliged, my lord.
My lord, I appeared in item number 16, my lord.
Yes.
Seeking leave to appear online.
Yes.
My lord, this is that matter where, my lord, the defendants were sought to be evicted by the plaintiffs, my lord. The first GA was presently being moved by Mr. Banerjee.
I'm there, my lord. I'm there.
Yes.
My lord, I have filed an GA application wherein I have said that till the suit, they are paying a rent per month. Occupational charge, they are depositing with us. We have taken another application saying that that should be in a market rate, they should deposit to us. And they have filed their objection where they have said they have filed two different suits in the City Civil Court at Calcutta, and where they have challenged their, first we initiated the proceedings under TP Act, Public Premises Occupancy Act, PP Act. Once we initiated that proceedings, he challenged that before the City Civil Court at Calcutta. Then we are contesting there. We have taken 2 points that the Civil Court do not have a jurisdiction, it should come to the Commercial Court. Against that, I filed an application and the matter has come up before the High Court in a revisional application, where the stay has been granted. Now, Lordship, with regard to this suit, then when I found that he is challenging my authority under a PP Act, then I simply initiated a notice that you are no more my tenant, because we had no registered agreement between us. For a period, he was my month-to-month basis tenant. So I gave him a notice for eviction, which he did not comply with. And thereafter, I have taken steps for eviction. Suit is filed, written statements are also given. I filed an application for appointment of a receiver to find out what should be the occupational charge till disposal of the suit. They are depositing, they have admitted that they are depositing the earlier rate at which he was given. So, Lordship, we gave him that rent a long back. So, the rent is not up to the market rate. So, I just wanted that today he should make payment in terms of the market rate instead of the ask-while rate. This is the small issue in GA1. Now, if your lordship kindly takes up their opposition first. If your lordship kindly takes up their opposition.
Mr. Banerjee.
Yes, lordship.
You filed the suit for eviction.
Yes, lordship.
Correct. And
Yes.
as said, they are making the payment either occupational charges or monthly rent, whatever it is, as per the old rate. Correct.
Lordship.
Now the suit is at the stage of framing of issues.
Lordship.
And in the suit, you might have been paid for the mean profit also.
Lordship. Lordship.
So what the rent they're depositing what is the present market rate, that will be decided in the main profit. If you got the decree, then the inquiry is to be conducted with regard to the main profit. In that,
yes.
At this stage, what I propose, suppose subject to correction by both of you, let the suit be proceeded. And
yes, lordship. Yes. Lordship, there was a direction of your lordship in the suit event.
Now, today the receiver is appointed, then he will proceed. When let the suit be proceeded. If you are entitled to get a decree, then automatically you will get a decree for the main profit, or the officer will be appointed for ascertain the main profit with regard to the market rate.
I'm grateful to you, Lord.
Let the GA1 be kept pending, and it will be decided along with the suit.
Right. In the suit, lordship, there is a direction. So there is a direction in the suit for filing of judge's brief of document.
Today speaks for framing of issues. Whether
lordship suggested issue.
Kindly keeps it the next day, then we can give both of us. We can give the suggested.
We can lordship can keep it on Monday or Tuesday. Then we can give the suggested issue.
Yeah, come with the suggested issues, but the matter can be proceeded.
Yes, we can do that. We can do that.
You will adduce only one witness. They will adduce whatever evidence. Then the case can be proceeded. That will
yes, sir. Yes, certainly.
Is there any other applications are pending? No, only one.
No, lordship. This is the only application.
So appearing for the plaintiff. So appearing for the defendant. It is fine from the record. The suit is fixed today. Suit is fixed for framing of issues. The plaintiff has also filed an application being GA1 of 2022, praying for what is the GA1? Interim order.
GA1 is the application which I am talking about.
You are also paid for an interim order.
Yes.
What about the interim order?
Lordship, interim order is only
there is really no scope of any interim order here, my lord. I would be arguing that, but
lordship, money was the main concern, and second concern, he should not part with the possession with any third party.
Interim order.
No, where is that?
As well as for appointment of a special officer, public receiver, for collection of the to ascertain the present market rent of the suit premises in question. Full stop. Considering the prayer made counsel for the plaintiff and considering the prayer made in the application being GA1 of 2022 and the prayer in the suit, it is fine in the suit also, the plaintiff has prayed for main profit till the recovery of the possession. Full stop. This court is of the view the suit is at the stage of framing of issues, and if the plaintiff will get a decree, automatically a special officer can be appointed to ascertain the main profit. Thus the GA number 1 of 2022 be kept pending and will be decided at the time of filing.
May I give another suggestion, lordship?
Yes.
Lordship, instead of keeping it pending, we can lordship can pass an order that they will not alter the nature character of the suit property, and it can be disposed of. That's it.
Where am I doing that?
Well, I know you are not doing, but then
Then
There is no issue of
why will
keeping.
you enjoin interim order? My lord, I oppose to that, my lord.
Since they are in possession, I have no access to the possession inside. What are the internal changes they are making? I am not saying that they are doing, but I have no access to do it.
Honorable Judge is passing an order, Mr. Banerjee.
On fixing another date for framing of issues. In the meantime, the parties will exchange the suggested issues.
My lord, we'll do that.
Let the matter appear on 31st of January 2024 for framing of issues. In the meantime, the parties are directed to exchange their suggested issues.
We'll do that, madam. Very grateful.
Next.
Lordship can give the direction for discovery and inspection meantime, Lordship.
Already there. That
Oh,
already.
I'm deeply.
Yes.
My lord, the next matter also I am appearing. My lord, I appear for the plaintiff in this. My lord, this is, my lord, an order had been passed by my lord in May of 2024, my lord, granting an injunction restraining the respondent number 1 from withdrawing money from the bank accounts that are held in India. My lord, in December 2024, my lord, there was a supplementary affidavit that was filed, my lord, bringing on record 2 other bank accounts that are held, my lord, by the defendants. My lord, service was to be completed, my lord. 13th December was, my lord, the order that was passed.
Yes. So now
My
what
lord,
you want?
My lord, service has been completed to an extent, my lord, because defendants number 2, 3, and 5.
Yes, my lord. Under instruction, my lord, I am appearing for respondent number 2, my lord, in the National Bank. My lord, I am praying for time to file my vokalatnama and competency. My lord, since considering the present situation of Bangladesh, my lord, I am praying for, since issuing visa is also taking a longer time. So, my lord, I am praying for 8 weeks time to file
8 weeks time. So what
Yes,
the
my
suit
lord,
will-
the
where the
bank
suit will
has
go?
to, my
For
lord,
8 weeks?
my lord, bank has to authorize a person to come over Kolkata.
Correct.
And my lord, it is passed through board resolution, and board resolution has to be authenticated by Bangladesh Bank, Foreign Affairs Department, and my the Bangladesh High Commission. So it will take a time. And since Bangladesh government is not issuing visa for coming Kolkata, so my lord, present situation is very complicated for appearing the authorized person. So, my lord, I am praying for a longer time, for 8 weeks time. My
My lord, if my lord grants my lord extends the injunction, my lord, I have no issue, my lord. My lord, however, my lord, if the affidavit of service may be kept on record, my lord. My lord, defendant number 1, the address could not be found, and defendant number 4 is refused.
So suffering for the defendant number 1. And defendant number 2. The plaintiff has filed the affidavit of service. Let the same be kept with the record.
Grateful.
Counsel for the defendant number 2 submit that. She is appearing for the defendant number 2 and requires 8 weeks time to file wakalatnama as the defendant
And my lord, competency. Sorry, my
affidavit wakalatnama and affidavit of competency as the head office of the defendant number 2 is situated at Bangladesh. Full stop. Counsel for the plaintiff prays for submit that the interim order granted earlier is going to be expired today and paid for extension of the interim order.
Grateful.
The submission made by the counsel for the respective parties. The defendant number 2 is the learned advocate appearing for the defendant number 2 is granted leave to file wakalatnama along with the affidavit competency within 6 weeks from date. Full stop. Affidavit and the interim order granted earlier, which is going to be expired today, is extended till 7th of March 2025 or until further order, whichever is
Grateful, my lord.
list the matter on 7th March 2025.
Grateful.
Lordship, I'm for the plaintiff. In a commercial suit, my lord, Lordship has been pleased to allow my order 13A application of the commercial code, and my lord has been pleased to direct the sum indicated there to be deposited before the registrar original site. That order was tested in appeal, and the order was upheld. Only but the amount was directed the 20 lakhs. My lord directed us to ascertain from the registrar whether they have deposited, even if in the terms of your lordship's order and the order of the appeal court. But we have written to the registrar, and my lord, till date, my lord,
they have not deposited in compliance to the order of your lordship or of the appeal court. That report has come. And the first page is the report from the assistant registrar. And lordship.
No amount by way of instrument has been
And
received.
secondly, now, as in the morning I was telling, now is the second track of delaying. They have filed an application seeking, my lord, that the revocation of leave under clause 12, wherein we have ascertained, my lord, no clause 12 leave was, there was a change brief, no clause 12 leave was taken, needed, my lord. So, my lord, the application and last 3 occasions, they are not appearing. My lord, this is the ploy.
Where is the report? When the writ of summons was served?
My lord, that is completed, my lord. Lordship's order will.
So that is what is undefended suit?
Yes, my lord.
So what you want now?
So, my lord, that GA4, my lord, that they have filed, my lord, for revocation of the leave under clause 12, may that be dismissed because they are not appearing and there was, my lord, on the face, there was no leave. Kindly see the suit. There was no leave under clause 12.
An order revoking.
And these are the.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Full stop. Counsel for the plaintiff submit that in spite of the order passed by the Honorable Appellate Court dated 23/12/2024, the defendant has not deposited the amount in terms of the order passed by the Appellate Court.
And Lordship's last order, 6 January 2025.
Full stop. Subsequently, this court also directed the defendant to deposit the amount, but as per the report of the Assistant Registrar Cash Department of original site, it reveals that no amount has been deposited. Full stop. Counsel for the plaintiff submit that instead of depositing the amount in terms of the order passed by this court, which was subsequently modified by the Appellate Court, the defendant, sole defendant,
my lord.
The defendant has filed an application being
GA4 of 2024, GA-COM 4 of
2024, praying for
revocation
an order, praying for revoking of leave under clause 12 of the latest patent, 1865, and for returning of the plaint. Full stop. Counsel for the plaintiff, though none appears on behalf of the defendant, and none moves the application filed by the defendant, but learned counsel for the plaintiff has drawn the attention of this court to the prayer made in the plaint and submitted that no leave has been sought for by the plaintiff and no leave was granted by this court. And as such, the application filed by the defendant being GA-COM 4 of 2024 is misconceived. Full stop. Consider the submission made by the counsel for the plaintiff. Peruse the plaint. The plaintiff has made the following prayer in the plaint. This paragraph, page 9. Okay. Full stop. On 16th of October 2023, the plaintiff has presented the plaint before this court. Presented the plaint before the London Master, and London Master has admitted the plaint by passing the following order: semicolon, inward comma. Plaint is presented and admitted subject to scrutiny by the department. Full stop. Neither in the prayer portion of the plaint nor the order passed by the London Master any leave was granted to the plaintiff under clause 12 of the latest patent, and as such, question of revocation of leave does not arise. Full stop. Considering the above, this court find that the GA-COM 4 of 2024 filed by the defendant is misconceived. Accordingly, the same is dismissed.
May there be the direction on next occasion for preparing and filing judge's brief of document?
Full stop.
And
they filed the written statement?
No, that was closed long back. That is admitted position.
Full stop. The summary judgment you filed, what has happened to that? Chapter 13.
Yes, yes.
Plaintiff has filed an application.
And there, my lord, had directed the sum to be deposited, which they have not yet.
Not
my lord.
deposited. So you want to prove the, and you take a full stop. As no written statement has been filed, by which order the court is this suit is going in undefended.
But it's long back. Order. Wonderful. But I believe November 18, madam.
Let the affidavit of today when the madam this क्या बोला? No. Full stop. By an order dated 6th of December 2024, this court already dismissed the application filed by the defendant being GA Com 3 of 2024, wherein the defendant had prayed for extension of written statement. Accordingly, chance to file the written statement by the defendant is closed. Full stop. The closed by an order dated 6th of December 2024. Full stop. In view of the above, the plaintiff is directed to file the judge's brief of document within 2 weeks from date. Full stop. File the affidavit of evidence of the plaintiff witness within a week thereafter. Full stop. List the matter on. Give the date for witness action.
March. They are indicating March 12.
Huh? 12th March at 3 p.m. Take this one. Huh?
Yes, ma'am. 12th March.
18th March at 2 p.m.
As your lordship.
Come ready.
Yes, ma'am.
Yes, next. Call the fixed one.
Lordship, I'm appearing on behalf of the appellant. We had concluded our submissions in September, Lordship. The other side has to respond today. We can give a refresher to my lord. I'm led by Ms. Archana Shankar. We can give a refresher for my lord's convenience.
On behalf of Shatrup Chatterjee, Mr. Nandulal Singhania was appearing for the respondents, my lord, but he has returned the brief. And Mr. Shatrup Banerjee has been appointed in this matter. My lord, kindly grant us 2 weeks' time to go through the brief, my lord.
He has already concluded his argument.
No, Lordship. We have concluded our arguments.
On that day, he has completed the
That was a different appeal, Lordship. This is a different appeal, Lordship. That was a different appeal that's going on. This is a different appeal. Lordship, they have been taking time since September for even in fixed matters, Lordship.
Yes, you are appearing.
My lord, Mr. Shatrup Banerjee is appearing in this matter.
Okay, I am adjourning the matter subject to payment of cost. Because September they have completed their argument. Subsequently, that's why Mr. Singhania is not appearing. Because time and again they are taking time.
My lord, and
today is the specially fixed matter, and you know, whether you know or not this practice of this court. If the fixed matter is praying for adjournment, then the cost is to be awarded. That is a simpliciter theory of this court.
Kindly adjourn the matter for this day only, my lord.
Okay, 20,000. You say how much time you want, I will give, the meter will be increased. It is up to you. You want 1 year, I will give 1 year. And that is then.
You want just instructed me to.
Yes.
Mr. Banerjee instructed me to ask time.
Correct. I am not telling that Mr. Banerjee has not instructed you. I am telling you with regard to the procedure which this court has adopted, because all the advocates are not getting an opportunity to appear before this court to press their application because of the fixed matter. The case is today is fixed for fixed matter. If the fixed matter is adjourned, then kindly come see, nobody is there. What the court will do? All the advocates know the fixed matter will be taken up. The other advocates are not ready. So if you want adjournment, I will give the adjournment subject to payment of cost as per the days. It starts from 20,000.
Kindly grant a short passover, my lord. I will.
What passover? There is no other matter. No other matter. Sorry. So appearing for the appellant. It's
Yes,
appeal.
yes, Lordship.
So appearing for the appellant. So appearing for the respondent. It is fine from the record that the learned advocate appearing for the appellant has concluded his argument in the month of September 2024. Subsequently, thereafter, time and again the respondents are taking time to argue the matter. Full stop. Today is fixed. Today the matter is especially fixed for argument on behalf of the respondent. Full stop. When the matter is called, the learned advocate appearing on behalf of the respondent submits that the earlier advocate has left the brief and now the learned advocate is appearing and prayed for time. Considering the submission made by the counsel for the respondent, the case is adjourned. Subject to payment of cost of rupees 20,000 to the State Legal Service Authority within a week from date. List the matter on, give the date, 345.
Lordship, if we could request for 12th of February, Lordship has also listed another matter, Lordship.
12th February date है
So, Lordship, I think that is also listed at 3 p.m.
345.
हमारा ही matter fixed है.
हमारा ही suffix, Lordship.
14th February?
Yes, Your Lordship.
At 345? At 345.
Much obliged, Your Lordship.
Grateful.
For Lord, the defendant, Lordship, I am led by Mr. Rohit Banerjee.
Lord, I am opposing this application.
He is today in the court. Milord, may I file our affidavit in reply, Milord? This is our application, Milord, for amendment of written statement, Lordship.
You are appearing for the defendant?
Yes, Lordship.
Amendment in the written statement by incorporating the counterclaim?
Yes, Lordship.
Yes.
Milord, I am led by Mr. Banerjee, Mr. Rohit Banerjee. He is Milord not available. He is Milord out station. May I pray before your Lordship to fix Milord another day, Milord, for hearing?
Really, Milord, two grounds I am taking, Milord. First of all, Milord, 120 days have passed long back. Milord, after 90 days, the 30-day period, they took an Milord extension, Milord, to file their written statement. Filed it. This is a subsequent application for Milord amendment of Milord the written statement. Now, Milord, completely changing the nature and character of written statement and Milord introducing a counterclaim. A huge bunch of papers have been Milord served as well as by way of amendment of written statement. Milord, which in my respectful submission cannot be allowed. Apart from that, we have also taken a ground of Milord limitation. Milord, they can argue as and when Milord. These are the principally two Milord grounds Milord which we are objecting to.
Milord, in this point, Milord, I am not ready to answer. Milord, in this argument, let Mr. Rohit Banerjee come.
Where is Mr. Banerjee?
He is Milord out station. Milord is not in town, Lordship.
Yes, Mr. Let come on the next day. Mr. Banerjee is not here.
Very well.
File my affidavit in reply, Lordship.
What file?
I have also filed my opposition.
Affidavit in opposition of J2. What you are filing?
Affidavit in opposition.
And I filed Milord our reply.
Milord, Mr. Singhani is appearing.
I'm for the plaintiff.
You file reply?
Yes, Lordship.
Tell that. So appearing for the plaintiff, so appearing for the defendant. The plaintiff has filed affidavit in opposition in connection with GACOM 2 of 2024. The defendant has filed affidavit in reply to the affidavit in opposition. Let the same be kept in the record. Full stop. Counsel for the defendant submit that the arguing counsel is out of station and prayed for time. In view of the submission made by the counsel for the defendant, the case is adjourned. Let the matter appear on 11th February.
Grateful.
I'm appearing for defendant number 1, my lords.
Yes.
My lords, on the last question, my lords has given direction for file notice and discovery, inspection and discovery of documents. My lords, I have written to the plaintiff, my lords, but I haven't received any reply.
You
This is
are
my
appearing for
defendant number 1, my lords.
SBI General Insurance.
Yes, my lords.
Who is for the plaintiff?
My lord, we had written to the advocate on record for the plaintiff and they have refused to accept the notice. So we have written to the plaintiff itself, sir. My lords.
What do you filed?
Affidavit of service, my lords, of the notice, my lord.
The discovery inspection completed?
No, my lords, we have written, they haven't replied or
you are for the defendant?
Yes, my lords.
What can be done?
My lords may dismiss the suit. My lords may dismiss the suit, my lord.
Huh?
Dismissal of the suit, my lord, I'm praying for.
So appearing for the defendant number 1. Full stop. Counsel for the defendant number 1 has filed affidavit of service showing that the defendant number 1 has requested the plaintiff to inspect the document mentioned in the written statement, but the counsel for the plaintiff refused to accept.
My lord, the advocates refused, and then we have served the notice to the plaintiff itself, the plaintiff company.
So they have not come forward.
They haven't replied, my lords.
Documents, but the written statement, but the counsel for the plaintiff refused to accept the notice, and accordingly, the defendant has sent the notice to the plaintiff through mail, and the same was duly received, but neither the plaintiff nor the advocate on record of the plaintiff come forward for inspection of the document. The affidavit of service filed by the plaintiff be kept with the record. Considering the above, this court finds that the plaintiff is not interested to proceed with the matter, as in spite of the direction passed by this court, neither the inspection was carried out, nor has prayed for any accommodation. Accordingly, CS
4110, my lord.
CS Com
410.
CS Com 410 of 2024 within bracket old CS 180 of 2022 is dismissed for default. Interim order, if any, stand vacated.
It was my lord.
Next.
Lordship, item for number 21, I appear on behalf of the respondents and being led by my senior Mr. Debraj Shahu. He'll be appearing online, Your Lordship.
My lord,
I appear for the defendant, my
plaintiff.
lord, in this matter. My lord, in November, my lord, we had written a letter to the plaintiff for my lord, disclosing the documents, which was not complied with, my lord, on 17th of December, Lordship. And when the plaintiff did not appear, my lord, I had apprised this honorable court. Lordship had, my lord, extended the time till 1 week after vacation. But
Yes,
till
my
now,
lord, I
my lord, the
appear for
plaintiffs
the
have not
plaintiff, my
disclosed any
lord.
document for inspection,
My
my
lord,
lord.
I appear for the plaintiff, my lord. I seek to complete the same, my lord, if my lord allows me 1 week more.
No, kindly see the last order. It is
Yes,
made
my lord,
that if the party failed to complete the discovery, the document as stated, the chance to discovery or inspection, the document will be closed. Then
Yes, my lord, I apologize, my lord. I tender my apologies, my lord. If my lord
My
grants
lord,
me
I'll
1
be
week's
opposing
time, my
that
lord.
prayer, my lord, and as per my lord, if I may kindly place, my lord, order 11 rule 3.
Correct.
Lord, sub rule 5, they cannot now, my lord, the plaintiffs cannot now rely on these
it's
documents.
a commercial suit.
Yes, they cannot now
Yes, my lord.
rely upon the documents at all.
My lord, I only seek for 1 week's time, my lord, to complete the same, my lord.
No, you have not completed. 20th August, the court was granted time. Then 17 December, the court has granted time. 27 December, this court has granted time. इसमें क्या किया, कितना ऑर्डर निकालो? 20 अगस्त के बाद का ऑर्डर नहीं है इसमें.
My lord, there would be one on the 17th of December, my lord.
I am closing it. Let the issue be framed.
My lord, may it also be, my lord, recorded. They have also not, my lord, requested for inspection of our documents. Although we had sent a letter.
कितना ऑर्डर है? 28 20 के बाद 20 अगस्त 20 अगस्त के बाद 17 दिसंबर
Yes.
ठीक है नहीं yes
My lord, if 1 week may be granted, my lord, that should be completed, my lord.
pay cost so applying for the plaintiff, so applying for the defendant. Police counsel for the defendant submitted in spite of the notice issued to the plaintiff, neither the plaintiff has disclosed their document for inspection, nor the plaintiff has come forward for inspection of the document of the defendant. This court find that by an order dated 20th August 2024, this court directed the parties to complete the discovery and inspection within 3 weeks. But the same was not completed. Again, by an order dated 17th of December 2024, this court extended the time for discovery and inspection of the document. By the order dated 17th of December 2024, this court has made it clear that if the parties fail to complete the discovery and inspection of the documents, a chance for discovery of inspection of document will be closed. Today, when the matter is called, again the counsel for the plaintiff prays for a week time. Considering the submission made by the counsel for the plaintiff and for the interest of justice, time to complete the discovery is extended by the following direction. Subject to payment of cost of ₹20,000 by the plaintiff to the State Legal Service Authority within a period of 1 week from date. Full stop. The plaintiff shall disclose their document to the defendant within a week from date. Full stop. The defendant shall also disclose their document to the plaintiff within a week from date. Both the parties shall complete their inspection within a week thereafter. Full stop. On completion of the discovery and inspection, both the parties are directed to file their affidavit of admission and denial of the document within a week thereafter. In the meantime, the parties are also directed to complete this exchanges adjusted issues. List the matter, 3 week bola na? List the matter on 21st of February 2025 for framing of issues.
Grateful.
Item number 22, I'm appearing for the plaintiff's minute. By an order of my lords of 6 December 2024, Millets had directed us to finish the discovery, inspection, admission, denial, and come up with the suggested issues. In the meantime, what has transpired is that the defendant had approached the plaintiff for a settlement. The talks of settlement are going on. May I beseech my lords to please extend the order such that we can come back after 2 weeks and complete all of this if the settlement fails.
Who is for the defendant?
No, they have not been appearing. Though a written statement has been filed by them, they are not appearing at all.
So they have not filed the written statement?
Yes, they have filed a written statement.
So,
but they are not appearing when the matter is taken up. We'll see the last order, 6 December 2024. I had mentioned that they have submitted their written statement. They have served upon us a written statement. Whether or not they filed it is what I'm not aware of.
You filed the affidavit, you filed the document. Then
Yes,
I am framing the issues. What can be done?
No. The difficulty is that they have approached us for a settlement.
Okay.
So that is the reason why I'm seeking 3 weeks time.
The defendant. Police counsel for the plaintiff submit that the defendants have approached the plaintiff for settlement of the matter. Accordingly, counsel for the plaintiff prays for extension of time to complete the discovery and inspection, extension of time to comply with the order dated 6th of December 2024. In view of the submission made by the counsel for the plaintiff, time to comply with the order dated 6th of December 2024 is extended for a further period of 3 weeks from date. List the matter on 28th of February 2025 for framing of issues.
I'm obliged. That will be defendant. There's no sole defendant, sole plaintiff.
Defendant, not defendant. Yes, next.
Deeply obliged.
Item 23, my lord, I appear for the defendant.
Where's the plaintiff?
The plaintiff last
occasion. Lordship, I have been instructed to appear on behalf of the plaintiff. There has been a change of advocate, your lordship.
Yes, I know, sir. Whenever the case has come for the inspection of the document, framing of the issue. There are 4 categories. One, change of the advocate, fracture, advocate, the client has out of station, and the no instruction. These are the 4 I am hearing for the last 2.5 years. Tell me, other than these 4, what is your ground?
We have not been able to take the change, your lordship, and it can be.
Okay, I am framing.
Lordship would kindly give me a week's time. I would be coming with the fresh vakalatnama and the issues, your lordship.
Okay, you pay the amount of 20,000 to the State Legal Service Authority. I am granting.
Lordship, the advocate is not there. Who was the conducting advocate who was supposed to issue the change is not there, your lordship.
Yes,
that is the difficulty.
On the 25th November also none appears, sir, for the interest
Yes,
of
I was not there, your lordship, at that point of time.
What can be done? If you are not appearing in this commercial suit, the court has to proceed something.
Lordship would give me one chance. This would be my humble request.
I am not curtailing, but only to pay the 20,000. That is only the legal service authority, not to this court or not to the plaintiff, not to the defendant.
I am beseeching your lordship now.
Because there are so many persons who may get the legal aid from the legal aid service authority, pay the amount to her, so they will get the service authority and service of this legal service authority.
Lordship would only record that I am appearing for the first time, and I am not having the right of audience today also. Otherwise,
since appearing for the defendant, full stop consent, the learned advocate appearing for the plaintiff submit that
we have not been able to get the fresh vakalat.
But I don't think my learned friend is appear because he doesn't have vakalat number.
Yes.
Don't know.
Learned counsel appearing for the plaintiff submit that though he is not having the vakalatnama, but the plaintiff has instructed to appear as the previous counsel is not appearing in the matter. He prays for extension of time to complete the discovery and inspection of the document. Considering the above, for the interest of justice, the case is adjourned for 2 weeks. Let the matter appear on 11th of February 2024.
I am extremely grateful, my lord.
Made clear that on the date fixed, if the plaintiff failed to disclose the document to the defendant for inspection, appropriate order will be passed.
Okay. I am grateful, extremely grateful. Grateful.
My lord, I appear for the plaintiff, my lord. Lordship's last order.
I am appearing for the
defendant. 17 December 2024. Kindly seize, my lord. Before Mr. Lakmani starts, my lord,
before my friend, my lord,
I possibly have
let
a right.
Let me make an embarrassing request, my lord.
Yes, what about the appeal?
My lord, kindly allow me, my lord.
Is there any appeal? What is the order in the appeal?
My lord, we will file it, my lord. Also,
appeal is also frozen.
It is in the process of being filed yet, my lord. It is on the verge of filing. Kindly, my lord, just give us.
Yes, what is the what is?
My lord, I am praying Lordship fixes it. My lord, records that it is now. It can be proceeded ex parte. Lordship's previous order of 30th September 2024. If my lord kindly takes this once, my lord, this order 30th September. Ache. My lord, kindly sees the 4th paragraph of the first page of that order. It is found that on the prayer made by the counsel for the defendant on 3rd September 2024, this court granted leave to the defendant to file an application for extension of time to file written statement. My lord, this was necessary because it was the last date when you could have come and file an application. Now, this leave was granted. Kindly sees the next para. As per report, it is found that the defendant has filed master summons along with the application on 11th September. So, it's beyond 120 days. At 2:30 p.m., report reveals that the defendant has filed vakalatnama so-and-so in the department. Then Lordship turns the page, comes to the second page, penultimate paragraph. This court finds that the defendant has taken leave from this court but has not filed the application on the date fixed. As per report, vakalatnama was filed on 4th September without leave of the court because Lordship's leave was only for 3rd September. Thus, the application filed by the defendant on 4th September cannot be accepted. So, there is no application even for extension of time to file written statement. Order is dated 30th September 2024. Adjournment taken on 17 December 2024 that they are going to prefer an appeal. Now, we are in January 25. So, I am saying, my lord, I am praying that kindly fixes it ex parte so that I can, my lord, proceed with this.
My lord, if your lordship would kindly recall, this is, my lord, that matter which, my lord, triggered your lordship to give directions to the department.
I am sure you will get the order from the appellate court, then the order automatically it will be recalled. So and so. appearing for the defendant. This court find that by an order dated 30th September 2024, this court find that the defendant has not filed the return statement. Even the not filed the return statement, and the auto time limit of 120 days is already elapsed. In view of the above, let the parties are directed to complete the what inspection will.
Well, it fixes it ex parte, and I'll proceed.
Let CS Com 3 of 2024 be placed in the list of the undefended suit. Full stop. The plaintiff is directed to file the judge's brief document within 2 weeks from date. Full stop. The affidavit of evidence of the plaintiff witness be filed within 2 weeks thereafter. Full stop. Please the matter. Give the date for witness action.
The Lordship would kindly consider clarifying, my lord, that this order will not be an impediment in my appeal. That's my only apprehension.
Well, that's not necessary here.
Let the matter appear 17 March at 3 p.m. for witness action.
Grateful, my lord.
Affidavit of evidence बोल दिया ना?
My lord, this order should also not prevent me from taking out an application for summary judgment. Now it's here.
Next.
My lord, item number 25, my lord, appear for the plaintiff, my lord. May I file my affidavit of service, my lord? Pursuant to your lordship last order, my lord, the advocate on record of the defendant has taken, my lord. He has taken the service, my lord. I have given it by way of mail also. I have given to all the defendants, my lord. The issue is the defendant, my lord. When I've posted to a defendant, my lord, it's coming addressee left, my lord. But it's coming as addressee left.
So,
but advocate on record has taken, my lord. And even the mails have been sent to all, my lord.
What is the suit?
My lord, suit was for a loan granted, my lord, on the basis of dishonor of check, my lord.
Huh?
Loan was granted, my lord.
So why is the affidavit of service?
My lord, what has happened, my lord? My lord, may kindly what has happened, my lord? The summons, my lord.
Achha. But in spite of the receipt of communication, no reply has come from the record, no record. The suit is filed when the plaintiff was dismissed for default. Subsequently, suit was restored by an order written. This finds that the defendant is not appearing in the meantime. The dismissed for default restored. So you issued the notice.
Yes, my lord.
Sole defendant.
Sole defendant, my lord.
But it has written unserved.
Yes, my lord. As addressee left, but the advocate on record of the defendant has taken, my lord.
Advocate on record has taken.
My lord. And the emails we have served by emails also, my lord.
To whom?
To the advocate on record as well as to the defendant, my lord.
Defendant also served.
Yes, my lord.
Where is the email?
My lord, may kindly see the first page 2 of the affidavit of service, my lord. All the 3 emails are there, my lord.
Swati Agrawal @gmail.com.
That is my advocate on record, my lord.
To who is the defendant?
My lord, the Supreme Freight Carriers. Deepak at Supreme Freight Carriers. The other emails are also there, my lord.
So he has not come forward.
They have not come forward.
So what
They have all along, my lord, they have contested the injunction application, my lord. They were supposed to deposit the amount also, but they have not deposited it, my lord.
So writ of summons earlier served.
My lord, writ of summons, for that I had on the lordship order is there, my lord. On the previous occasion, what has happened? There was no formal order of service of writ of summons. So by letter we had given to them because the honorable court desire was okay, you serve it them here and now, and I'm not recording the order. So ultimately, by way of letter, we had given to them, my lord, 18 May 2022. Not by this court, my lord. The Justice Kapoor was there sitting.
That will be better to writ of summons.
My lord, that was the reason why I had shown this letter also, my lord. That's recorded in your lordship order also, my lord.
Since appearing for the plaintiff. In terms of the order dated 23rd December 2024, the plaintiff has served the notice upon the learned advocate on record of the defendant as well as to the defendant by speed post as well as through mail. The notice sent to the speed post was written with the endorsement, addressee left, but the email has been received by the defendant. In spite of receipt of the notice, none appears on behalf of the defendant. Let the affidavit of service filed by the plaintiff be kept in the record. In view of the above, CS-COM 248 of 2024 within bracket old CS 49 of 2021 be placed in the list of undefended suit.
I'm grateful, my
Full stop. The plaintiff is directed to file the judge's brief of document within 3 weeks from date. Full stop. Affidavit of evidence of the plaintiff witness be filed within a week thereafter. Within 2 weeks. Within 2 weeks thereafter. Full stop. List the matter, give the date for a witness action. 18th March at 3 p.m. for witness action.
I'm grateful, Maro.
Next.
Maro, may kindly record that even the advocate on record has received it, Maro.
Yes, record.
I'm grateful.
Lord, I'm appealing for the plaintiff, my lord. This is the matter where I have filed a GA5, but this was to be filed in the computer system, whatever. Now that has been done, my lord, but there was some technical glitch for which I am praying for not today because this will be finally today, my lord, in the computer online system, my lord. So I was praying for not today so the matter can.
Who is for the defendant? Nobody.
My lord, initially JP Tibrewal was appearing, but now they have written a letter saying that they have given, they have taken change. The bank has taken change and given to some other. We have asked for the address. They have not
As per the prayer made by the counsel for the plaintiff, the case is adjourned.
And they did not appear on the last
Let the
occasion.
matter appear on 31st January. Come on 31st.
My lord.
27.
My lords, I am appearing on behalf of the plaintiff. My lords, on your last direction, Lordship had directed us to be prepared with the suggested issues today and file the judge's brief of documents and
Inspection
admission.
completed.
Yes, my lord. The only thing is, my lord, my admission denial is ready. What has happened, your lordship, is on 17th January.
That may I just indicate before
an advance copy has been given of
that
an
was in
admission
an
and denial.
incorrect format, my lord.
And
That's
it's
an incorrect. We
completely
withdrawn
blank.
it, my lord. We prepared it afresh, my lord. Maybe
May I get some additional time? The admission and denial is ready, only its affirmation is required, my lord. I will file the judge's brief of documents, my lord, and the suggested issues today.
My lord, I'm serving a copy of my admission denial also, my lord.
So appearing for this. What about the issue?
Issues, my lord, will give me some time. There's default on both parts.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the you are for the defendant.
For the plaintiff.
The counsel for the defendant has filed. Counsel for the plaintiff has filed judge's brief of document and suggested issues. After serving the copy to the learned counsel for the defendant, let the same be cut with the record. Learned counsel for the defendant has filed affidavit of admission and denial of the document after serving the counsel serving the same to the counsel for the plaintiff. Let the same be cut with the record. Learned counsel for the plaintiff press for extension of time to file affidavit of admission and denial of the document. So the counsel for the defendant pressed for time to file suggested issues. In view of the submission made by the counsel for the respective parties, time to file the affidavit of admission and denial of the document by the plaintiff is extended for a further period of 10 days. Full stop. The filing of suggested issues by the defendant is also extended for 10 days. Let the matter appear on 11th of February 2025 for framing of issues.
Oh, pleasure. May I just indicate one thing, my lord? In the cause list, my lord, we'll note that the names of the advocate of the plaintiff are appearing. We have, my lord, filed our wakalatnama entered appearance. The name for the defendant, my lord, it's not appearing in the cause list. In the cause list, advocate, this is an issue that, my lord, my clients are based outside of Calcutta. They have this issue, my lord.
Counsel for the defendant submitted, though they have filed the wakalatnama on behalf of the defendant, but their name is not appearing in the cost list. Accordingly, the department is directed to take appropriate step for recording the name of the defendant in the cause list.
Deeply obliged.
Grateful, my lord.
Of the instant suit.
Grateful.
Yes.
Sir, this is my application GA number 2, my lord, for seeking condonation of time to file my written statement, which is already filed, my lord, within 120 days. My lord, beyond 30 days, but it is within 120 days. And we've explained.
When you receive the writ of summons,
My lord, we'll kindly see.
you are appearing for a plaintiff.
No, no, I'm
Defendant. Who is for the plaintiff?
But Miss Niranjana Adya, my lord, was appearing.
She's not here.
Lord, we've already filed, my lord, and served it upon them.
When you received?
Not 17th and 18th
Defendant
of
number 1, 2, and 3,
1, 2,
17th
3. Malad
May
7.
2024.
But 17 September, Malad, and 18 September.
17th September.
And 18
Where you mentioned?
paragraph 3 of my application, Malad.
October. Main defendant 21st October. So it's time to main
Defendant number 1 on 21st
October.
October.
So it's in February.
And defendant number 2 and 3 on 18 September. So 120 days is over.
That 120 days is over, Malad. For defendant 2 and 3, it will be 15th of January. For defendant, the main defendant, it is in February, Malad. We have given all our explanation from paragraph, Malad.
So you have filed the combined written statement?
Yes.
Combined written statement.
How it can be?
Right. But the stand, Malad, it's arising out of a contract, Malad, where the parties are, Malad, similar, Malad. The principal relief is against the state of West Bengal. Malad, there is no requirement to, Malad, in facts of this case, there is no requirement to file a separate written statement.
Correct.
We've already filed.
And the written statement is filed, Malad. It is affirmed, Malad, within the 128 days.
And filed also.
And filed, Malad.
When you affirm the written statement?
But it was 15th of, Malad, I was instructed it was 15th of...
Where is that?
13th of January and filed on 15th.
Have you got the backside paper? Leave granted by this court?
Yes, by wait.
13th January.
Yes. Well within time. Well.
And a copy of the written statement has been served upon the plaintiff as well.
Lordship, I'm appearing for the plaintiff. Lordship, may it be taken up tomorrow. Lordship, I'm traveling. I'm on my way back to High Court. Lordship will apologize me. May it be taken up next day.
Not.
It's an applicable
If it is to be mentioned tomorrow, but then it can be tomorrow, of course,
Monday,
but Saturday.
Tomorrow is Saturday, Lordship. Next day, Lordship.
Mr. Sinha is appearing tomorrow.
There will be no formal.
Please ask him. I have no problem in coming.
Lordship, Mr. Sinha will ensure that the court functions tomorrow, I believe.
Court has no objection.
Court has no problem. You are not here.
Court has no problem. Sense appearing for the plaintiff, sense appearing for the defendant. As per the prayer made by the counsel for the plaintiff, the case is adjourned for a day. Let the matter appear on Monday.
I'm grateful. I'll apologize. I'm appearing virtually.
Take, Mr. Sinha.
Lord 29, I'm appearing for the defendant. My Lord, before my learned friend will have a lot to say, but may I just provide one clarification? My Lord, what has happened is, my Lord, if your Lordship sees the last order, I appeared and I made a statement that I am instructed not to appear. My Lord, the statement was made on the instruction which I received from my advocate on record. My Lord, the situation is now such that my advocate on record possibly, my Lord, there is some possible dispute with the client because of which he has recused himself from the matter, but he is formally not handed over the no objection certificate. My Lord, I have my new advocate on record, my Lord, who has been appointed, my Lord, because for the reason that the NOC was not granted by the former advocate on record, we could not bring the Wakalatnama on record. But I have a copy of the Wakalatnama authorizing my present advocate on record to appear in this matter.
But what about the amount?
Now regarding the
I
instruction.
now have my 2 minutes.
But I'll just take 10 seconds more, and then, my Lord, now the situation is your Lordships have already passed an order, my Lord, directing us to secure the amount in dispute. And we have also come and made a statement that we will endeavor and we have to, my Lord, comply with your Lordship's order. My Lord, the difficulty is, what I'm now instructed is, my Lord, there is some liquidity crisis and my client has been suffering from this for a long time. Despite our best efforts to persuade our clients, my Lord, they have not been able to arrange because of the liquidity crisis. There are various contracts which they had also executed.
The contractors up till 25th, 27th March, they are having the total balance.
But not in this case, my Lord, not in
this case. I am submitting in as a whole. The contractors and the departments, all the departments are having the sufficient fund till 28th of March of every year. But 1st April to May or June, they have some crisis. They may have some crisis. I have better experience on this side.
But the only submission I was making today, despite, my Lord, everything, I am still instructed today that my clients will require some time. My Lord, I have to secure. My Lord, to try and secure this amount. I can only, my Lord, today make this prayer. My Lord, I can only make this prayer.
What is your prayer, sir?
Lord, to grants me a month's time, my lord. To see.
Month's
That's
time.
what I'm, my lord,
So
instructed.
that's I'm telling you, month's time, then you will come in the financial year, financial month. Then
But in the
you're going to
meantime,
again in difficulty with regard to the GST and added value tax.
in the meantime, their application for judgment upon admission is there, my lord. That can be heard, my lord. We'll try and secure it. My lord, I am now leaving it up to the plaintiff. If they want to, my lord, press for orders, my lord, they can press. But this is the instruction that I have as on today.
Yes, my lord, will kindly take into consideration. I understand my learned friend's difficulty, but my lord, I can't appreciate my learned friend's client's difficulty. 30th August 2024 is the original order passed by my lord. My lord, will kindly have the date 30th August 2024. That order was carried up in appeal. Appeal dismissed, confirmed. Thereafter, my lord has directed them again to secure on 26 November 2024. My lord, the orders speak for themselves. Thereafter, my lord, the last order passed by my lord 6 January 2025, an affidavit of compliance is directed to be passed, my lord, filed. Nothing of that sort. My lord, that affidavit of compliance is not being affirmed by an advocate. It's being affirmed by his client. They're taking this court for a ride, my lord. I must, at this stage, my lord, that is my submission.
There is
It's
no
an order of court that has been subsisting for more than 6 months. This client, this defendant has chosen not to comply with the orders of this honorable court, my lord. Let them be personally present now, my lord. I'm praying for, my lord, strict action to be
my lord,
taken.
today, if I am, my lord, having a liquidity crisis, my lord, the
That
compliance.
was the basis
my lord,
on which. That is the business.
Having a liquidity.
But I can't, my lord. If he wants to press for further press, my lord, I cannot, my lord, possibly come in the way, my lord. I made a bona fide submission, my lord, that if given some time, my lord, because we also want our client.
Since August 2024.
Because, my lord, this is not a case, my lord. I'll just indicate, although,
was passed.
my lord, in August,
August
my lord, I'll also indicate, my lord, this is not a straitjacket case, my lord, where they have a, my lord, undisputed claim of, my lord, 40 lakhs, what they have claimed, my lord. The admission, my lord, at the time when the hearing of judgment upon admission takes place, I'll demonstrate that, my lord, there is no such admission, no clear, unequivocal admission which is on record.
That is correct. That is correct. That's why this court has not directed to pay the amount or deposit the amount. This court has only directed that 40 lakh rupees is to be kept in a separate account and file the affidavit showing that the amount has been segregated and kept in the separate account. That's all. This court has not passed any order. Otherwise, now the chance has come. I have to file and pass an order to appoint a receiver.
My lord.
To take the depths of all the depths of the defendant.
Lord, may I then pray for a week's time, and then, my lord, I'll not, my lord, I'll not object if they want to.
Order appointing a receiver of any of the officer. I will.
My lord, I prayed for an injunction upon his bank accounts. My lord, I have
Kindly
gives
gives me a week's time. My lord, week's time. Keeps it on Tuesday. In the meantime, I'll take instructions and come.
As so and so suffering for the plaintiff, so and so suffering.
And may I also pray for your lordship's leave to file the wakalatnama, my lord, because
Wakalatnama, who is restraining you?
But unless we get a
made by the counsel for the defendant for the interest of justice, the case is adjourned for a week. Let the matter appear on 7th of February 2025. Come on that day.
My lord, will
Come
kindly
ready, otherwise.
Lord, will your lordships grant leave, my lord, because the former
the counsel appearing for the defendant is granted leave to file. Why your other advocates not you are not given the no objection?
But the former advocate has not given.
Advocate is granted to file wakalatnama on behalf of the defendant without obtaining any no objection from the earlier advocate.
My lord, only one submission. My lord. If they still don't file the affidavit, my lord, will grant me liberty to pray for further orders, my lord.
Okay? That's what I'm telling. Let that come on that day. Let
My
the
lord,
file wakalatnama.
my lord had directed us to serve a copy upon the plaintiffs because the advocate wasn't appearing. This is my affidavit of service, my lord. A notice.
Affidavit of service filed by the plaintiff be kept with the record.
Obliged.
Yes, next.
I'm great.
345. Matter number 3 of the non-covered cases.
Well, I appear on behalf of the respondent. Well, today I have to give reply, Millard. Now, Lordship might recall this is, Millard, an application, Millard, filed, Millard, for summary eviction in an eviction suit, Millard.
Yes.
Now, point, Millard, that I had taken, Millard, that there is an admission on their part. If Lordship has taken note of all, Millard, arguments which I have advanced on the last day, that during the interregnum of the lease period, which was for 25 years, they have accepted rent from me. And by accepting the rent, my status has changed slightly. I have become a monthly tenant, number one. Number two, alternatively, I have become a tenant by holding over. And to that effect, my lord, I have relied upon a particular document which is annexed to my affidavit in opposition. And that document, Lordship has taken note of it. That is, my lord, at page 19 of my opposition.
Just to interject, my learned senior friend, he is on reply. So
No, not more than 10 minutes. Be rest assured.
But you should restrict yourself to the point of law, not re-argue that.
No. Now, Lordship
Just a minute.
has seen that. Now, my lord, in there, and the maintainability of the suit has also been, sorry, my lord, Lordship.
Yes.
And the maintainability of the suit has already been kept open. Why? Because I say notice is bad. That's my specific stand in the written statement as well as in the affidavit in opposition. Now, what they have said in their, while dealing with my point, they have said they have given an adjustment to the proposed rent. That's the only point. Now, my answer to that, what I said also in my petition when I started the argument, if had this been a case of adjustment, they could have said that at the first instance in the first notice. They did not do that. First notice, if Lordship sees once, I have prepared a note also. It's a simpliciter eviction notice appearing at page 57.
Yes.
Lease period has expired.
Yes.
Thereby, you have to vacate.
Page 57.
Page 57.
Of your
First
affidavit.
notice of the petition. The document which I had shown, that is from my opposition, though that's also part of their petition.
Yes.
Page 57. In reply to that, I have said that. Now, there is no whisper about adjustment. This proposed adjustment for the first time came in reply to their notice, that is at page 63 of the petition.
Yes, you
Yes.
pointed out. Yes.
Now, kindly comes to page 64. Lordship would find the period. From 2015, they didn't do anything. They say this is what we have adjusted. I say this is a matter which certainly requires adjudication of facts. Because had you taken this point at the first instance, situation could have been different, could have been better. You could have said that. Now, why I say this, that provision you had in the lease, kindly have a look at the lease, which is the very genesis of the dispute. That is, my lord, page 43. Lease starts at 25 years, my lord.
Yes.
Page 40, the lease, my lord. Lordship would find, my lord, the first page. Then, my lord, page 42. I have argued that last two lines, Lordship would find the lease period will expire on 31st October 2020.
Yes.
Now, kindly see one or two clauses relating to this proposed alleged enhancement and their adjustment. Page 43, how frivolous their stand is, whether summary eviction is possible or permissible. That's the point. Clause 1. The lessee shall pay unto the lessors during the continuance of the lease the monthly rent of sum of rupees 1400, which I had been paying back to the eviction notice, only on the 7th day of each month, and there is a provision for interest also. Last two lines. If I fail to do that. Now, next, kindly, my lord, comes to page 48.
Yes.
Clause 16 and 17. It's very important, this clause. In case of any breach of any covenants or conditions herein contained and to be observed and performed by the lessees, this lease shall be deemed to have been determined forthwith at the option of the lessors, and the lessor shall have the right to re-entry and possession. So they had that right. And alleged, my lord, proposed enhancement, Lordship has seen from the period of 2015. That's their plea in defense. And that is after I had given a reply to their eviction notice and the documents I have annexed. So they didn't exercise this clause at all. They did not exercise this clause at all at the very first instance. Today, my lord is deciding whether summary eviction or not without a trial. Only to that extent.
Yes.
And next clause, it is hereby expressed that if the said monthly rent has been reserved in areas for 2 months, then again they have a right to evict. So really, clause 16 is to be read with that enhancement clause. So they didn't do anything. What the eviction notice says, period expired. So I said this stand is a frivolous stand. Yes. And just, my lord, to counter the stand taken by you in my opposition, that I have become a monthly tenant. Or otherwise, tenant by holding over because you have accepted. And in support of that, my lord, I had relied on certain judgments. My lord, first 2017, Lordship knows uptown. Then, my lord, 2015. And other 2 judgments, my lord, on acquiescence, I have all indicated in my written notes. Kindly have a look at this because I will not trouble your lordship much. Very much. A note copy there, George Shab Dejo.
Yes.
2 judgments. Kindly have a look at this written notes. Just I will indicate, my lord. Second page, lordship sees, my lord. I have indicated, I am not troubling your lordship. There is already an order subsisting which has not been challenged. Page 2 of my notes. The maintainability of the suit has been kept open. Why? If lordship sees the written statement and the opposition, lordship would find my standards notice is bad. So how will you decide? Because I say I'm a tenant, monthly tenant. I have relied upon a bank statement. You controvert. And you controverted when? After I did that. And I've shown you the clause. You had the right to evict me. You didn't do that. So your simpliciter eviction notice is on the basis the expiry of the time. Now, my lord, lordship would find, my lord, I have said at last paragraph, lordship would find.
The adjustment was the old rent or new rent?
Old rent.
Not the enhanced.
But they say it's no. Old rent, but they have said you are supposed to pay more.
Correct. That's why the amount which you have paid, that was made adjustment.
No notice, nothing. No notice, nothing. The moment I have taken a stand that you have accepted rent for 6 months, they say from 2015 I am adjusting because you are supposed to pay more. But why didn't you point?
That's why that adjustment of the old rent or enhanced rent.
Just give me a minute's time, what they have said. And I have controverted that stand also in my written statement. Page 63. No, they have said you are supposed to pay more. Kindly see page 64. I'm grateful to your lordship. That's not on the basis of old rent. Kindly see the clause, rent for the month of July 2020, because I had always been paying rent.
Where from? Page 60?
Rent for the month of July 2020.
Page
64. Kindly see what the quantum, not 1400, 2049. So that has to be the enhanced rate. And that is the contention in their reply. No notice, nothing. Some bona fide has to be tested at this stage when my lord is deciding chapter 13A or a summary eviction. Because somebody will...
So enhanced rent, that is 15%, 10%.
10%.
10% in terms of the agreement.
Yes, agreement. And for the period 2015 to 2019, you could have simpliciter said, you're giving me a notice that you please evict. That's the clause you had. And when did you do that? Not at the first instance.
Second.
Yes.
Yes.
So how this will be decided? Certainly this needs to be, my lord, gone into and has to be done by a trial. Now, my lord, kindly see the other point, my lord. I have, my lord, indicated in my written statement that I have taken this point. I have shown you the maintainability point is still, my lord, open. And I have indicated the relevant pages also. Page 2, lordship would find the order whereby maintainability point has been kept open. Page 76 of the application. So I've indicated in my notes. And all the notices, including the last notice, which they had issued 23rd November, I have indicated that page 69. And also the affidavit in opposition and the written statement, relevant pages and the paragraphs, I have also indicated page 2 and page 3, where I have taken this stand that I have become a monthly tenant or the tenant by holding over alternatives. So this stand is very much there in the written statement, and whether the suit is maintainable on this notice, that's also a point to be decided. Okay. So how this will be done at this stage? Now, my lord, kindly turns over. I will not trouble your lordship much, my lord. The judgments which I had cited, my lord, kindly comes to page 6, last paragraph. I have given reference to 2017 Volume 1 Supreme Court cases, Uptown Millard paragraphs. It clearly says, Millard, only a tribal issue which I have to, Millard, indicate, not more than that. If I can show that, I have a right to be given unconditional leave to defend. Only if it's a sham, frivolous, vexatious, only then, Millard. Whether stand or the facts really...
Yeah, that is the law.
Yes, yes. Now, Millard, the other one, 2015 Volume 10 Supreme Court cases, when the issues are triable, it has to be relegated to the trial. The next judgment, page 7. I have cited. Lordship has the copies also, Millard. So I am not. I have not again multiplied it.
I will go through.
Yes. Now on acquiescence, it's clear. Law is well settled. 2015 Volume 15 Supreme Court cases, page 1, paragraph 40 and 41. I have quoted those things, Millard, in these two paragraphs, and the principal Lordship would find page 8. I am not troubling your Lordship. The exact paragraph and the language, what the acquiescence is, that has been categorically quoted in my notes. The principle is page 8, Millard. The principle is based on the doctrine of acquiescence, implying in such a case that a party who did not make any objection, because they did not do that, acquiescence into the alleged wrongful act other and therefore has no right to complain against the alleged wrong. Then the other one, 2022 Volume 2 Supreme Court cases, paragraph 39, detailed explanation of acquiescence has been given following the earlier one. And the last one, Millard, it's on approbate and reprobate. Next page if Lordship turns over. 1992 4 Supreme Court cases, paragraph 10. That judgment I have also handed over, because by accepting rent, you have accepted me as a monthly tenant.
Yes.
So under these facts and circumstances, I respectfully submit before your Lordship, certainly, Millard, matter needs to go to trial and the application is liable to be dismissed. Because it's a right, it's a very valuable right that is accrued in my favor. And whether the right at this stage can be curtailed on this base, on the basis of the facts, that Millard court would, Millard, kindly see. Okay. Lordship would kindly see. I'm grateful, Millard.
It took around 2.5 years to decide this come to this final stage of this Chapter 13A application. Now, two issues falls for...
Whether you're blaming to the court or...
No. It's my fault. The client told 2 years gone, Chapter 13A is not yet been decided. You told we will get a summary judgment. That's a client told me today. No.
That's not the way.
Now, the two issues falls for consideration of this court. First, whether the defendants have a lawful and a justifiable defense to my Chapter 13A application for a summary judgment. And if they have, whether a conditional leave or an unconditional leave. That's the two things. With regard to the judgment cited by my learned friend, that's 2017 Uptown, that's well settled. Now, his moot point in this, or moot defense in this Chapter 13A application, that he has paid rent beyond the time period of the lease period, and I have accepted it.
During the existence.
During this. Kindly take up, you should have dealt with this. Kindly take up page 17 of my reply, 19 of my reply. And side by side, your Lordship will kindly take up page 57.
19 of the reply?
Yes. 19 of the reply. Yes, affidavit.
Affirmed by? Who was affirmed?
My
Shamal Kumar?
Yes, Shamal Kumar.
Yes.
It's two counter receipts, both dated 18th August 2020. Lordship got it? Two counter receipts.
Which one?
This
page?
It's 18. The affidavit ends from 19 onwards.
Of your application?
Of my reply.
Reply, there is no annex.
Yes.
Reply, there is no annex.
There is an annex, Miller.
But I find one. But
yes,
this point he has not raised.
Yes, I have.
Achha, this one, page number 19.
Yes.
Okay.
Yes.
If you had indicated, I would have dealt with. I will right now.
Yes.
It's the 18th August 2020. Two counter receipts, which the rents for the month of one counter receipt for the month of July 2020. Another for the differential amount, my lord.
July 2020.
Yes.
This is the 1 month.
This is 1 month.
And
And that's a lower one, the bottom one, July 2020.
correct.
And the check number was indicated. The payment is not disputed.
Correct.
And second is for the differential period, differential amount. That's written in the middle. From November 15 to
November 19.
November 19. 186.34 paisa. Your lordship will get at the rate of 186.34 paisa. That's a differential amount of 9,130.66 paisa.
9,130.66
paisa. And the receipt, my counter receipt at the bottom part is 2049.74.
74.
Kindly mark that those two things.
Correct.
And the dates are 18th August 2020. During the subsistence of this lease period, he paid these two amounts to.
Correct.
And I gave him a receipt.
So what you want? What is the submission in this?
He said, according to my learned friend, that the amount which he has paid was for the rents for after the lease period has expired. But according to me, and that's a document, will speak, that those amounts which he had paid was for the rent for July 2020 and for the differential amount. Now, 18th August, he makes payment of this. Your lordship will, by side, will take page 57 of my application. Your lordship will keep this on one side and kindly take page 57 on the other side.
Yes.
He says that this is the notice by which I have said, please vacate. I said that your lease is expire on such and such date. Please intimate me the date and time when you would vacate. That's letter comes in 3rd of September 2020. 1 month, quite 1 month thereafter. In reply to it, the defendants say that we have been, that's his reply, is page 60. He says, we have been living here for such a long period. You cannot claim a 10% enhancement. And he says that we have paid you rent. In reply to it, I give them a clarification letter, page 63.
Yes.
Para 1. Your lordship will first come to the fourth paragraph, page 63. In this context, I have already written a letter to you on 3rd September 2022. Let me know the date and time as to when you would hand over vacant physical possession of the said flat to me. You have not informed me anything in this regard as yet. As regards to the allegation made by you in the letter under reference are concerned, the same are absolutely false, incorrect, save and accept the rent for the month of July 2020. No further rent was paid to you. First, he is aware because he has the receipt. Pursuant to the aforesaid deed of lease, the lease rent was supposed to be enhanced at the rate of 10% over the existing rent after the expiry of every 5 years. And in view thereof, original rent of rupees 1400, which was enhanced to 1540 and further to 1694 and thereafter to 1863.40 and lastly to rupees 2049.74, which was duly accepted by the party. After long delaying, in the month of August 2020, you made payment of the pending differential amount of lease rent from the month of November 2015 to November 2019. That's a receipt, my lord. The last check of rupees 11,180.40 paisa, which was given by you, was towards the rent for the month of July 2020 and for payment of the aforesaid pending differential amount of enhanced rent from the month of November 15 to November 2019, which was not paid by you in terms of the deed of lease dated 15 December 1995. Particulars whereof are provided herein below. The particulars which were mentioned in the counter receipt, again reproduced over here. Next paragraph. It is well within your knowledge that during the tenure of the aforesaid lease, certain amounts were not paid by you, details whereof is given below. Rent for the month of August and October 2020, 2 months, my lord. That rent was not paid by him. And differential amount of enhanced lease rent of rupees 1863.40 to rupees 2049.7 paisa at is equal to 186.34 paisa from the month of December 2019 to June 2019. Total amount due is 7,453 less security deposit of 1,400. It's 6,053.60 paisa was due and payable by him. I gave a clarification. Today, my lord, he says, I have given you a rent of 11,000 and odd sum, given you a check. That was for a future rent or for a period after. If he was a bona fide person, he could have produced that receipt. He has the receipt. For what purpose he has paid? I have produced the counter receipt. He could have produced before that receipt and shown.
What is the last date of the agreement?
30 October,
Tenancy period up till
30th October 2020. 31st October 2020. If he was a bona fide lessee, and if my intention was that, yes, he will stay, he must be having a receipt, rent receipt for the payment of this 11,000. In the receipt, it should be mentioned that for what purpose, for what period this amount is being paid. He did not produce. If he is able to produce that this money, which was 11,140, was paid for future month, my case ends. I have shown that counter receipt, that this is the amount which you have paid for this purpose, not for the future rent purpose.
So when you issued the notice?
I issued the notice after expiry of the, that's
3rd September.
3rd September.
And the date of expires on 31st of October.
31st of October.
A month before.
Two important things I should indicate. No reply to this notice dated 19th November 2020, page 63. He does not deny it. 19th November 2020, he does not deny the contentions, my contention, that the amount which he has paid was not for the rent for the month of July 2020 or for the differential amount. Yes. One more thing. I give him a notice to vacate my property. That's page 69. He does not say anything. He does not reply. He receives this notice. He does not deny and says, why will I vacate? How can you issue this notice? That's page 69.
Yes.
He receives this notice. He does not come up and say that, no, how can you issue me this notice to quit?
Yes.
Because I have given you a rent. You have accepted it for those rents. He does not say. Moreover, when I disclose this document, it also does not deny and dispute it, that he does not have a defense at all. He is merrily enjoying the property after the lease has expired in October 2020. For the last around 4 years, he is enjoying the property of Devoto property free of cost and not paying a single penny to the Devoto estate.
Actually, Devoto property should be free of cost.
For the deity, not for a party.
Partakers are not the deities, honestly. Irrespective of who we represent, partakers somebody else. Lord, I must tell you, Lordship, that's the first impression. Lord.
This does not lie in the mouth of a illegal occupier.
Lord, page 17 he has relied upon. So prima facie, Lordship has to see whether the document is genuine or not. He said, I did not produce any rent receipt. My simple reply to that, it was not my obligation to produce a rent receipt because my right to remain in possession, and whether I was in possession or not, that has not been disputed, never. Now, so far as this document is concerned, kindly have a look at the document itself. Is there any signature appearing that I have received it? No. My instruction I have taken from my advocate on record right now that no receipt is there because actually we have not received this document. Important is the date. Important is the date. Why say? And another thing, kindly see the check number, what has been mentioned in this document. Few things I must tell your Lordship. Lordship has seen the check number about the alleged adjustment.
Yes.
130990, 130990. Kindly see the check number mentioned at page 17, all prima facie, because you are not inviting the person to go to box. All at the prima facie stage. Page 17, on the basis of affidavit evidence. What about the other numbers, my lord? Kindly see. I am relying on his document. I am making submission on the basis of his document. Page 17, no receipt. Whether the document manufactured, afterthought, created or not, we are not sure. Prima facie, have a look at this document. Page 17.
Page 17 of?
Reply. Only this
19,
document.
19.
Page 17 of the reply, my lord. 19. Yes, I'm sorry.
19.
Page 19.
Yes.
See the check number, my lord, kindly.
Yes.
13990. And kindly compare with page 17 of the bank statement which I have produced.
Page
17 of my affidavit in opposition, bank statement. The check number has to tally at least. Even if we accept his argument is correct, though on the face of it appears to be erroneous because the lease clause I have shown you.
Page 17.
Page 17, my lord, the check number 13990 318. 318 numbers enter 20th date of transaction.
20 August.
20th is the date. 20th August 2020.
Correct.
Kindly see the check number. Detailed check number has been mentioned. Transaction. Inward clearance.
11,180.
Correct, my lord. 13990 318.
1309903.
318. Another number is there, my lord. 318. Somewhat not clear, my lord. But after 9, it's not clear, but what is clear is after 990 there are numbers.
Correct.
And now kindly see page 17. Whether do this number, my lord, tally on the face of it? No.
Yes,
990, but after 990 there are numbers. I have three things to submit. First, the document has to be absolutely clear when you say that. Read the lease clause and their right of adjusting from 2015. Now, my lord, whether 2015 ran, there's another point, my lord. Now I am taking it in law. I am entitled to 2015. You are saying about adjustment. What is the limitation period, my lord? 3 years. After that, can you do that? Then what is my status? I have not indicated in my notes. They have said this right now. I am taking this, my lord, from the bar. Maximum period 3 years. So according to you, you have shown your letter. You have relied on your letter 2015 onwards.
But they have taken the plea now. Why you have not given the reply?
My lord, I have not given any reply because I have made my stand. But in my opposition and in my written statement, I have made it clear. Kindly have a look at this, my lord. Affidavit in opposition and the written statement I have indicated in my note. I anticipated.
Because August payment was made.
August payment was made.
And October he has given the notice.
First notice September.
September notice.
First
given.
notice is of September.
Correct.
I replied, I have made my stand clear.
14th October.
14th October. Then they came up with the reply about this proposed alleged adjustment. They say I haven't given any reply. Dealing with this, I say I have made my stand clear.
Okay.
Not required to give another stand because I am taking the same stand. Now kindly see the pleading, written statement. I have indicated in my notes, my lord, whether I have dealt with this letter or not. Kindly, my lord, takes up my written notes. I have indicated the relevant paragraphs where I have dealt with this paragraphs where they have referred to this notice.
Yes.
Kindly, my lord, comes to my lord. Kindly, my lord. Sorry, my lord. Comes to my lord. I'm sorry, my lord. Yes. Page release agreement. Just give me a minute. Time. There was a vehicle that in the right dated page 16 and They made a, yes, my lord. Paragraph 11 of my written statement, which, my lord, lordship would find, my lord, a part of my affidavit in opposition. Paragraph 11.
Of the affidavit?
No, yes, absolutely.
Affidavit.
Opposition. All part of affidavit in opposition. I have annexed the written statement. Kindly see what I have taken, what stand I have taken. Paragraph 11. With reference to the paragraph 7 to 11 of the plaint, save what are matters of record and save what appears therefrom, each and every allegation
Paragraph 7.
content therein.
Affidavit in opposition.
Yes, my lord.
Page paragraph.
My lord, affidavit in opposition affirmed, and at the last page, reverse lordship would find my advocate on record's name, Mrs. Lakshmi Agarwal.
10th June.
Page 28, my lord.
Okay,
Running
written
page
statement.
Yes. Running page written statement. I'm sorry, paragraph 11 of the written statement.
Okay.
It starts, my lord, at page 27. I'm sorry, my lord. With reference to paragraph 7 to 11 of the plaint, save what are matters of record and save what appears therefrom, each and every allegation content therein is denied dispute. It denies and disputed that the lease rental was paid by the defendants July 2020 as alleged. The contention of the letter dated so-and-so are denied and disputed. As the same is it. The defendants have duly replied the letter of the plaintiff dated so-and-so by a letter dated. The contents of the letter dated 14th October 2002 are correct and defendant treats the same as well. By the said letter, the defendants have informed the plaintiff about paying rent till December 2020. A copy of this letter dated so-and-so. Then comes their letter, which they've said I have not dealt with. The contents of the plaintiff's letter dated 19 November 2020 were incorrect and the same are denied and disputed by the defendant. It is contended that after the expiry on 31st October 2020, even after the expiry of the lease period, the plaintiff has accepted the rent from the defendant and such fact should be evident. So I've categorically taken, I have repeated and reiterated the same stand and same facts lordship would find my affidavit in opposition.
Okay.
Where is the proof that I have received? I'm taking their best case. And, my lord, the 3 years period, 2015, permissible in law.
I will file the affidavit. Written note.
My written notes, my lord, they have paid and I have accepted the rent.
Then you are very well.
So-and-so offering for the plaintiff. So-and-so offering for the defendant. Yeah. So-and-so offering for the plaintiff. So-and-so offering for the defendant. Hearing in connection with GA5 of 2022 is concluded. Both the parties have filed their written notes of argument. Let the same be kept in the record. CAV.
But today we shouldn't have troubled you. It's a half-day court. If lordship sees the cars parked outside, so all courts, now
Unexpected, my lord. I thought we will certainly have a 3:30 today.
No, on the last day also I told your lordship that only one day, working day, 23rd we had holiday. So there is a probability. But today we have a full...
Anticipation went wrong.
I'm grateful, my lord, for trouble, and my lord, I have troubled you, my lord, kindly, my lord. Grateful, my lord.
The very next matter, my lord, item 30, it was called till 29. My lord, the defendant has not entered appearance. 120 days is over. Is a suit. My lord, I was just humbly praying, my lord, I've got the report.
31.
Item 30. Item 30, my lord. It was called till 29, so that I thought I could take my chance. This, my lord's last order records, my lord, summons being served on 19 September 2024.
Not over.
My lord, now it is over. It is 17 January. It is over, and we have got, my lord, a report from the deputy registrar, my lord, that nobody has entered appearance, my lord, till 18th of January. 120 days got over, my lord, as per from 19 September on 17th of January.
So-and-so offering for the plaintiff. None appears on behalf of the defendant. The plaintiff has handed over the service report, wherein it reveals that the writ of summons was served upon the defendant on 19th of September 2024. 2020. The plaintiff has also handed over this report issued by the deputy registrar within bracket legal, dated 18th January 2025, wherein it reveals that none appears. Defendant has not entered appearance either in person or through advocate. It is fine from the record The writ of summons was served upon the defendant on 19th of September 2024, but the defendant has neither entered appearance nor had filed the written statement. This is a commercial suit. 120 days is over. Thus, time to file the written statement is also closed. In view of the above, CS Com 759/2024 be placed in the list of undefended suit. Full stop. The plaintiff is directed to file the judge's brief of document within 3 weeks from date. Full stop. Affidavit of evidence be filed within 2 weeks thereafter. Full stop. List the matter on 21st of February, no, 28th of February 2024 for witness action. The reports we kept in the record.
Grateful, my lord. Deeply obliged.
Yes, call कर दो कोई है. Next.
My lord, I am appearing for the plaintiff in item number 31. My lord,
Yes.
is your lordship able to hear me?
Yes.
My lord, in these two matters, my lord wanted us to come back with my lord, an agreement for my lord arbitration. My lord, the plaintiff in item number 2 has prepared my lord that agreement. It only awaits the signature of my client. I was only beseeching my lord if a month's time could be given to me. My lord, my client is not well. My lord, there is some difficulty at my client's end.
So appearing for the plaintiff, so appearing for the defendant. In CS Com number 766 of 2024. So appearing for the plaintiff, so appearing for the defendant in CS Com number 423 of 2024. As per the prayer made by the counsel for the plaintiff in CS Com number 766.
My lord.
First matter.
First matter, my lord. My name is appearing, my lord.
John, let the matter appear on 25th of February 2025.
My lord, first week of March, if your lordship could post on.
Fix on 3rd March. 3rd March kar do.
My lord.
Yes. Next.
Item number 33.
My lord, this is the order, your lordship, in respect of direction to the bailiff for giving the report, your lordship.
Which one?
Your lordship, this is the same matter wherein your lordship is directed that the right to file the written statement of 120 days was passed and hence the right was closed. Your lordship, they went for the appeal. Kindly read it. They went for the appeal and the honorable division bench was pleased to direct that the stay should be given to that order till the report is filed by the bailiff and your lordship examination of the bailiff.
Your lordship, this honorable court is awaiting the report from the office of the sheriff.
ये रिपोर्ट आया नहीं? डिप्टी शरीफ साहब रिपोर्ट नहीं आया?
Yes, chair.
report.
ये भाई क्रॉस करता होगा ना टाइम नहीं करना
रिपोर्टটা তো দেখছি এই তো
রেঙ্গারি কাটনা রেঙ্গারি কাটনা
দেখছি তো
মোটা রিপোর্ট করতে আমাদের মোটা তো লিডার কেউ নেই আজকে অনলাইন কানেক্ট করতে পারো না
ওটা আটকে আছে তো কারণে আমরা যে নিজে করি জাস্ট ফিরেনটা যদি ফিরে আসতে পারে
ঠিক আছে তুই ভুলে যাস কেন না
কারণ করতেই যাচ্ছি
দেখেছি তুই বলে গেছি টিপ কর প্রসেস আমি
দেখি আগে কি রিপোর্ট
Yes.
Your lordship, the report, lordship, it was regarding that they are saying that it has been served on Gajmukh.
Your lordship.
The fact remains that the postal authority informed that the envelope duly served, duly received for and behalf of the Jute and Industries Limited. Formally, Nudia.
Nadde Jute Mill.
Nadde Jute Mills Company Limited. Kantal.
Service is complete, your lordship, in that.
Your lordship, your lordship kindly directs the this report so that we can obtain photocopy of this report once and come back on the next occasion. Kindly allows us to go through the report.
Lordship, we can also have a copy, Lordship.
So appearing for the plaintiff, so appearing for the defendant. In compliance of the order passed by the Honorable Appellate Court and the order passed by this court dated 13th January 2025, the Sheriff, Deputy Sheriff of Calcutta has forwarded the report, has submitted the report, full stop. Let the report be forwarded and be supplied to the learned advocate appearing for the parties. कल्याण ये जो है रिपोर्ट है ना इनका 1 2 3 4 कॉपी करके इनको दे देना
Oblige,
in course of the day.
Oblige,
In
Lordship.
course of the day. Let the matter appear on 11th of February
Your Lordship.
Deeply oblige, Your
I'm
Lordship.
only praying any date after 15th, Your Lordship, because my leader, Senior Mr. D.N. Sharma, is suffering from a ligament injury, so he cannot come to
On
court.
17th February.
Great.
Oblige, Your Lordship.